if I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I get started, for those who don't know me, I'm a Texas trial attorney. I'm going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. I was minding my business and I was drinking my water. And they said we got some action today. Good morning, all of y'all. Thank y'all for stopping by, for joining. I know it's a lot of other places y'all could be, but y'all decided to stop by here. So I thought we were starting at 7:30, but I guess it's 7:45 my time, 8:45 their time. So I'm gonna go ahead and see if I can link in the stream of the court, and we can be on our way. So I can hide this chat and see if I can get it all over.
All right, good morning, everybody. We are in session for this ongoing criminal trial. We're doing motions today and possibly for the next several days. For the defendants, I have not met y'all yet. You have not met me. I'm Judge Whitaker. I am the new judge who has been assigned to take over this case and preside in this case from here on out. As I said to the attorneys about 10 days ago when we had a scheduling meeting, I am going to encourage the parties to engage or re-engage in any kind of plea negotiations that might be fruitful. I suspect that for both sides of this case, there is a good bit of uncertainty and a good bit of risk with continuing with this trial, with potential appeals, you name it. So just bear that in mind, and we will go ahead and get started with the various motions. So the first motion that we have is, well, they're not in any particular order, but I've tried to put them in an order that I think makes sense. And the first motion that I am going to deal with is the motion filed by the state, essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions, I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrienne Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred, and we would just simply ask the court to afford the relief requested in the state's motion.
All right, thank you. And anybody from the defense who needs to add anything to what's been filed in writing?
Good morning, Your Honor. Doug Weinstein for Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV, the state 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. All right, with regard to this motion, you know, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of up to them. And if there is a complaint filed, then they will have to deal with it.
She not
But I
denying
think
it.
that in regard to the
That's-
propriety of doing that in this case at this time, I'm going to deny the state's motion. Obviously, if facts change and the state or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to move forward without instituting any kind of a restrictive order for speaking with the press in the case. With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s, they're in effect in Rule 22 period, only permits recording when the judge is on the bench, not during any recesses and not during any bench conferences. So let's make sure that we abide by that from here on out. I was having to reference some prior live stream that was in some of the motions that were filed and some of the responses, and notice that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right. So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order. Mr. Steele, is there anything you want to add to what's in the written filing?
Yes.
Go ahead.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, may I just step back 1 second?
Yeah, she ain't getting rid of this case.
Good morning, Madam Court Reporter. I am Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take offense to or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated July 8th, 2024. And what happened here is you have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable recused court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted. Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Miss Love, Miss Bumpkus, Bumpus.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in
All right.
that.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness to change his statement. He made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case,
Okay.
I'll be right back.
All right, Brian. The judge is like, I already read everything. She already ready to rule. And this is an issue that's not really that consequential right now. The appeals court or the Supreme Court can always go back and correct the words of Judge Cross when she kicked off Judge Glanville off the case. So he just wants the words corrected. Because Rachel Cross said Glanville did nothing wrong. He's like, hold on, Rachel. You lied early in the morning.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay?
She said she don't want to be waiting. He got all these papers. Let's go, Brian Steele. Straight to the point. Ain't no sense in sugarcoating it.
Is this a case that's not cited in your? Okay.
He giving it to the he just put it on her desk.
Thank you. Thanks.
Sometimes lawyers that do that, they leave it out the emotion on purpose, so the other side can't really get a chance to respond to it.
Your Honor, I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, ARCHER versus Maryland. It is 859A, as in at least a 2D 210 2004 case, and starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. It's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Previs, P-R-E-V-A-S, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process. And then skipping down to the next paragraph, similarly, it was.
Can I interrupt
Yeah,
you, and let's not skip down, because I think that part we're skipping is maybe important too, because it talks about the specifics of what that judge did in this case. So what is that?
Okay, well, he did a lot of things, but what the court is referring to, under the circumstances of this case, the phone call to another judge in the presence of the witness, the threat of life imprisonment as a sanction for contempt, and the suggestion that the other judge will give Bailey the longest possible penalty for contempt detracted from the dignity and integrity of the judicial process rather than uphold it. Similarly, it was unnecessary and excessive to instruct Bailey on how he could testify in the Archer case. Mr. Archer was one on trial. Bailey was represented by counsel who could have advised him concerning the various testimonial options if that was deemed necessary under the circumstances. Even if Bailey was unrepresented, it was not in the province of the court to suggest to the witness how he could testify to avoid a contempt sanction or how to allay his fears of testifying. In either case, it was not the function of the trial judge to suggest to the witness that he could testify favorably to the defendant, Archer. Specifically, Judge Purvis advised Bailey that he could testify favorably to the defendant, and there is nothing that anybody can do to punish him for that. That admonition was incorrect because Bailey could be prosecuted for perjury. So it goes on. I mean, there's great language. And the reason I use that, I understand it's not binding precedent, is it's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, just to highlight, because I heard what you said, the witness said, can I have 2 weeks to go home on house arrest instead of in a county jail? His child was having a birthday. That was a big deal to him. And then I'll make a decision whether to testify or not. I want to think about it. That answer should be from the court, because the court can do anything in contempt. It can give a fine. It can give weekends. It can give house arrest. It could do nothing. It could say you satisfy your contempt. That answer to that question was done by Ms. Hilton in front of the judge. Ms. Hilton said, no, you cannot. You have to go to jail. I find that offensive. This is my words. And that's why I'm disagreeing with Judge Krause. Number two, Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. Mm-hmm. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is nothing was done appropriate. I mean, and I don't want to get into, and the state actually filed a motion later saying the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said, I'm not accepting those factual findings, respectfully, because they're wrong, A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the questions, but Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Ms. Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changed the complexity of the case. Because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded, except for 2. So they track over 16 hours. The judge told him, and Ms. Hilton told him, and Mr. Copeland said, you previously told me, meaning Ms. Hilton, I could just say I don't remember. I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does as under Georgia law is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. So to me, as found by the Maryland court, this is intimidation. There was nothing appropriate. And the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree. And that's why I wrote that motion.
All right. Anybody else? And I know that there is another, or there are a couple more motions for mistrial based on the ex parte that talk about coercion and things like that. And I'd rather take those up in the context of those motions. So if that's what you want to argue, hold off. Otherwise, come on up.
Your Honor, good morning. Max Shard on behalf of Shannon Stillwell. Of course, under the Harvey rule, I have joined Mr. Steele in his motion. I would like to, I guess I disagree with Mr. Steele in one small aspect. He is seeking to challenge the findings of Judge Krause, the factual findings is the way he's articulated it. And I too have concerns about the order in the respect that it suggests that the ex parte meeting was or could potentially be appropriate. I don't believe it was appropriate at all, and I know that we're going to get further into that. But Your Honor, I would my disagreement in where I want to veer off from what Mr. Steele was saying is that I don't believe that they're factual findings. They're not necessary for her ruling. I believe that they're mere dicta. I don't believe that they're binding on you at all. What Judge Krause's order said, I believe that you independently can take a look at the transcript and make your own determination about whether the ex parte meeting had an appearance of impropriety or whether it was in fact improper, which it certainly was. So I just object to the characterization of these as factual findings because I don't believe that they are. I believe that they're merely dicta, and I believe that you're able to make that assessment on your own. Should you view them as factual findings, I, of course, join Mr. Steele in his objection to those quote unquote findings. That's it. Thank you.
All right. Anybody else from the defense? All right, I'll hear from the state. And I know you haven't had a chance to see and absorb the Arnold rule, I think Arnold, the case that Mr. Steele just, Archer, shared with us before now, but.
Your Honor, I will use it as he has presented and just point out the most obvious omissions and distinctions that I see present with the Archer case. Mr. Steele stated to the court that Mr. Copeland had no privilege to invoke. He spoke about what did or did not happen during the meeting, during the hearing in chambers. I would ask that the court, as the court has already read the transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court as it relates to intimidation. Mr. Steele asserts that a statement made by Ms. Hilton essentially is part of what makes the hearing improper. The state has cited in its motion or its response to the court cases that support the state's position that this hearing was not improper. Essentially, in order for, as this is a motion to challenge factual findings, I'll speak to the factual findings that have been challenged. Again, Mr. Steele cites that Judge Krause's finding, the way he said it, if it had been made in open court, it would have been proper. The
All
court,
right, why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. And I believe, and Mr. Steele, you can correct me if I'm wrong, but I think that the factual finding, that's the second one you're challenging, if it even is a factual finding, is Judge Krause's statement. It is worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about?
Yes.
All right. Okay, Ms. Love.
thank you. And so given the fact that the court has at its disposal the transcript of the hearing, Your Honor, and given the case law that the state has cited to the court, specifically, Your Honor, Allen v. State, 336 Georgia App 80 at 81, citing King versus the state, a Georgia Supreme Court case whose site is 273 Georgia 258 at 264 through 265 as authority for its ruling that appellant had no standing to contest the grant of use immunity to a witness. And King versus the state itself ruled after an appellate complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity that would apply to that compelled testimony, that the hearing in question was not a part of the proceedings against appellant, and that while appellant, quote, might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order, or that would suggest that appellant's rights were the subject matter under consideration, and that appellant had no standing to address the matter of the hearing outside his presence. I bring up those two cases, Your Honor, as well as Gilbert versus the state, and that site for Gilbert, Your Honor, is 306 Georgia App 776 at 777. Notwithstanding Gilbert's waiver, however, his argument is without merit because Gilbert has no standing to contest the grant of use immunity to Lang. The court again cited King and pointed out how the defendant there had argued that the trial court erred by conducting a hearing outside of his presence to determine whether a witness should be compelled to testify against him in exchange for use and derivative use immunity. This court goes on to cite the portion of King that I just read to the court, and goes on to say, on the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which the defendant had no standing to address. In this particular instance, of course, there is the distinction that Mr. Copeland had invoked his right to not testify at a point where there was no, I'll agree with Mr. Steele, there wasn't a privilege to invoke. The point at which he said, I plead the fifth, is when he was asked, I believe, his age in years. The concern that we had, the concerns that we had, we presented to the court, and mainly it was that Mr. Copeland, as is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hilton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered. The hearing in chambers, as is reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were. The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury. So
Yes.
I don't have any problem with this love. I refer to the transcript, but if she's going to testify, I would ask that she testify as a witness. I don't believe it's proper that she proffers information. I believe that she wants to be a witness, which I do believe she is. She would have to sworn to testify.
All right, thank you. So I have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is whether I can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the authority, the court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's. Just as each court that at each step in this process has its own set of duties, that one belonged to Judge Krause.
Okay.
So we would ask that the court deny the motion to challenge the factual findings of Judge Krause.
Anything else from the defense on this particular motion? Has there ever been an attorney invited to talk who didn't take the opportunity?
I took a pass a couple of times, Your Honor. Doug Weinstein for Mr. Kendrick. The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to and complaining about here. That is a hearing about the issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in chambers on the 10th, far after that immunity decision was made, at least just speaking with respect to my client, Mr. Kendrick.
Okay, thank you. Anybody else? All right, with regard to just this particular motion, which is styled a motion to challenge essentially Judge Krause's factual findings in her recusal order. It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. To the extent that it is a motion to reconsider that court's order, that's a little bit closer to something that I might be able to do, but I can't really do that either. That, as Ms. Love correctly pointed out, was a motion to recuse Judge Glanville. It was before Judge Krause, not this judge, and she granted the relief that the defense sought. I understand that the defense does not like some of what might be factual findings in there. There are other motions before this court right now for mistrial based on that, and I think it is more appropriate that I consider them in the context of that than going back and essentially undoing potential factual findings made by Judge Krause. I think I agree with Mr. Sharp that this is probably dicta anyway, in that the essential holding that the court made was that the recusal was based on Judge Glanville's engaging essentially while making a ruling on the motion to recuse and making kind of more than just the minimal necessary findings in his ruling. But I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular motion, understanding that we still have other motions for mistrial to take up where some of the arguments y'all made just now might be more appropriately considered. All right. So I think that actually the next motion I'm going to take up is the motion filed by Mr. Williams that has a very long style, but that essentially asks that any other ex partes be revealed, that a neutral judicial officer take a look at everything in the case that has been sealed and make sure that it is above board. And then for a mistrial based on the alleged judicial misconduct that occurred during the particular ex parte that was the, 10th of June? And prosecutorial misconduct there and prior to that. So I got from the clerk's office every sealed filing from the state or any of the defendants in any of these 6 defendants' cases. I've looked at all of them. There's nothing improper about any of them. I refiled them. The order that it accompanies the resealing, I'm sorry, not refiled them, resealed them, actually delineates each of the things that I looked at or the dates of each of those sealed filings. I'll note that a lot of those ex partes were defense ex partes. There's nothing wrong necessarily with something being done ex parte. We're kind of talking about this June 10th ex parte as though, ooh, that is such a horrible thing. And it may be, but an ex parte in and of itself is not necessarily a bad thing, and both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper in my determination. All right. The next thing is the defense asking whether there have been any other ex partes that we don't know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
Uh-oh, here we go.
Your Honor, not being certain whether the seal filings include the transcript of the request from the state to have the hearing
She lying.
with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay,
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
all right. And was that done in writing or was that oral?
The request was done orally with the court reporter there.
Okay,
We requested that the court allow us to address the matter and that it be taken down for the
okay.
record.
You know what?
Anything beyond that?
Yes, there was also the state's request for a material witness warrant for one of the,
I think those are all reflected, and you may want to go back and look, but
Let her
I know
finish.
that there were material witness warrant requests from several different parties in the case.
okay.
Mm-mm. Mm-mm.
So those are the ex parte matters that we addressed with the court.
Okay, thank you. Mr. Weinstein,
No.
anything? Okay. Mr. Carlton? Mr. Matthews. Okay, Mr. Steele.
She could have been talking about something else, Judge. You cut her off. It might be another material witness warrant. Not
In
the
my best memory, which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement executed a search warrant for the computer of the Honorable Eric Johnson. He's a lawyer in the case who's severed out now.
Okay. All right.
And that was announced in open court. I asked recused Judge Glanville whether we can have an ex parte. All the parties were here, and then everyone went. So when I say everyone, all the people here went into chambers behind, and there was conversation in front of a court reporter.
All right. And when you say all the people here, does that include the state?
No,
Okay.
the
So you
state
mean
was
all
here.
of the defense attorneys?
And the
Okay.
state was here when I announced that we'd
Okay.
like to meet ex parte. The judge, former judge reconvened, our former judge reconvened.
Okay.
We went into the chambers here. So I have no idea if that's something you looked at or not.
And I don't know whether that's anything I looked at because that would have concerned a severed defendant. I would imagine it's in that case and not any of these 6 defendants. And I only looked at what was in these 6 defendants' cases.
I can't
But-
answer.
Okay.
And then, and when I say who was here, yes, Honorable Mr.
Okay.
Matthews, Mr. Weinstein, Mr. Harvey, I assume Ms. Westmoreland, she's shaking her head. Misty Williams, I know Mr. Adams was next to me, Mr. Sharp, and I presume Mr. Bucks. He's
Okay.
saying his head, yes. And the second one was also asked in open court for a meeting with the recused judge ex parte. And that was on the day before we're coming up to a man named Mr. White, like the color, was going to testify. And we had it at the bench where the court is. And that was Mr. Sharp, Mr. Matthews, Misty Williams, myself, and Mr. Adams. And if I miss, my memory's wrong, I'd like them to correct me. That's who I remember being there. And it was on the record.
Okay.
So I don't know if you saw anything about that.
All right.
And that was the total that I've had with.
All right. Thank you.
Thank you.
Mr. Harvey.
Just to be on the safe side, there wasn't, we had a in-camera meeting with Judge Glanville. When I say meeting, it's not ex parte.
I can't hear you.
And I believe that he helped. But the concern is scheduling conflict in federal court.
Okay.
That I had, and we resolved that. I just want to make sure. That
All right. I appreciate it. Thank you. Mr. Sharp.
Your Honor, to the best of my recollection, I recall being with Mr. Steele in the announced ex parte regarding that gentleman, Mr. White. I also believe there was an ex parte regarding another permission to interview a separate witness who was unrepresented at the time. I believe that probably is reflected in the sealed records. I can't recall if Mr. Steele was with me or not, but that also occurred, and that would have been before the jury was sworn. That was late 2022.
Okay, thank you.
Mr. Steele is indicating that he was present.
All right. Okay, so that takes care of that part of that motion, unless anybody wants to inquire further as to any of those.
Y'all better. The state hiding something.
Okay.
What's confusing to me, Your Honor, is in the transcript of the June 10th ex parte meeting that we've focused on, there is, within the transcript, there's a clear indication that Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of, that they seek answers from Mr. Copeland about and wish to pass these questions on to him. There is nothing in the transcript that indicates discussion between, I believe it was Ms. Hilton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically. So that's my concern.
All right, so I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumed surely you must have given them a list of questions. Now, I have no idea whether that's what, if it was just like, surely you have a list of questions, or if there had been a prior conversation, and I will ask Ms. Love that.
I believe that since Ms. Hilton was the one present.
Or Ms. Hilton.
But I can say that I did hear Judge Glanville, I believe, in open court say something similar to that, but I will allow Ms. Hilton to.
Okay. All right. Ms. Hilton, was there some basis from something that had already occurred for Judge Glanville to have asked that?
No, Your Honor. We were very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting.
All right, and was everything that occurred in that meeting, other than the times when Judge Glanville stepped out so that Mr. Copeland could talk to his own attorney and I believe talk to y'all, was everything else recorded?
Yes, Your Honor.
Okay, from the outset of that meeting?
From the outset of the time that I entered the room, everything is recorded.
Right, because you weren't there at the beginning of it.
Correct.
But you did not have a conversation with Judge Glanville prior to when you came into chambers and it was being taken down?
Outside of
About-
the normal,
How are you doing?
pleasantries
How
and
was
how-
lunch? Yes.
Correct.
Okay.
Nah.
And Ms. Love, you were in there at the outset. Was it recorded, taken down from the outset?
Yes.
Okay.
I stated at the beginning, it was, she was there from the beginning. And as I stated earlier, the only other instance that we spoke on that was also taken down.
Okay. All right. And that was earlier that same morning?
I think it was the Friday.
The Friday before? Okay. All right.
You
All
gotta
right.
watch.
So based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville regarding Mr. Copeland and what they discussed in that June 10th ex parte. All right, another part of this motion is a list of purported slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional. All right?
She mad now.
Continue to do that as I have.
All right.
The court require all parties to make certain that.
Okay.
Ooh.
With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, you know, I'll consider something that y'all want to present to me. But I know in particular, Mr. Steele, you took issue with apparently at some point Judge Glanville used some adjectives about you, specifically unprofessional and unprepared, that are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared, and so that ought to take care of that. And this court is going to instruct the jury, just like is done in every case, that nothing that the judge says, no matter whether it's this judge or the prior judge, is evidence. It's not supposed to indicate any kind of a bias one way or another. And so I'll give those curative or those instructions anyway. And if you want something additionally curative wise, I'm willing to entertain that as well. Okay. All right. So given that Judge Glanville is now recused from this case anyway, and I have instructed Ms. Love to conduct herself with professionalism, I am going to deny the motion for mistrial as it is sought and on the bases on which it is sought in this motion.
Your Honor,
Yes.
You don't like that.
I just asked for clarification, whether the court is finding that there were any unprofessional or.
I am not making any such finding.
Love didn't like
Yes.
that.
I think we just, maybe I was lost for a second. I think we switched to a place where I didn't believe we were at, or I didn't understand discussing regarding a mistrial. I didn't really understand us to be at that point in the motions yet. And I just wanted to be clear for the record, to the extent that a mistrial was denied. Mr. Stillwell, it has been we never requested a mistrial.
Okay.
And to the extent that a mistrial's been denied, I just want to be clear that Mr. Stillwell has not requested a mistrial. And when we were going to move on to Mr. Harvey's specific request for a mistrial,
Yeah, I hadn't gotten to that one yet. Okay. All right. I appreciate
I just want
that.
to make that clear for the record.
Okay. Thank you.
Love did not like that. Oh, she mad. She hot, y'all. Don't think for a second Love ain't mad.
All right. So now we get to the motion to disqualify attorneys Love and Hilton, the two of the main ADA prosecutors in this case. And the basis for that, this is also filed by Mr. Williams, is that they assert a need to cross-examine Mr. Copeland, attorneys Love and Hilton, and Judge Glanville with regard to the ex parte. Anything that Mr. Steele, you want to argue that's not in your motion with regard to this? And I do have a question for you about one thing that you said.
All right. So she denying this one, y'all. She's not kicking them off. That's a good thing, though. They need to live with their loss. Don't try to pass it to nobody else. I mean, you can tell the way she started off. She already denied this one in her head. In her mind, it's denied.
Yes, Your Honor.
You want me to ask my question first?
Whatever you tell me.
So in your paragraph 3, you assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
Okay. So going back to what you've read and digested June 10th, 2024 ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. What Prosecutor Hilton and what Judge Glanville were telling Mr. Copeland was, you can say lies, as long as they're not big lies, and you will not be prosecuted. He could be prosecuted for perjury and false statements.
Okay, and when you say that, do you mean when it was mentioned that if you say, I don't remember,
No.
you
it
can't
said
be
it.
prosecuted?
No, I have to get the transcript in front of me, but it was as long as Miss Love told you, which is not in the transcript, but the Judge Glanville said, as Miss Love previously told you, remember is the word used, unless it's a big whopper of a lie, you will not be prosecuted.
Do you have access to the transcript right
Yes.
now?
May I step back?
Yes, and of course, I thought I brought it up here with me too, but I don't seem to have it in front of me either.
Well, pull it up on the computer. It'll be easier to search for keywords. Y'all remember that?
If it's on my desk somewhere. I don't know how it couldn't be here, but.
Let me see if I can pull that up. To my email.
You may. And I'll give that back to you. I've got a copy somewhere. Just given that we're using a borrowed bench and courtroom, I don't have everything at my fingertips. All right.
But he
Okay.
handed me from the transcript of the ex parte hearing, June 10th, 2024. He directed me to page 40. It's Judge Glanville speaking, line 20. What will get you in trouble is you not, hyphen, hyphen, is you just invoking your Fifth Amendment. If you overtly lie about something, like if you tell a bold-faced, not big whopper, a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement. And then Mr. Copeland said that's what they're going to do. Then there's conversation by Ms. Bumpkus. That is what I was saying. You will be right back here. Then Ms. Hilton said on page 41, line 5, But if you say something that you know that you did not do, like you admit to something, you know you did not do, whether you, and then Mr. Copeland said, like murder, don't have like no statute of limitations, right? Ms. Hilton said on line 10, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland saying, but y'all don't like ... His lawyer said, you could charge him with false statements and he will be back in jail. That's what I'm trying to say. And then Ms. Hilton on line 17 said, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it. And the judge is there. So I hope that's answered your question. There's another space that I can find. I just need a second. But it's the judge saying you won't get in trouble. He says that throughout. You can say you don't recall, you won't get in trouble. There's also a place in here where the judge tells Mr. Copeland and Ms. Hilton that the statute of limitations, this is Ms. Hilton, the statute of limitations has run. In federal court, she says, I looked it up. In federal court, it's a 5-year statute of limitations. In Georgia, it's a 4-year statute of limitations. If I could get that site for you, I'll tell you exactly where it is. What page? I'm being told 24, Your Honor, but let me check. Mr. Adams said 24 going into 25. Your Honor.
I don't see it on 24.
On page 24, line 12 is what I see. Ms. Hilton says, and what we'll say, and Mr. Copeland and I, we've talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if you are, if any of your concerns deal with being locked up for anything, you can't. Like there's nothing that can happen. The feds, Ms. Bumpkus interrupts. Well, that's not, Ms. Hilton interrupts. It is true. Ms. Bumpkus, said, no, I said, that's not his concern. Ms. Hilton said, if it is if it's his concern for his safety, we need to know that. Like that's not expressed. So we don't know what the concern is that we can try to resolve the concern. This is what I'm saying, Mr. Copeland and I have had conversations before going to page 25, Your Honor, and here it is. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So there is nothing, like I researched it this weekend again, both those statute of limitations for what you and I talked about, which is a 2015 or before done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that's a concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything 2015, 5 years would have been 2020. Anything statewide is 4 years, it would have been 2019, finished. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
The
It
judge,
sounds
though.
to me like they're talking about some kind of particular crime he might or might not have committed that he might be testifying about, and whether it obviously wouldn't be murder because as he recognized, murder has no statute of limitations. But that sounded like it was a really particular crime.
You can't tell a person, I wouldn't tell a person, how about that? You can't be prosecuted because statute of limitations ran when you know he could be prosecuted in our indictment. The state is saying,
Agreed.
yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly, you can't be prosecuted for anything.
I don't know.
Okay.
I don't read it like that.
All right.
So on the next page, page 26, it's again, Ms. Hilton, line 2, you will not. This order, I
Can
don't
I
know
interrupt
if
you
you,
for just a second
Sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Right.
yes.
Okay, because I want you
We
to
need-
address that.
We
as
need you
well.
to testify. Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of? That's not
That,
true.
okay, that,
That's wrong.
Yeah.
A-
that is on, that's on page 36 of the transcript, lines 3 through, I mean, the discussion's kind of lines 3 through 9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act, at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers, forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015 that you found yourself in an office with a judge? Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly, you spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, I mean, you have the transcript and I know everybody has said, oh, there was Brady in there. Y'all got it all now. So it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify on some, maybe all of the things that happen in there. That may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about all of, you may have to stay in jail till all of the co-defendants trials on page 36. Anything else?
We need you to testify. Nobody needs him to testify. I mean, he could do whatever, it's America. He could do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty of perjury, but that's what judge. And,
All
and they also tell him how to testify. Judge Glanville tells the lawyer first. If you remember, I could get you the transcript. You remember you shaking your head. Judge Glanville tells the lawyer.
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
Okay. It's at the beginning when Ms. Love was there. Hold on one second. I'm being told page 30, line 5.
Okay, page 30, line 5 is Mr. Copeland talking.
Yeah, that's not.
Give me a second. Okay, so I start with page 8. Mr.
Page
Copeland.
8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions that I'd like to
No,
know.
where he gave legally incorrect information to Mr. Copeland,
Okay,
which is what you put in your motion.
well, okay, and page 8, though, if you take in consideration, sorry, on line
Okay.
9, the former recused Judge Glanville is telling the lawyer for Mr. Copeland, now, to be fair, I think Ms. Bumpkus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bumpkus says yes, or excuse
Was
me.
that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors. The judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge starts telling him that the client, he's telling Mr. Copeland that the clients are guilty.
Mr. Copeland's not here at this point in
get you.
time. This
I'll
is
get you.
his attorney, Ms. Bumpus.
All right, let me get that for you.
Judge on it.
It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find it. Okay, on page 26, Your Honor. Line 16,
Uh-huh.
Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe Mr. Copeland, are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted,
But he can be prosecuted for this case.
which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page,
Well, if you are, I mean, if the topic of the meeting is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting, and the nuances of that. I mean, that's a nuanced issue even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
okay. On page 30, it's not the judge now, it's Mr. Copeland speaking. Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you called, went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember, excuse me, I don't know. You told me that if I plead the 5th, I mean something. Why would I plead the 5th to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talking about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms.
Okay.
Love, that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And I
So-
want to ask questions.
Okay, so Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been taken care of.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. Ms. Hilton said, no, there's another 12. The court said there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't
Okay.
just hold a human being.
All right, so
That's not really
you
relevant, though.
can certainly ask Mr. Copeland about that.
Right.
I don't know
The
that
judge.
the prosecution's motivations are relevant to the issues that the jury is supposed to decide.
Right.
And with regard to Judge Glanville, again, he is not involved in this case anymore. So I'm definitely not going to permit you to cross-examine Judge Glanville in front of the jury because frankly,
Unnecessary.
it's irrelevant. And he's been recused. So to the extent that, do you have anything else with regard to why it is you ought to be able to have Ms. Love and Ms. Hilton removed from the case?
Yes.
Okay.
So, and just go back to your answer, last question, page 44, line 22, it's Judge Glanville
Okay, so you testify some aggravated
speaking.
assault.
Mm-hmm.
And he said, okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that's what the order said. That's just not true.
I'm sorry, where are you?
Page
I may be on
44.
44.
Line 22, Judge Glanville
Oh, okay. I'm with you.
speaking.
Yeah.
He said, okay, this is Judge Glanville. So you testify about some aggravated assault or murder.
Okay, so I'm
They can't
actually not
prosecute
with you.
you.
Page 44, line 2?
22.
20.
22, okay. All right. Gotcha.
Judge Glanville speaking. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute and they can't use his word.
Okay, all right, I will take all of that into consideration. I don't think that I'm going to make a ruling on this particular motion today. I want to take a full look at all of it in context, because I do think we have to consider it in context. I will note that one down as well.
So let me then answer your question directly. So what's going to happen in my mind's eye is I'm asking all these questions to Mr. Copeland. He's answering however he answers. I am pointing fingers at the two prosecutors. That mandates that the jurors have to rate their conduct that happened outside the jurors' purview. I am saying that he was given, he being Mr. Copeland, was given erroneous legal information. He was encouraged by the holding of hands of Judge Glanville, Ms. Love, and Ms. Hilton.
Holding
They
hands.
all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify, Judge Glanville said. Mr. Copeland will say, I don't know what he was going to say. But yes, I felt that. I felt that they were not going to let me out of jail. I can't then have, nobody should have, then lawyers stand up when the jurors now need to rank what they are doing in the case. Their conduct is at issue. I'm not making them witnesses. I'd rather they stay on, to be quite frank with you. They made themselves witnesses. And the reason is because they injected themselves in such a, my opinion, inappropriate communication with a court and a sworn witness who did not ask any questions. The gentleman was represented by known counsel. He says, and it's in here, I could give you the page, but there's no reason. Take me back to the jail. Judge Glanville said, do you want to talk with your lawyer, me, or the state? Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this to me is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Ms. Love. Ms. Hilton, I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Ms. Love tell you?
How would he know that?
Or tell your lawyer if your lawyer told you. And I'm not gonna, I understand I have to stay away from attorney-client privilege, but did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember, Ms. Love told you. We just read that. I want to talk about that.
All right.
And then at some point, I want to ask Ms. Love, why would you tell a human being
All right,
that he's going to
Steve.
just rot, in my words, rot in jail until 26 people are gone, which is not the law? And Ms. Hilton, why would you tell him that if he lies and you know he lies, you're not going to charge him? Why?
Okay,
And
so
those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that. But if you look back at June 10th, 2024, about 11 o'clock in the morning, not the ex parte hearing, recused Judge Glanville comes on the bench. Please look at the transcript because I'm not verbatim. I understand that Mr. Copeland's going to testify. Mr. Copeland's put on saying, are you going to testify? He said yes, and we rolled into questioning. I don't know how it got away from the prosecution, Ms. Love, Ms. Hilton, Judge Glanville. By the way, he told us things that are specific on the case. He said in here, I can give you the number, I committed all these crimes. All these crimes include murder. He's asked about statute of limitations for murder. We don't get any of that. So for all those reasons, I'm going to cross-examine Mr. Copeland. I'm going to bring all that out. And the people who are at the heart of that conversation are witnesses as well. They should not have done it. Then they tried to hide it, which I'm bringing out as well. And then just, I don't know how, but by circumstance, fortunately, whatever the right word is, we did get the transcript. If you read the transcript, I asked Judge Glanville for the transcript. He told me it was privileged.
all right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury, though.
Well,
Cross that
we'll
bridge when
get
we
there
to
when we get there.
Right.
But this is not, I cannot call anyone else. You can only go in the mind of Miss Love. Why did she call the meeting?
That's
I don't think anyone
irrelevant.
else could answer. No one asked for that meeting. This is my understanding. And Ms. Love stands up here and said, we needed to answer questions because Mr. Copeland asked questions. I don't see that. He's represented by a lawyer.
I see the relevance, though.
I mean, I don't see that.
Okay, well, thank you. I appreciate it.
Anyway, that's the basis of calling. I heard what you said about Judge Glanville. That's the basis why I want to call Judge Glanville and ask why did he join the prosecution team? And I believe that then dovetails into Judge Glanville saying wrongly that I was not prepared, wrongly that I was unprofessional. And then he later acknowledges that, but he says, I'm not going to instruct the jury. So the jury's never heard that. And I heard what you said, that you'll instruct the jury, but I'm going to argue that that instruction, that the judge has no role in the case except, it's not verbatim, but except to make sure that the parties, every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is permitted argument or not if we get to that.
Okay, but that's my strong belief
All right.
that the jurors get to know that who the judge was for
All right,
18 months.
Mr. Sharp, you look like you want to say something.
Brian
Thank you.
Steele. Whew.
And I'm trying not to focus on things that we're likely to
Okay,
discuss.
and yeah, remember that this is the motion to disqualify Ms. Love and Ms. Hilton.
Right. I would just like to stress one point that, Your Honor, I know that you have joined us and weren't there on June 10th. I think it's important to remember when we're talking about the potential to call the prosecutors as witnesses. My understanding, I know I didn't call an ex parte motion meeting. My understanding is that Kenneth Copeland did not request an ex parte meeting. My understanding is Caleb Bumpus nor John Melnick, who served as counsel for Kenneth Copeland, did not call for an ex parte meeting. They did not express any concerns. The state called for an ex parte meeting. And in the beginning of that ex parte meeting, with Judge Glanville explaining the need for the ex parte meeting, the state made statements to Judge Glanville that accused Attorney Melnick of violating his oath and of not fulfilling his professional responsibilities and representing Mr. Copeland. They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge, and mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love stated to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Shard an email, and he may have inadvertently included us, possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them, and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient. There's absolutely the reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties in dealing with an attorney and not with a represented individual. And somehow the state in this ex parte meeting where we were not allowed to respond or even to hear the accusations, they suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive. And again, we weren't there. That's the problem with these ex parte
All right,
meetings.
well, I'm going to get a transcript. I have just typed a note to Judge Glanville's court reporter requesting the transcript of the request for the ex parte itself. So I'll find out what it said and I'll share it with everybody.
Okay, well, that's in the beginning of the transcript that you have. It's in the first 6 pages, I believe. In fact, page 3 to 4.
Okay.
Page 3 to 4, they talk about this email, and we have the email.
Oh, no. I know the email.
Okay.
I'm talking about, I'll get the transcript of the Friday request as well. But yeah, I've seen the email. It's made an exhibit, I think, to the ex parte transcript.
And just so we're clear, and the reason I say that's important, because again, why are they doing this? What was the purpose of the meeting? Because that couldn't have been the purpose, because their stated purpose was completely inaccurate. And I would invite the court, I believe it's in the record, but we can certainly provide a copy of said emails.
It's an exhibit.
Okay, because that's not an accurate rendition. And you know, I'd be happy to answer questions about what happened, but that was not accurate. And these are issues that now the state has injected themselves. As Mr. Steele said, we didn't do this. We didn't do any of this. In fact, we were excluded. We knew nothing about it. And it's improper, and the state initiated all of this. And it's not just what happened in the ex parte meeting, but why did it happen? And ultimately, there's only 2 people, I suspect 1, but we'll say 2, that really know why this meeting was called. Because it wasn't called by, my understanding, Judge Glanville either. It wasn't called by his staff. It was either called by Ms. Love or Ms. Hilton. And we have the right to cross-examine them or examine them about that.
All right, thank you. Response from the state.
Yes, Your Honor. Again, Adrian Love responding for the state.
And I want to hear what you have to say. I've got your response. That's your written response. It's pretty thorough. So let's highlight what needs to get highlighted without rehashing everything.
That was my intent. Thank
Not
you,
to
Judge.
suggest that you would, but
Your Honor, I'd like to point to the court, McGlynn, MCGLYNN versus the state, 342 Georgia App, 170 at 173 through 174. In McGlynn, the court notes while Webb dealt specifically with statements made by a trial judge, this court has previously noted that either judicial or prosecutorial intimidation that dissuades a potential defense witness from testifying, or the defense can, under certain circumstances, violate the defendant's right to present a defense. However, such analysis must be undertaken on a case-by-case basis. Here, we note, as did the trial court, that nothing in the record suggests that the statements made by the ADA to the witness were legally inaccurate or misleading. In fact, the ADA's comments seem to have been confirmed by the witness's own attorney, who, unlike the ADA, is charged with acting on the witness's behalf and protecting his rights and interests. As we observed in Terry, the potential for unconstitutional coercion by a government actor diminishes when a defendant's witness has consulted with an independent attorney. That these statements by the ADA were later perceived by the witness as threatening is wholly irrelevant to our consideration of this matter. The court has held that the state is duty bound to inform the witness of the possible consequences of admitting under oath facts that could place the witness in legal jeopardy, including notifying the witness that the criminal law would be enforced to the full extent against those who violate it. And that's the court citing Murray versus the state, 157 Georgia App, 596 at 598. As of course the court has noted, we have included in our response the applicable case law that we believe is most relevant to the court's consideration of the motion to disqualify. In this particular instance, Your Honor, I would assert that the why of any particular proceeding is not a material issue, is not something that is relevant to the juror's determination of the guilt or innocence of either defendant in this case. It's not in any way. It's, if anything, it would be the effect of anything said on the witness themselves, and the witness himself could testify about that. In addition to the fact, as we stated in our brief, there were multiple people there as reflected in the transcript, and there's no reason to, there's no need to resort to an extreme remedy as disqualifying the prosecutors in this case, any more than we would have the right to cross-examine Mr. Steele and Mr. Sharp based on what they may have said to Adrian Bean or anyone else in this case. So we would ask that the court simply deny the motion for such an extreme step as disqualifying Ms. Hilton and me, and we would base our argument on what we presented in our brief.
all right, thank you. You know, something that's tied up with this issue is the fact that, I mean, there's been a motion filed with regard to it, and we haven't gotten to it yet, but I mean, I think the defense is correct, and I don't think the state opposed the fact that everything after at least the 14th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, or virtually all of it. And am I correct that the state pretty much concedes, agrees that that's true?
After the point where the motion to recuse was filed by defendant Kendrick.
Okay.
We don't disagree.
All right, so, and that was the 12th?
I believe.
Yeah. So, you know, we may be having really kind of an academic discussion about all of this anyway, because if what the court is going to have to do, and I invite y'all's input on exactly how to instruct the jury about this, if we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly can, we're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but we have to sort of think about that as well. All right. So I am going to take this particular motion under advisement, and I'll get you a ruling quickly, but probably tomorrow. Sure.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify the 10th, 11th,
Right.
and then the 12th is what you
Right.
referred to. And I understand we'll take up that motion tomorrow, but there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
Okay,
just
well,
want you to be
what
aware.
I mean that we'll get to tomorrow is how to, and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before, the testimony that occurred before can stay.
Okay. I misunderstood what
The
you said.
testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then that will be great, because it'll save us time and we'll have better contours about what we're dealing with. So I want y'all to get together about that, and we'll think about that probably tomorrow, maybe the next day, I don't know, but not today. But y'all after court today can think about that together with each other, okay?
The
all right.
reason I stood up, though,
Yes.
I just want to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Honorable Court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick et al.,
Right.
and you're intimidated, and that's why you're not testifying.
Mm-hmm.
I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state of Georgia be witnesses? I need that in the case. Because
Okay, let me ask you this though. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation is in black and white in the transcript.
I'm intending to cross-examine or examine Lawyer Hilton and Lawyer Love.
I know you're
On how
intending
they-
to, but what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how do you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state. My point is, I can't ask Mr. Copeland what
But the
happened to these other
issue,
witnesses.
as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland
Right.
into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and Mr. Copeland can't answer those questions.
Okay, but
And
that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need to be kicked out of this case. I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
Thank you.
Okay.
Excuse me, Your Honor.
Yes, sir.
May I just briefly address something you said earlier?
Sure.
Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out.
Right.
I do not, just for purposes of the record, I do not concede that this trial can continue.
I
that we can.
understand.
Okay, I just want to make sure.
A couple of motions from
Just
here
want to make sure
still.
that's there because you're asking us to meet tonight to go over what could possibly remain.
Well,
And I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No. Absolutely. I understand that. We'll follow whatever order
right.
that you give, Your Honor.
All right, thank you. Okay, so the next motion is Mr. Nichols' motion for mistrial and objection to mid-trial substitution of trial judge.
Here we go.
And it is quite lengthy and detailed with many subparts.
Well,
Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to
Well, there
talk
is.
about?
There
Do
is.
you want to come up here, or I mean, it's fine if you stay there and hold the mic. That's fine.
Well, what I want to say is, I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks.
Yes, so
Okay.
I think that needs to be addressed first. And then our motion was in the alternative, if you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
Okay,
So I think that would be the
Okay.
appropriate.
fine
Very
with
good.
me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, one, I joined theirs, they didn't join
Okay.
mine. So it's a
All
it's a
right,
second step.
that's fine. All right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first. And his motion asserts his motion joined by everybody else except for Mr. Stillwell. Is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kennedy's motion.
for mistrial filed July 23rd.
So I am, may I make my stance clear?
Yes.
Our stance, Mr. Stillwell's stance, is that this trial is completely broken. It's broken. There's error in this trial that would never survive appellate review. Illegal ex parte hearings have occurred. Our clients' rights have been repeatedly violated. The defense has been mistreated in front of the jury by a partial judge. It's broken. We are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Thank you. Okay. And, you know, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so Mr. Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that the state wanted this mistrial, goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that any mistrial would be with prejudice without the ability to try the case over again. But the determination has to be made whether the state had the ex parte on purpose with the purpose of goading, to use Mr. Kendrick's attorney's word, the defense into making a motion for mistrial because the state thinks they're losing the case and wants to be able to do whatever with. I got the concept right?
Yes, Your Honor.
Okay. All right. So this is also a lengthy and well-briefed, well-written motion. I will hear what you want to add that's not already in your written motion, if anything.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
As a lawyer, I feel compelled to speak to it, but I will sit down,
Okay.
given that I have no additional information. I would like to respond if the state does have something to add.
Okay.
I did not see a filed response from the state to our motion. I was served a response, so I'm not quite sure. I'm not quite sure what that's about, Your Honor.
Now, you know, sometimes they get filed, but they don't show up in Odyssey for a couple of days.
Don't make
Because
it.
y'all have been good about emailing the court when you file. I haven't actually checked Odyssey to see whether it's in there or not, but I would imagine that if the
Here she
state
go.
served everybody with a response, they also filed it. If not, they need to. Okay, so that is a part of this motion. And another part of the motion is, well, I think you say as well that we'll need to redo the from 612 on. That's a part of this motion.
That is a part of this motion, Your Honor, yes, that there is a requirement that everything after 612 is void.
Okay.
And in that motion, we argue what I stated earlier, that I don't believe it's possible
That it's
to
not
erase
possible.
that information from the jury.
Okay.
Also, I'm happy to take any questions you may have.
Okay, I appreciate it. All right, so, yeah, so there are a lot of different grounds in here. There's the state sought it because they wanted the defense to ask for a mistrial so they could get a mistrial and try the case over again. That substantively speaking, the ex parte was a critical stage at which the defendants were excluded. And then the concept of, which we've kind of brushed over somewhat, that Judge Glanville's comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues, three main arguments that I put forward in that motion. The only thing that I can think of that maybe I did not sufficiently highlight is just the tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As Mr. Shart has said, we are winning this case. The state's witnesses have not testified the way that I imagine they expected them to testify. And I do not believe that they should be allowed a do-over in this case, Your Honor.
All right.
But I'm not going to repeat what's already in
Okay.
front of you.
Okay,
Thank
thank
you.
you.
Again, if you have questions, I'm happy to
All right.
answer any.
And then also sort of in this motion and asserted in a lot of the defense motions are what we again touched on, that Brady material arose from this ex parte and y'all have it now, so it's not a Brady violation anymore.
And
there was.
And that's not a real requirement
Okay.
in order to grant our motion, Your Honor.
All right, I just wanted to make sure I covered that as well. Okay. Does the state want to be heard with regard to anything not already in their response?
Yes, Your Honor.
Okay.
Just based on defendant Kendrick's representations to the court and others that they're winning, and therefore we goaded them. If they're winning, then let's just keep it rolling, because the state vehemently objects to a mistrial.
Okay.
And I am unclear how we are arriving at the conclusion that the state, in conducting something according to the rationale presented to the court by the defendant so far, that the state never intended that they find out about in an effort to cause them to do something. I don't know how those two can be squared with one another. So we would ask that the court deny the motions for a mistrial based on the state, based on anything. I'd point out that this is not the first or the second or the third motion for mistrial. The state has objected every step of the way. We continue to object to a mistrial. Again, if they feel they're winning, let's keep it rolling. And we would ask that the court just deny it. Of course, the court is aware that the issue here is not whether anyone acted improperly, but what objective the prosecutor is trying to achieve. It does not make sense to assert on the one hand that we want you to not ever learn about it, and on the other that we are intending that you be goaded into an act by our doing it.
Okay.
So, thank you.
There are issues here as to whether people acted improperly. Perhaps that does not go to the goading, but I don't want to, it's clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights. He has been locked up in Rice Street for 22 months. I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. I have no interest in retrying this case, Your Honor, and we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
All right, thank you. And I don't know whether this was, I think this was Mr. Nichols' reply to the state's response. So I don't know if it was with regard just to Mr. Nichols' own motion for mistrial or also Mr. Kendrick's motion for mistrial, but I think the argument is applicable to Mr. Kendrick's as well, so I'm going to address it right now. Mr. Nichols argues that the state says that the defense's characterization is a mischaracterization of what happened in the ex parte, but does not offer their own characterization, and therefore they essentially aren't opposing it. And I should just take as fact everything that the defense said. And I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, "The hearing in chambers was proper," unquote, and then quote case law. So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper. So with regard to that issue, I'm not finding with Mr. Nichols. Now, I am going to, in the context of taking under advisement the other motion that we talked about before, take under advisement the concept of whether what occurred in chambers was coercive, and if so, was coercive to the extent that under the cases like, I think, Wynn and Webb, it requires a mistrial. Because I think the concept generally was before Judge Krause, but not in the kind of detail that it is right now. So I do think that that is something that I can take into consideration and will take into consideration, and y'all both briefed it. And so I'll get the ruling to you. As with regard to the propriety of the ex parte itself, you know, we've kind of already talked about, I don't think that was the actual basis of Judge Krause's order on the recusal. So I will endeavor to make a substantive ruling on that as well. So that's another one that I'll probably give you my ruling tomorrow. So, making myself a note. All right, now to Mr. Nichols' motion for mistrial, which, in addition to everything else that's in Mr. Kendrick's, essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible. And Mr. Harvey, I know.
I apologize. Can I interrupt you again?
Yes.
Thank you. I do that with, a smile and a request for permission.
Okay.
Again, I think there are several other mistrials with prejudice that have not been heard by you, and that would include Mr. Williams filed on July 10th of 2024, entitled in part, Motion for Mistrial Based Upon Judicial and Prosecutorial Misconduct and thus bar retrial. Mr. Shart, on behalf of Mr. Jackson, also has a mistrial with prejudice pending that I don't believe the court has heard. And again, I think in seriatim, if you decide on all of those, then I'll come behind these brilliant lawyers.
All right, I appreciate it.
Follow up.
So with regard to Mr. Williams earlier, prior to the, July 9th. Honestly, I don't know that I saw a motion to recuse filed July 9th, but when we talked about all of the pending motions before, there was the July 10th motion for a fair trial and for mistrial on prosecutorial and judicial misconduct. That's one of the first motions I took up today. Is there another one? Yeah. Well, I did. That was one of the first ones. Is there another one other than that? Yes.
Mr. Williams is not asking for a mistrial. If you grant a mistrial, then that would be over objection, in that if you grant, I joined in the goading. See, I think it's a two-step process. You grant a mistrial or deny a mistrial. If you grant a mistrial, then there has to be a conversation about a plea and bar. So I'm joining. If you grant it, would be over objection, then I'm going to file a plea and bar. So I was just upfront with the court. So
But
you are
with regard to anything, is there any motion for mistrial filed by you on behalf of your client, other than the kind of, not really omnibus, but multifaceted motion you filed July 10th that was for a fair trial to get all the ex partes for mistrial based on prosecutorial and judicial misconduct?
On Friday, July 27th, I filed a response to the state's, you called it a gag order. And in that, the second part, I also filed an adoption that if you declare a mistrial, it will be over objection. And then I will be raising a plea and bar because it would be, the only reason to declare a mistrial is because the defense was goaded into it. So that is it. So.
Okay. All right. So Mr. Harvey, I don't think Mr. Williams has another one. And then Mr. Shart, on behalf of Mr. Stillwell,
July 23rd at 3:07 p.m., a motion for fair and constitutional trial. I believe I have a lot to say.
yeah, and
I believe I'm similarly situated to Mr. Steele in many ways regarding that, because I do believe we're being goaded into moving for a mistrial. I do believe that the case law supports that conclusion. I do believe that so much in this case has happened that has broken the case. I believe, and I'd love to be able to argue all of that, but I am not specifically asking for a mistrial unless jeopardy attaches.
okay.
And so that's where I'm at. I'm happy to argue that. I'm happy to argue that before or after Mr. Harvey or Mr. Steele.
Okay. Give me just a second. Sure. You know what? I need to find the motion that was just referenced by Mr. Shard. Anyway, why don't we've been going for a couple of hours. Why don't we take a 5 to 10 minute convenience break? All right, we'll be in recess.
All right. So what y'all think so far? What do y'all think? How y'all think the judge is doing so far? If y'all don't mind hitting the like button on the video so we can circulate it. Let's see. All right, so I've been trying to take a few notes as we went along. Let me see if I can pull them up. Or maybe not. Maybe I can't pull them up. I'll just go through them. So the first motion she had covered was the motion to gag the defense attorneys because DA Love and DA Hilton said that they breaking the rules they breaking bar rules. And what the judge essentially said is that if they're breaking bar rules, then go complain to the bar. Don't complain to me because I am going to deny the gag order request. So that simply means the lawyers can continue to do YouTube interviews, any other interviews. So I think that one was like a fair one because we all know Fonnie Willis did her press conferences, and it was only right that the defense can have a chance to do their interviews and speak on behalf of their clients. So I think that was a fair ruling on that one. Let's see. What else? Amy said, which is a joke. The DA Willis has been all over attorney give interviews. Yeah, all the time. And right now, for people that's joining, we're on a break, a comfort break. Let me see. Hold on. What do you know? And then they also filed a motion. Brian Still filed a motion to correct the language of Judge Cross when Judge Cross said that Glanville did nothing wrong. And she said that's pretty much for an appellate court, an appeals court. And that's the same thing I was thinking. Like, that's not really relevant right now to go in and fix what Judge Cross said. The Supreme Court or the Georgia Court of Appeals can always go in and fix Judge Cross ruling when she said Glanville did nothing wrong. So I think that was like the second one she covered. They also filed a motion to find out if there are any other ex parte secret meetings that happen behind closed doors with the lights off. And so far, what both sides have said, there's no more secret meetings. They both disclose all the secret ex parte meetings. And nothing's wrong with ex parte by itself. It's when a material issue is being discussed behind closed doors. And the judge also pointed out that the defense had several ex parte meetings of their own. So what the defense really wanted to know is Love hiding any other meetings? And Love said, no, everything's on the record, supposedly. And the court, court agreed. Let me see. But the prosecutors did say that they had one ex parte meeting in which they wanted to find out about Woody's lawyer, which is weird because if he has a lawyer, whether it's Bumpus, who Brian Still kept calling Bump Gus. So if it's Bumpus or if it's Melnick, whoever his lawyer is, as long as he has a lawyer, I believe the state overstepped by trying to figure out who his lawyer should be. Let's see. They also was mentioning Mr. White. Y'all know who that is? I don't know who Mr. White is. Maybe D'Angelo White. If somebody know who that is, put that in the chat. I don't know who that is. It don't sound familiar to me. Also, a motion was filed, and the judge told DA Love, she pretty much reprimanded her in a way. She told Love that you need to be truthful to the court. And Love was like, when, is the court saying that I haven't been truthful? And the judge was like, no, but, just going forward, make sure you're always truthful with the court. And Love didn't like that. She was so mad. Love was upset. Love said, oh, no, what you mean be truthful? When have I not? Every day. What else? What else? And then we also had another motion. Brian Still wanted a jury instruction to basically tell the jury that Judge Glanville was wrong when he said I was unprofessional and unprepared. He's telling the judge, fix that. And the judge was basically like, no, I'm not going to fix it. The jury, they've been here. They can see that you're, you know, if you're unprofessional or not. They can tell if you're prepared or not. The judge said, I'll give a jury instruction at the end that basically says that nothing the judge says is evidence. I'm kind of conflicted with this one because if Brian Steele have the judge tell the jury that Glanville was wrong when he said Brian Steele was unprepared, then you're kind of putting it back in their minds again. I'm like, it's been so long now, I'm sure they forgot about it. There's no sense in refreshing it in their minds that what Glanville did that was wrong. So the judge pretty much denied that one. Motion to disqualify Love and Hilton. Now, Brian still kind of went off on like I guess a tangent, if you will. He wants Love and Hilton kicked off the case, but he was kind of going down the rabbit hole for a little bit, in my opinion, because the stuff he wanted to ask the judge, he wanted to question the judge on the stand, Judge Glanville, and he wanted to kick off Love and Hilton because he wanted to put them on the stand as witnesses, because he wanted to ask them why did they tell Woody certain things. They may be true and all, but that's really not relevant to the case of guilt or innocence. So trying to get into the minds of Love and Hilton of why they said what to Woody is not going to exonerate Young Thug and send him home. So that's kind of like having a mini trial within a trial. So a lot of times judges want to allow, you know, talking about a lot of side stuff, if you will, distractions. Even though I give Brian Steele an A for effort, and I think even later on he goes on to say that I don't even want them kicked off the case. Let them stay. Let them witness this butt whooping they finna get. y'all not gonna be able to pass it to another prosecutor and say the only reason the case was lost is because we were kicked off the case. No, y'all gonna stay here. Y'all gonna stay here and own this loss. What you mean? You're not gonna bring nobody else in. That's not gonna happen. All right, let's keep going. And the judge said she's not going to disqualify them right now. Love and Hilton can stay. She's going to take it under advisement. She's going to go home and think about it. And maybe tomorrow she'll figure it out. But, I mean, we got to have some of our characters in the movie. If we already lost Glanville, and we know how crooked he was, and if we lose Love and Hilton, we may not have any more people watching this trial. We'll just be sitting back waiting for the news that they were found not guilty. Somebody said, don't cancel the trial. And that way we can get more followers on YouTube. Come on here. Well, yeah, thank y'all to the ones that do subscribe and support the channel. Yeah, but I'm sure if the trial's over with, we'll cover more trials. The law don't sleep. Let me see what else. And then in the motion of love to disqualify Love and Hilton, DA Love walked to the podium. And when she walked to the podium, the judge said, hey, if you already got it in the motion, if you already got it in writing, you know, don't repeat it. And Love was offended. She said, I didn't plan on it, or something like that, to that effect. So you can tell that she got an attitude with the judge. She really upset with the judge. The judge and Love are not clicking at all. They're not clicking. Hilton, not Hilton, Love and the judge are They're already going at it. Put it like that. They're already going at it. All right. What else we had after that? We had Mr. Kendrick's motion for a mistrial with prejudice. I believe she's going to take that one under advisement as well. But you know, Matt Shaw, he had a point. He said this trial is broken, and even though the judge is trying her best to patch it back together, I think it's a lost cause. I mean, I know she wants the cameras in the courtroom. She want to be on TV. Maybe she thinks this is a career-defining moment for her. But this case, she can't fix it. I know she may try to hang on to it. But even if it goes all the way, I'm sure the appeals court will throw it out eventually. That's if there's a conviction. But what Matt Shaw say? He said, we are winning this case. He said it to their face. Doug Weinstein said we're winning this case. Oh, we're jumping back in.
I wanted to address to the audience is that there's been kind of a lot of up and down and back and forth and in and out, and that is distracting. So I know there may be times when you need to step out for a particular reason, and that is fine. But let's try to minimize that, because if it gets too distracting, I'm going to have to ask you to step out until all your business is taken care of. Okay, so you got to go out, but then it can't be a up and down every 5 minutes thing. All right, thanks.
She's gonna tell the ushers to hold the doors.
Okay. So, Mr. Short, yes, I saw your motion for a fair trial, and the reason I didn't register it as a motion for mistrial is because it's essentially not. It's saying if you grant a mistrial with prejudice, we're in on that. But otherwise, we'd like to, even though we think this trial has been a disaster, we would like to keep going because we think we're winning. So you asked that it be a constitutionally fair trial, and I guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial. Under the Constitution of the state of Georgia, the United States, and the laws of our state. Okay, that is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
I appreciate that. I guess my concern is that all this is not under your control, because you're taking
And I can hear you fine, but I don't know whether my core reporter can or not. You can either come up or you can pick up your mic if you're just a long way away.
Come up, we get to see you on the camera. Get some of that
I
exercise.
guess my concern is that I have no doubt that you will do everything in your powers. I just don't know if at this point, if it's within your control to ensure that we receive a constitutionally appropriate and fair trial at this point, based on what's happened previously. And, you know, I do have cases regarding the concept of goading.
Okay.
But I'm trying not to step out of turn. I know that I am stepping out of turn a lot this morning, but I'm trying to not step out of turn. If you would like those cases.
Yeah, I'm happy to take into consideration anything that y'all want to offer that is on point.
Go. May I approach?
Yes. Can't really get to me, but you can get to my staff who can hand it to me. Thank you. Oh, yeah, I've seen web-cited, and I'll take a look at Jackson and Wilson.
Oh, did I not give you Anderson?
No.
Oh, I'm sorry.
Thank you. Okay.
And Your Honor, I believe that those cases stand for the general proposition combined. Each of them are a little factually different,
Okay.
but they stand for the proposition that the trier of fact can consider certain factors. Of course, the difficulty in determining if someone's goaded someone else comes down to intent. And typically a district attorney or a prosecutor is not going to take the stand and say, I intentionally goaded someone. So you look at objective facts, and these cases stand for the proposition that you look at how basic the rule that was violated is, the experience of the prosecutor. In this particular case, this is a big county. The prosecutors involved in this case are a chief deputy with the district attorney's office and a deputy with the district attorney's office are the two prosecutors that were involved in the ex parte meeting. You look at the evidence of the case, and I know that this is another area where you're hamstrung a bit because you haven't been sitting to hear the evidence. But I concur that the whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that they're a key witness. And without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked and they needed a mistrial. The trial was not going well. The previous witnesses that have testified, it's been again, I know you haven't been here, but we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment by inconsistent statements and contradictions. So, and that's another factor that those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's attention.
All right, I appreciate it. Thank you. All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial preceding yours that we have not discussed. And I am going to address a few of your issues really, well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings. And I have no idea where you got that from, because I certainly never said that.
When we were here last week, and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying, I'm not going to revisit certain motions, or I'm not going to go back to hear those. That was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, I'm going to deny your motion, for example, for a severance, for a 105 instruction at this point. But that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court understanding the cumulative nature of what has happened and how it would factor into your particular decision at the next point in trial. That
makes a little more sense. I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, as soon as she finishes it. You all have, some of you have already pointed out, particular things that while not the official transcript, I can review on YouTube, and I've done that to the extent it has been relevant to these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
Well, okay, yes, and okay, no.
Yeah.
Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up to where we are at this particular point after 9 months or thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it.
But you
You know
can't.
what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it, but now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice, their actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, just reading a dry transcript is insufficient. Every court from the US Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer. You cannot get the context. You cannot get the understanding of a witness unless you're there to view that witness. So I start from the premise that no matter how hardworking you may be, and I think you're a very hardworking judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that that should stand, and I'm going to grant. I mean, it's entirely in your discretion, and that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the discretion, the trial court must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial, sit as a 13th juror. Don't think you can possibly catch up to that extent. Nor do I think that, based upon the cumulative nature of Judge Glanville's saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction, which the court said, you know, I'm probably going to give that at the end of the trial, but I don't think it's necessary to give it now. So,
Okay,
all of those.
I understand.
No, you don't, because you would
And
have did
I
a
don't really
mistrial.
need to hear from the state on this one. With regard to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule on the motion for directed verdict, assuming we get there. But if not, I can ask for, can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial.
She don't want to go.
Is a basis to grant a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times, it's not routine, but it happens when a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review, when it is a different judge than the trial judge. So, you know, if and when we get there, I will consider whether anything ought to be granted as a 13th juror, if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis on which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything ought to be taken into consideration if and when you make that motion again, With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit something. Okay.
To make sure that my motions were also based on the underpinning constitutional rights, both federal and state. And I don't want the appellate court to say, hey, she didn't say anything about that. But I want to make sure that those bases are preserved. Although I disagree strongly with your ruling, I'm still here.
All right, understood, and it is so noted, and obviously it's to whatever it is that you have, any of y'all have set forth in your various motions. All right. All right, I think we all already sort of agreed that we need to redo everything that happened post recusal motion on June 12th, and the details and logistics of that we'll take up probably tomorrow. But that motion itself is granted. All right, a lot of what comes next is evidentially specific. And before we get to that, I know that there are some outstanding bond motions.
Here we go.
So
Here we go.
Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that whichever, I don't even know who took up the bond to begin with, but another court has already considered all of those, the IALA factors, and you don't present changed circumstances. You just essentially say this call was wrong to begin with, and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So
Oh,
that
wow.
motion is denied.
Wow.
Can I address the court?
Do you have changed circumstances?
Yes.
So, okay, go ahead.
Yeah, a lot of
There
change.
weren't any in your motion.
Mr. Williams has been in custody since the 9th day of May of 2022. This is in my motion. Or it should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy because if he flees, the case goes on because it's mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the IALA factors, and so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team.
There you
He
go.
said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew.
Delayed.
Well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an IALA type change circumstance.
Okay.
So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Wow.
Even though potentially it was not done by a fair tribunal.
I don't, all right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, you know, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse. And that was not what the rules require. And so recusal was necessary, but she even, I think, went on to say, but even with that, I don't, you know, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Then I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration, but I understand what you mean. All right, Mr. Huey has a motion for reconsideration of bond with asserted change circumstances of
It's already denied. No more.
the ex parte being a critical part of the trial that he was excluded from, and having been held longer than he otherwise would have because of the delay
Right.
resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carlton Matthews for Mr. Marquavius Huey. I cite for the court Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now with the state, right? With a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence when the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for bond is made, that the candidate, based upon the change in circumstances, would be a good candidate for bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. Wow. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of Georgia?
Mr. Matthews, that is not an appropriate consideration for bond.
I would ask.
Period.
Understood, Your Honor. I'm asking the court to look at the resources that are required to have Mr. Huey here every day. That's all I'm asking the court to look at.
Consideration for bond. All right.
So essentially, Your Honor, I'm asking the court to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court
All right,
based on judgment calls.
okay.
So Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law, and also I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state, 298 Georgia 438, a 2016 case.
What was that site? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial,
Okay.
so forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor,
Okay.
which we are alleging is a change
Okay.
in circumstances, a change brought about by the court and not by Mr. Huey. And we believe that that month-and-a-half delay where he's had to sit in the jail, we're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor.
Okay.
Respectfully.
Thank you.
Thank you, Judge.
All right. So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper. It was that Judge Glanville engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration in the defense's view has become biased, but that in the same way that I said to Mr. Steele with regard to Mr. Williams, if I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bonds. I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond. He asserts changed circumstances that essentially This case has taken way too long, which
Well,
I
Your Honor,
don't
could I-
necessarily disagree with, but
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
all right, I will do that. I
Thank
think
you.
that would be more appropriate. Thank you. Okay. So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion for, it's entitled for reconsideration regarding certain hearsay statements. But given that we've all acknowledged we're redoing Mr. Copeland's testimony, it's not even really reconsideration. It's consider it anew as we go forward. So I'll hear you on that.
Thank you, Your Honor. Before I get started, could I hand over a case? It's actually the Scudder case that Mr.
Okay,
Matthews
sure.
referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may in fact not be a motion, but that King was involving a request, giving the court background facts to show that granting immunity to a witness was in the interest of the public.
Okay.
That had already been done in this case the Friday before. So it's completely different when they had the ex parte meeting on Monday, and I believe Scudder is
Thank you.
more appropriate
All right.
to consider, and it's much more analogous and on point to what happened in this case. And of course, Scudder points out the problems with such a meeting and held that it was improper. Regarding this issue of Mr. Copeland, I appreciate the court correcting my label of what this really is. I agree that it's a consideration anew, and we had prior discussions about it. There was not a written order to this point.
And do you want me to take a look at the original consideration? If so, y'all need to point me to where I would find it.
I don't know where it is,
Or we
and
can
this is
just
not,
start over.
I don't mean to sound like I'm being smart out here. It was discussed. Some of my motions were brushed over so quickly. I think I assumed that I had lost that motion in front of the prior trial judge, and I'm not sure if there was actually a ruling or not. I'm trying to, if I could go back to my seat for a
Okay.
second,
Sure.
Yeah, according to Fonnie Willis, she said gains accounted for 75 to 80% of crime in that county. 75 to 80%. So I wonder if crime has been down by those large margins. So she took down apparently all the gains. I doubt it.
I'm gonna read you something else as well.
And thank you for your comment. She said she watching in the bushes. Let's go.
This one. Okay.
They trying me hard.
I'm handing 5 cases to the court, and I've also provided copies to the state.
Okay.
Thank you, Judge.
Factually, what this is about, Your Honor, is based on statements made by Kenneth Copeland, out-of-court statements.
Mhm.
I think the understanding where we are and the understanding of the facts as we know it, or the alleged facts as we know it, is that Mr. Copeland claims that he was in Mechanicsville on January 10th, 2015. This involves the alleged murder of Donovan Thomas, for which Mr. Stillwell and Mr. Kendrick are charged, and is part of this RICO indictment as well. He alleges he wakes up in the middle of the afternoon, is in Mechanicsville, maybe 300 yards from the scene of where Mr. Thomas was shot, at the Green Store, off of McDaniel Street, at the corner, I believe, of McDaniel and Glen Street. And Mr. Copeland tells the police that he is trying to find his friend Demekion Garlington, and trying to figure out where his friends are, because he woke up in the middle of the afternoon. And he allegedly calls Mr. Garlington and travels down to a McDonald's on Cleveland Avenue. In these pretrial statements, he claims that Mr. Garlington was pulling into the McDonald's as he was pulling in, and essentially in pretrial statements, he says Mr. Garlington and a gentleman named Mr. Demise McMullen, who's also known as Nard and is also charged with the murder of Donovan Thomas, approached the car. Mr. Garlington gets in first, and quickly indicates to Mr. Copeland, before outside of the earshot of Mr. McMullen, they killed Nutt, essentially, and allegedly points to another car that is a white small SUV type car that contains, according to the story, Mr. Stillwell, Mr. Kendrick, I believe, Mr. Williams, Mr. McMullen was at one point in the car, and another gentleman. The point is, it's a quick statement, and it's they, and he points to this car, according to Mr. Copeland, out of court. And this was June 10th, 2015, when Mr. Copeland said that.
Yeah,
There were-
and I have listened to and read the transcript of that interview.
Okay,
So I'm familiar with it.
and just to add context, there were several interviews with Mr. Copeland prior,
Right.
and he never made mention.
This
of
was
these
the
things.
5th one.
So, and also to add context, Mr. Garlington is called in to an interview. He's subsequently interviewed. He denies making those statements. Also to add context, Mr. Copeland on the stand acknowledged that he made those statements to the police, but denies that they were true. And although he didn't specifically say it, he seemed to be alluding that he no longer has the same relationship with Mr. Garlington now as he had back then, because Mr. Garlington wouldn't lie for him. It wasn't directly said, and I'm sure will come up in cross, but putting the dots together, Mr. Copeland was in legal trouble, wanted Mr. Garlington to lie for him, to verify this lie that he was telling the police. Mr. Garlington wouldn't do it, and it foiled Mr. Copeland's attempts to get out of jail. That's the context behind all this. But the question is the admissibility of this statement, they killed not, and to the extent any follow-up conversation about that incident that Mr. Garlington allegedly said to Mr. Copeland. Mr. Garlington is charged in this indictment. He has a Fifth Amendment right. He's not on trial with us. I have no information that suggests that he's going to be testifying in this case. So he will not be testifying. So the state is attempting essentially to ask Mr. Copeland about statements he made to the police that of what Mr. Garlington told him, because there's no indication that Mr. Copeland himself has any firsthand knowledge or is a witness to any of this. Now, I have a separate concern about the way they're not laying the foundation for a prior inconsistent statement to play the videos, because Mr. Copeland is in fact acknowledging that he told the police. He's not denying making that statement. He's just denying the veracity of that statement. That being said, the statements themselves, how are they admissible? Because they're clearly hearsay. Garlington to Copeland, Copeland without firsthand knowledge. So the state has always taken a position, as I understand it, that these are statements by a co-conspirator. Thank you. They've always taken a statement that they're statements by a co-conspirator. In their filings recently, and I don't want to misstate this, they may have made this claim before, so I'm not going to say it was the first time to make this claim, but I noticed in their filings, they argued in the alternative that they're statements against penal interest as well. And they've provided cases, and I have just handed up my cases. Regarding co-conspirator statements, of course, and we're talking about hearsay and the confrontation clause. It seems to me their main reliance is on the Kemp case, where the Kemp case, as they want it to be understood, is that idle chatter or narrative of past events do not further a conspiracy, but narrative of past events are admissible if they serve some present purpose of the conspiracy, including statements made to solicit membership or participate in the conspiracy or to promote cohesiveness among or provide reassurance to other conspirators. And the reason I filed this motion is because in all prior discussions, the trial court completely glazed over the furtherance. I'm focusing on whether these statements further the conspiracy. Okay, the state's cases do not apply to this situation. The difference, and I'm referring to the Kemp case, United States v. Flores, which the state relies, United States v. Santiago, and US v. Holt, all in their filings. There's absolutely no indication in the record in these statements that the alleged declarant Garlington was attempting to solicit the membership of Copeland in the conspiracy in any way. And I understand the states in the case law, some of the cases indicate this, that you have a conspiracy, you got a small conspiracy and a large conspiracy, and statements in furtherance of a conspiracy could be furthering the large conspiracy. Okay, but soliciting membership, there's been no allegations whatsoever by the state. In fact, we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. They've fought to say that Kenneth Copeland had nothing to do with that conspiracy. So there was no solicitation there's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. In fact, that had already occurred at the time that these alleged comments by Mr. Garlington were made. And if the argument is, well, they were trying to solicit his membership into a larger conspiracy, the YSL conspiracy as a whole, Mr. Copeland, according to the state, from the very beginning, according to their expert, Investigator Belknap, according to everything they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland from 2012, 2011, 2013, well before this date, where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy according to the state.
Okay, let me ask you this. So a part of the cases that the state cited, I mean, it may be that part of it was one way you can find this as a co-conspirator exception is soliciting membership, but another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang. Right. So can you address that?
Well, they have the burden of proof by preponderance of evidence to show that this has been furthered. There's been no evidence. Again, we're seeing pictures from over the years. There appears to be complete cohesion. There's been no evidence that this was done, if it happened at all, which my sense is it didn't happen, but assuming that the statement was made by Mr. Garlington to Mr. Copeland, this brief statement, I think we're really stretching where the exception is essentially swallowing the rule. If we just say, well, a statement about past events with absolutely no indication that someone said, hey, this is what we need to do. We need to be quiet. We need to do this. We need to do that. There's no indication that Mr. Copeland was instructed to do anything. Mr. Copeland just drove where he wanted to go afterwards. Now, I will say, and I'm sure the state's going to point this out, that people on the street apparently thought Mr. Copeland was involved and began allegedly shooting up houses that he was associated with, but that has nothing to do with the purpose of the statement that allegedly Mr. Garlington made to Mr. Copeland. So there's absolutely, I mean, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement and just assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with? Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything. You know, the story that comes out through past statements are Mr. Treadwell takes a car somewhere to get rid of a car, to get rid of guns. You know, again, I'm not saying these are true statements, but that's what comes out in the discovery, and that's what comes out in other people's statements. Mr. Copeland has, it's completely devoid of anything that Mr. Copeland was asked to do. As far as also fostering cohesiveness, Mr. Copeland himself said that Mr. Garlington at the time was his best friend. So I'm not sure. In the United States v. Flores case, they talked about cohesiveness and cohesion within the group. And that was a situation where one individual, the declarant, was talking to another individual that didn't know. So you got the declarant, who ends up, and then another individual who ends up being the witness. We'll call him the third party. And then you have the defendant, and the declarant is telling the witness, hey, let me tell you about the defendant. He's a solid guy because this is what he did. And we're all one cohesive group. But the witness and the defendant were not close. They didn't really know each other. So the middleman, who ends up was the declarant, is kind of informing one person about the other and saying, oh, he's solid. We can be cohesive. In this case, Mr. Garlington and Mr. Copeland and Mr. Stillwell all knew each other very well. And that's come out in testimony. That they're, according to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. So I think it's distinguishable in that aspect as well. US v. Holt, I'll just point out also, with all my other arguments, there's no indication in that case. It talks about keeping a co-conspirator abreast of the situation. There's no indication that Mr. Copeland needed to be kept up abreast of the developments at the time. Mr. Copeland was not summoned to do anything by the group. Mr. Copeland called Mr. Garlington wanting to find out where he was. So it wasn't a situation where the group, assuming these statements were made, called Mr. Copeland to bring him in. Oh, can you pick us up? Can you do this? Mr. Copeland reached out to them. And also I'll point out that US v. Holt was argued under or decided under the plain error standard, because the trial attorney did not object appropriately. I have the 4 cases I handed up: US v. Blakey. Well, I'm sure the court will read the cases, but State v. Wilkins I thought was particularly informative. It's a Georgia Supreme Court case. Trial court made a pretrial ruling excluding incriminating statements made by the co-defendant had been tried earlier. Trial court held that while statements were made by a co-conspirator, they did not further the conspiracy, and the trial court did not abuse its discretion. And it goes through all these different statements that the declarant co-defendant made that were basically spilling the beans and did not further the conspiracy in any way. State v. Lane, same thing. And that one, it's interesting. The appellate challenges the murder conviction, and the trial court granted Lane a new trial. The allegation was, the appellee, the defendant, hired Stallworth to kill a gentleman named Mr. Perez. A witness named Thompson testified that Stallworth told her about the plans to hit a lick before the killing, and then afterwards said that Lane did not pay him because he killed the wrong guy. The trial court initially at trial let the statement in, but then at the motion for new trial reversed itself, saying that in no way, in no stretch of the imagination was this statement made in furtherance of the conspiracy. A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy. The state points to no evidence that suggests that by these statements, Stallworth was seeking to solicit the help in conducting the scheme or concealing its existence when he made those statements to his girlfriend. So those are the cases that I rely on. I also provided Stafford v. State, which is a little different because that was made to law enforcement. It supports my proposition generally, but it's a little different because it was made to law enforcement. Would you like me to address the statements against interest while I'm up here?
Is that in this motion?
Well, no, I understood the state's reasoning for the admission of these
Oh, the
statements.
penal interest? Yeah,
Yes.
go ahead. Yes.
So I'm confused on how this is against Mr. Garlington's penal interest to say they killed someone. It's a hearsay statement that inculpates the accused is admissible if the declarant is unavailable. Okay, I can see that. The statement so far tends to subject the declarant to criminal liability that a reasonable person. Gotcha. I'm sorry. That would subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true, and the statement is corroborated by circumstances clearly indicating its trustworthiness. My main objection is number 2, although I do believe that the statement is not corroborated either. But prong 2, it was not the type of statement that tends to subject the declarant, in this case, Demekion Garlington, to criminal liability. He said they did it. I don't know how that could be a reasonable person could, how it could be said that a reasonable person would feel that saying they did it would put that person in legal jeopardy. As we know, as the pattern charges tell us, knowledge of a crime, mere presence, but certainly knowledge of a crime is not enough to convict anyone. And again, he did not say that he had any part in it. He did not say he played an active role. Additionally, Your Honor, I would point out the Williamson case that that I provided. And the Williamson case is, I believe it stands for the proposition that when if you find any part of Mr. Garlington's statement to be self-inculpatory, which I don't believe it is, Williamson dealt with a situation where within a statement, there's inculpatory and exculpatory segments of the declarant statement. And Williamson says you have to deal with the pieces of the statement individually, and you just can't say, well, there is some inculpatory parts of this statement, so therefore it's all allowed in. You have to excise out the self-exculpatory areas within the statement and the neutral areas within the statement. It says 804B3 only extends to self-inculpatory statements and not self-exculpatory portions of a larger inculpatory statement, or to aspects that are neutral as to interest. Self-exculpatory statements are exactly the ones which people are most likely to make when they are false, and mere proximity to other self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's Williamson v. State, 512 U.S. 594, 1994. So if there are, which I don't believe there are, any inculpatory parts of Mr. Garlington's statement, the exculpatory or neutral aspects of that statement need to be excised out. And I'll point out that if you listened, and I know Your Honor did listen, but I mean, I've listened to these statements 15 times, 20 times at this point. It's very unclear to me where the source of some of, we're assuming a lot of it's coming from Garlington, but it's really unclear where Mr. Copeland is claiming to have received some of his information and when he received some of his information. So that makes this task difficult. I think that absent a showing that the state can meet their burden under 801 D2E or 804 B3, that none of it should be admitted. But Certainly, if we were going to admit some of it, we would have to excise out the parts that are not self-inculpatory, including, but not limited to the part where he's pointing at other individuals and say they committed a crime. So those are my objections. I think if they come in that it violates hearsay as well as the confrontation clause.
And what's your confrontation clause argument? Because we haven't really touched on.
Well,
that
because
so much.
Mr. Garlington's the source of the information, and he's not going to be subject to cross-examination. He's not testifying.
All right.
So thank you.
Thank you. Who's arguing this for the state?
No. She about to be longer than him for sure.
Judge, I will, of course, stand on, not stand only on, but stand on the response that we have filed. I would point the court's attention starting off to page 3 of our response and the second full paragraph on that page, Your Honor, where we are giving some facts of the case wherein it's already been shown at trial that a few days before the murder of Mr. Thomas, Mr. Copeland said that he was with Defendant Williams when Defendant Williams rented an Infiniti from a rental facility at the Atlanta airport. That same Infiniti, we allege, was utilized in the murder. Evidence at trial has already proven that Defendant Williams did in fact rent an Infiniti Q50 on January the 7th and returned it on January the 11th. Testimony at trial has already revealed Mr. Thomas's participation in Mr. Thomas's standing as a high-ranking rival Inglewood family blood gang member to the YSL criminal street gang. The week before, as Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial by Mr. Thomas's brother, Kelvin Watts. And in the early morning hours after the murder, multiple YSL gang members, including Mr. Copeland.
Slow down.
I apologize. Including.
And y'all start reading instead of talking. Speed up. All right, go ahead. So in
the early morning hours after the murder of Mr. Thomas, multiple YSL gang members, including Mr. Copeland, Defendant Williams, Mr. McMullen, Demekion Garlington, Diamante Kendricks, and Shannon Stillwell fled to Miami, Florida. And after these members of YSL returned to Atlanta, there were a number of retaliatory shootings between YSL and IF gang members. So just to sort of encapsulate that, all of that, when Demekion Garlington alerted Kenneth Copeland that they just killed Nutt, he was alerting Kenneth Copeland to the fact that a rival, a high-ranking rival gang member has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
I apologize.
yes, sir.
A lot of this is not, and I put in writing, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown or will.
Okay. So you, Ms. Love, are presenting this as what the evidence has already shown.
Part of it. Not
So
the part that I'm saying now, I specifically say when I mean to say that the evidence has shown.
okay, so the evidence has shown that Thomas was a high-ranking
Yes.
person in a rival gang.
Yes.
That the week before Mr. Copeland was assaulted by Thomas's brother.
Yes.
That in the early morning hours after the murder, Mr. Copeland was amongst the people who fled the group of alleged YSL members who fled to Miami. That's established already?
No, so that will be established.
Okay.
I did not assert that testimony at trial has revealed this, but I am
Okay.
asserting that it will be established.
Your Honor,
Who all has,
apologize. It matters, it was not in the early morning hours. Mr. Copeland's phone records, if you go by phone records, will be several days late.
Okay. Thank you.
Weinstein finna get him.
Excuse me, Your Honor, I object to the language of it's already been proven in here. I don't mind if she says that there's been evidence that's been submitted, but
Okay.
already been proven, I think is too much.
Right.
Noted. Agreed. That's not for us to decide. That's for the jury to
Jury,
decide.
right.
Ms.
our
Love,
position?
that's fine. Our position is fine. But what, so is your evidence going to show that Mr. Copeland went to Miami in the early morning hours after the murder, or is it going to show that several days later? he
Not
went to
several
Miami?
days later. I believe it was actually, I know that, was it the next day? I think it was the next day that
The murder was,
January 10th.
okay, and he went to Miami.
And then he was in Miami.
While the state's doing it, if you really care, it's
Your Honor, if I
January
may.
6th is the alleged beatdown.
Okay.
Mr. Copeland, it wasn't a week earlier. January 10th, it's going to be January 6th. It's at the club.
Okay. Thank you.
Crucial. It's a compound, not
It
crucial.
was the Sunday before, Your Honor.
Okay.
And so the murder is January 10th in the evening. Some YSL members arrived in Miami on the 11th. Mr. Copeland arrived in Miami on the 12th. So the departure from Atlanta by some was hours after
Okay.
the murder. Mr. Copeland gets there on the 12th.
Okay. And do you have evidence that they all congregate together
Yes.
in Miami? Okay. Okay. And does he go, does your evidence show that he is with anybody else on his trip to Miami? I'm just
Just one
curious.
second.
She about to get her lie together. Here she go.
Mhm.
Testified to answer your question. I believe that Mr. Copeland testified
Talking to Mike.
after the recusal motion, that he traveled to Miami with his girlfriend for the mother of his child
Okay.
and his baby.
All right. Thanks.
And also, my understanding, and I believe it was testified to, it may not have been, was
Sure.
just to, when we're using the word fled, is that Mr. Williams had a show in Miami.
Okay.
Matt, you giving her more time to get her lie together.
So, Your Honor,
Mm-hmm.
Mr.
Max.
Copeland, I believe, has testified already that they were collectively in Miami.
Okay.
Regarding the court-specific question of who he went down there with.
Yeah, she lying.
We don't
That's
assert
okay.
who he
They were
specifically went down there with.
Together once down there. And when did they come back?
They came back at different times.
Here she go.
Our phone records, I'd have to look at.
A couple of days later?
I thought he went with his
Just give me a
girlfriend.
ballpark.
Some, they came back at different times.
Okay.
Different times.
All right. And was there a show For Mr. Williams down there, some kind of a music show, I assume.
Look it up.
We,
You don't
that's an assertion
Okay.
that we haven't. That's not evidence that we
Okay.
have or we have put in. It's not evidence that we
All
have.
right, well, that might be some,
And there was, so just to also clarify, this vehicle that was rented, it was rented for a certain number of days. It was
Okay.
supposed to be returned, I believe, 3 days after it was returned. So they returned it early. They returned it on the 11th instead of returning it later in the month as it were. I think, as I said earlier, I believe it was returned about 3 days early. If there was a show, Mr. Williams was aware that he was going to be attending at a particular time on the 11th, the need to keep the car, unless they intended to drive the car to Miami, I would assert should have reflected itself in the way that he secured the rental. If he intended to be at a show, then
what date did he rent it?
he rented the Infinity on January 7th, I believe it was. And he returned it on the 11th.
All right.
And the already admitted at trial is the rental agreement that shows that it was due to be returned later after the 11th.
So it was probably a week rental,
Actually, Judge,
maybe? Okay, whatever. You said a few days early, which, okay. All right, so back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence or is it going to be in
that
evidence?
has been already put in evidence and additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth, okay. Between YSL and whatever the gang is
It's
that
gangs.
Mr. Thomas,
IF,
okay,
yes.
all right.
Specifically, if I may, there were instances that were testified about regarding a particular shooting. So right after the murder of Mr. Thomas, there were a number of shootings that Mr. Copeland was very concerned about and spoke about when he spoke to police in the early morning hours of the 11th. When he himself went down there, he essentially said to them, and I believe that the court has the recording of Mr. Copeland's first interview, they're shooting at me. They think I did it. They being Ifke, they think I did it. And so his girlfriend's father's house was shot up. His brother's house was shot up. Mr. Williams's father or stepfather's house was shot up. There were a number of shootings that have already been testified about.
All right. All right.
So just to start with the assertion regarding cohesiveness, that it's not so much a situation where we're asserting that someone is trying to bring Mr. Copeland in to the fold. He's already a part of it. And in alerting him to this happening, this event, he's including Mr. Copeland in on what's going on with the gang. This is our position, so that Mr. Copeland can comport himself appropriately.
All right.
We have noted in our response that when we are talking about a conspiracy, it's not just the conspiracy, it's not regarding the conspiracy of the murder of Donovan Thomas only. The conspiracy is the wider, broader participation in YSL, and the criminal conspiracy is alleged in count 1.
And Ms. Love, is it correct that Mr. Copeland also said to police that after the first revelation that they shot Nutt by Mr. Garlington, that, and that was in the McDonald's parking lot, that either they did or they were then instructed to follow
They did follow them too.
the car that had apparently been involved or allegedly been involved, follow that car to
Condo.
another place where they all spent the night,
Hold on just one second.
Oh, here she goes.
and that he did so?
Okay, we're trying to make certain that the court is hearing that it's Mr. Treadwell's vehicle, not the Infiniti,
Okay,
that they are following to the same place.
okay. But the vehicle that Garlington apparently indicates when he says they shot Nutt
Pointed to the white,
means the people in that car.
yeah, the Nitro, yes,
Nitro, okay.
yes, the
sorry.
Dodge Nitro.
Okay. And they then,
Followed the Dodge Nitro.
Mr. Copeland follows the Nitro.
Yes.
And is he directed to, according to him?
I don't know that he says that he's.
Okay, well, anyway, he follows the Nitro and they all spend the night together at an apartment that Mr. Williams has in Midtown.
I don't know that they spend the night. They end up at Mr.
I don't know whether they did either. I'm asking what Mr. Copeland said happened.
That they all go to the
Okay,
home. Of
Okay.
Mr. Williams.
okay,
I can assert what I expect other evidence will show that is not yet been shown, but
Say
other persons that we expect will testify during the course of this trial will also say that they met at Defendant Williams' condo. And as reflected in some of the factual acknowledgements of some of the persons who have already entered negotiated pleas in this case, they were given money to lay low. Members of YSL were given money to lay low following the shooting of Mr. Thomas.
okay. All right, and so your theory is that,
In alerting
go ahead.
Mr. Copeland to what just took place, it furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly.
All right.
And they do act accordingly.
Okay. All right, what about your statement against penal interest argument? I mean, I think that Mr. Sharp raises kind of a good point that how can it be against Mr. Garlington's penal interest to say somebody else did the shooting?
It wasn't just the shooting. He also, Mr. Copeland, that he has also talked about Mr. Garlington's words to him regarding his presence and his knowledge of who it was that participated in the Little Wayne bus shooting as well.
Okay,
And
so
these-
this
That's
is
not
an
a statement,
entirely different
right.
shooting.
Right.
There were two, yes. two
Right,
different-
so
It's not
let's focus right now on what he said, the hearsay about the Thomas shooting.
He didn't say
How is
nothing.
that against Mr. Garlington's penal interest?
It's, Mr. Garlington, as we said, is providing information about we argue, a gang-motivated crime committed by members of the same gang that he is a member of. So in saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He's a member of the same criminal conspiracy as those that he's called murderers and shooters in the Little Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder or the shooting. He would not be privy to the information that they just killed Nutt had he not been a part of that same gang that these persons that he alleged have just killed Nutt are also parts of.
All right, so is your theory then that when he says this, it reveals that he's a part of this same gang and therefore he can be charged under a gang count?
No, he has he's, because of his involvement, so it's not just that, it's not so much that he can be charged under
Well,
a gang
a
count.
statement against penal interest would require that what you say could get
You
you
in trouble.
arrested and convicted of a crime, right?
Exactly.
Correct.
So how is what he said going to do that?
It is evidence of his membership in a criminal conspiracy that is YSL. The act that they have committed is evidence that this enterprise commits criminal acts. It subjects him to punishment under count 1 in our indictment.
So as a RICO charge, not even a gang charge, a
Well,
RICO charge.
a RICO charge and a gang charge, to be clear, because in our case, the RICO charge is involving the criminal enterprise that is YSL, the criminal street gang. Mr. Garlington is a member of YSL, the criminal street gang. Part of what is necessary to prove a criminal street gang even exists is the fact that members commit crimes to further the interests of the gang. He is acknowledging that a group that he is a member of commits these type of crimes that he is talking about. That acknowledgement can subject him to punishment for acts that he commits as part of or in furtherance of the
Yes,
criminal
for acts
street
that
gang.
he commits. He hasn't, by this particular statement, admitted to committing any acts, right? He's saying somebody else did. All right,
As it relates to the shooting, he didn't do that.
okay,
Yes.
all right. Okay, anything else on this issue?
Just 1 second, Your Honor. And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas before the murder.
Okay.
Also reflects his involvement in the gang itself.
Okay. All right. Sure.
And Judge, if I
Hang
may,
on,
before
she might
Mr.
not be done. Go ahead.
Apologize.
That's okay.
I would
She
cite the court to United States versus Padilla, P-A-D.
Is this a new case that's not in your response?
It's
Okay.
not.
Okay, all right.
She may not be done. Of course she not done.
USB Padilla,
Yes.
what's the site?
It is 2000 US APP Lexus 1843 at
What's going on, Simply Todd? Thank you for popping in. For a quick minute. Let's see. Yeah, she denied bond, Jiggy. She denied bond. What's going on with the judge? Who got to her? The people want to know. Did they hit him up in the back room?
At what?
page 5.
Okay. All right, 2000 US APP Lexus 1843 at 5.
Yes.
Okay. All right.
Wherein the court says that we reject the arguments of Padilla and Rodriguez that the district court erred in admitting plea allocutions of 5 co-defendants. The district court found that all of the co-defendant statements being admitted into evidence were self-inculpatory, involving inter alia admissions of membership in the named RICO conspiracy, and the court declined to reverse the district court's finding as an abuse of discretion. So in his statements, we would argue inculpate him in the RICO conspiracy that we have alleged in this case.
Okay. Thank you. Mr. Sharp.
So, John, I think it's clear that this is not a statement against penal interest. You know, it's what a reasonable person would believe. And, you know, to come up with these theories about RICO conspiracies when you haven't done anything wrong, I just don't see that as falling under that exception to the hearsay rule. Regarding the statements, whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements about the alleged murder. Apparently he said, you know, can you come pick me up? Sure. He went down there. A statement, we say it was never made. Mr. Copeland now says it was never made, but regardless, the statement, if it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows.
Okay.
The state is arguing that narrative events given so someone can comport themselves appropriately makes a statement in furtherance of conspiracy. And if we just logically think about that, that would mean that any time there's a declarant and someone else and a witness who are allegedly involved in the same conspiracy or in the same gang or anything else, anytime a statement of narrative events is made from declarant to witness and they're linked together in any sort of alleged gang or conspiracy, by definition, it would fall under this exception. And that's just not the case. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory. And it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything. And, you know, if we were to just allow those spilling the beans statements in under that just imagined alleged basis, then the rule really doesn't even need to exist and the exception would swallow the rule. So it doesn't fall under either of the exceptions asserted by the state.
All right, thank you.
Your Honor, may I add one thing briefly?
Yes.
I just point out that the cases that were cited by defense in support for their position, those were not gang cases. Ours specifically, the cases that we cite are gang cases. We cite a plethora of gang cases. And in doing so, we express how here there is a distinction between the case that we have and the cases that they are citing, and that we are specifically talking about the criminal conspiracy of the YSL street gang. The argument that any statement made for a narrative purpose would be admissible is inapplicable here, where the statement that was made was not just any statement for a narrative purpose. It was a statement about a criminal act committed by a co-gang member, a co-YSL member or members of the enterprise that this young man, Demekion Garlington, is alleged by the state and we believe can be proven to also be a member of. Additionally, we will be at trial later on, presenting evidence from other sources of what took place at that condo, which further show
All
what
right.
we are arguing here.
All right.
That's enough.
Let's break for lunch. We're probably a little bit on the late side for breaking for lunch, but it is 12:35. Let's come back at 1:45. Mr. Steele, I'm going to give you your copy of that transcript back. Thank you for loaning it to me. Thanks.
All right. Woo, let's go. This is insane. Hold on, real quick. Hold on. Let me a second. I don't know why that banner popped up. I'm trying to make a banner for lunch. Let me see. All right, so we already know the bond motion was denied. Judge didn't want to hear it. The judge said there was no change in circumstances. The judge said, what's changed? Well, Judge, you would know that it had you been here the entire trial. You can't come in 9 months later and then ask crazy questions like what's changed? What didn't change? That'll be easier. This is wild. For her to just deny them bond after the state had a meeting, a secret meeting that delayed the trial, over a month and a half. So to no fault of their own, the defendants, they have to sit in jail. So let's say the state do something else in the future to keep them in jail longer. Is the judge going to come and say, okay, there's still not a change in circumstance? Oh yeah, she had her mind made up. Her mind was made up. She didn't even ask the state to respond. She had already knew that it was going to be denied. She didn't need Ms. Love to get up there and talk for 20, 30 minutes. She said it's already denied. And obviously that set the tone, because when that first motion was denied, they already knew Matthew's motion was going to be denied as well. And he had a good argument. They on lockdown 23 hours a day. That was a really good argument. Now, I don't think I would have went into the cost details. He said it's too expensive to keep him in jail and to transport him every day. I wouldn't have went that far. I mean, that's outside the scope of the argument. But the argument he made at first was enough. It was enough to say that they're in jail because the judge was having a secret meeting in the back room. And he had a really good point. He said that when Judge Glanville first denied their bond, we didn't know that he was secretly working with the prosecution team. So in theory, a fair judge never set bond or decided bond because he was never fair this whole time. This whole time he's been a secret player for the prosecution. So what he's telling her, you should decide bond now because we never had a fair chance knowing what we know now. Had we known Glanville was, playing hide and go seek with love in the back room with the lights off, then we could have addressed it then, but we didn't know that he was low down and no damn good. That's what they said. I'm not making it up. They said that we didn't know Glanville was playing for the other team. We didn't know. Had we known, we would have been trying to get rid of his no good. See, I'm not gonna go there. I'm not gonna do it. And I think that was a strong argument. And now the judge is saying she still don't think that's enough. And then she's playing that Glanville game. Well, maybe in the future I'll reconsider. No, woman, you not. You denied it now. It's gonna be denied. Let me see what else they talked about. So now it seems as if Young Thug will be in jail until this case is over with. I mean, she's still trying to play like she may entertain a motion for a mistrial. Based on what I see today, that's not happening. She wants this case to go forward. And then for some strange reason that's unknown to me, she's still trying to push for a plea deal. Which is wild. Why are you trying to make the prosecutors and the defendants sit down and work out a plea deal? They're not going to work out anything. And then on top of that, she tried to backtrack when Harvey, the ponytail attorney, went up there and said, Judge, you said you was not going to go back and review all of Glanville's prior rulings. You're not going to go back and watch the trial. And he used that in his motion. Now all of a sudden she's trying to make it seem like she didn't say that. Now all of a sudden she said, oh, I've been on YouTube. I've been watching. I've been getting caught up. Woman, come on. Yeah, she wants the clout. She thinks this is a big case for her career that she can say, I presided over the longest case in Georgia. Not realizing she wasted time because if they do get a conviction, it won't stand. And I think Attorney Harvey told her right. He said, I appreciate your effort. He said, try as you may, try as you might. But we won't get no fair trial tonight. He said it's not gonna happen. There's no way you can go and watch a video and use that video to substitute for the real thing. You have to be in a courtroom. You got to see people's facial expression, their reactions. A lot of stuff wasn't even caught on the YouTube cameras. And he had a good point. Yeah, he had a real good point. And then also, what did he say? So normally at the end of a trial, normally what happens, defense attorneys will move for what they call a directed verdict. That's basically where the lawyers tell the judge, hey, judge, the prosecutors did not prove their case, so we're asking you to find our clients not guilty. You don't even have to send it to the jury. They didn't prove each and every element of their case. So we're moving for a directed verdict, and the judge can say not guilty on the spot and send them home without even submitting it to the jury. That really happens, but it's possible. And what Attorney Harvey said was, how can you take that into consideration when you haven't been here the whole trial? So when the state case is over with, when they close out their case, when the state rests and it's the defense turn, we are going to ask the court for a directed verdict of not guilty, and you won't be able to make an educated ruling on that because you haven't been here the whole trial. And what the judge is trying to say is, well, going forward from here on out, maybe I can make a decision based on what I hear from here on out, which is crazy because that's not possible. How are you going to make a decision from here on out and you're missing over 100 witnesses testimony? I can't tell. Somebody said she friends with her. Well, that's what you call a friend. What they say, who needs enemies? See what happens when you put your name on anybody's flyer? They probably thought this woman was their friend. Now, don't get me wrong, she's not, it ain't like her in love or like close, you can tell. But she denied their bond. I mean, that's like the biggest thing that we were all waiting on today. And she sat there and denied it. Northside said this judge is going to make the state look corrupt, that they are just to save Glanville's face. She not allowing no chief judge stand on her watch. I mean, I think he told her right that she's unable to go back and try to watch on YouTube. Let me see what else I got in my notes. But I thought they'd been in custody since 2022. But one of the attorneys, Matthew, said that his client had been in custody since 2021. And he rightfully told her that's a long time. What do you think Brian and them saying to one another? Well, I'm sure they're talking about this judge because they didn't really know which way she was going to go. And I'm sure the clients maybe had a little hope over the weekend that, okay, we got a new judge. This is their first time seeing that judge. The lawyers probably told the client that it may be a good chance she will give y'all a bond. And then she come in here. And it was like the bond was like the first thing or one of the quickest things that she disposed of. Like as soon as they made the arguments, it's not changing circumstances. So state, you don't even have to respond to this nonsense bond motion. I got it. So I'm thinking she's trying to make a name for herself. Let me see. I mean, she granted stuff that was like inconsequential, like a motion for a fair trial. She granted that, of course. But granting the motion for a fair trial and actually giving a fair trial are apparently two separate things. Because I'm trying to understand why she think that the trial being delayed this long through no fault of their own, the defendants should remain in jail for another who knows how long. The state can keep calling witnesses over and over again just so they can punish young thug indirectly. Yeah, we may not can get a conviction, we may not can't win this case, but what we can do is drag it out. And when we drag it out, we still get some time out of you, so to speak. We're still getting 2 years out of you, 3 years out of you. You would never get this back, even if we lose. Thank you, Tip State. So yeah. But I think now she showed her hand. She showed her hand now. So she said she fooled me. I thought she was going to be fair. That's not happening. She said, okay, maybe she said she would deny bond because she's going to rule a mistrial. Nah. That ain't happening. I mean, the motions have been filed, so she was going to rule on a mistrial with prejudice. What's she waiting on? These motions were filed a week ago on Tuesday. some even before that. I mean, if she wanted to grant a mistrial, she would have. That's why I think and I kind of figured in the beginning when she started going through other motions and not the mistrial motion first, I was like, okay, mistrial denied. Because it wouldn't make sense to go through 100 other motions just to grant a mistrial. I mean, if you're going to grant a mistrial, then all the other motions are irrelevant. So I kind of figured, you know, she's not going to go the mistrial route. She would have did that first, and they would have saved a whole lot of time. Somebody says they better not give her another party, not one more, not a one, not a one. Wait, what this mean? She was screen time. Oh, she won't screen time. Yeah, she not going nowhere. Yeah, don't sleep on Fonnie. I think she behind it too. And let me go through my notes. Let's see what else we got. I don't know. Saying that they winning the case. I don't know if that's hurting him or not. I don't see how to have any bearing on what the judge has to consider because the defense think they're winning the case. Well, she don't want the jury just sitting in the back while they hash through all these motions. So once this is done, then the jury can come back. But the way she's moving, we could probably be done by tomorrow with this. Thank you, 313. The best side on the replay. She has an agenda. I don't know what it is, but there is an agenda. Somebody said Sharp, Steele, and Harvey need their money back from her. I thought it was another one. I thought it was the older attorney. Is it Bots or something like that was on there? I don't know if Sharp was on there. I don't know. We gotta go back and see. I'm still tripping on no bond though. I definitely thought he was coming. Nah. Yeah, Mr. Bob. There we go. Law Malcolm said, Jiggy, come on, man. You should have known that Jeff not getting out. Right. I don't even know how she's going to tell the jury why there is a new judge in the building, because obviously she don't look nothing like Glanville. So that's going to be interesting right there. Are you going to tell them he was kicked out because of misconduct? And I understand, I think Brian Steele said that he's going to, like he was telling the judge the questions he was going to ask Kenneth Copeland on the stand. And that could be kind of good and kind of bad, because when you're telling the questions you're going to ask, and then you're giving the element of surprise away. And now the state knows what questions you're going to ask. And they may even try to file a motion to stop you from asking those questions. See, when you ask the question in front of the jury, the state can object, but the jury already heard it. So it's already in their minds. But if the state file a motion now to stop him from even asking those questions, then, you know, he could be blocked by the judge. He'll be warned by the judge. Don't even go anywhere near those questions, and he'll lose the element of surprise. No, she didn't grant house arrest. No. Now, see, the people was riding with her at first, but now I think the tide is turning. Now we starting to think maybe this judge ain't as, ain't as equal as we thought she was. It's not even that she denied the bond, but it's like she didn't even give it much thought. She pretty much said there's no change in circumstances and moved on. It's not that she would have to just give him a bond, but she should have at least entertained it more. And maybe even allowed the state, why shouldn't they get a bond? .313, so I'm not riding with her at all. She can go. 313 saying we showing her the door. Get him Joe said if the case doesn't get thrown out or a mistrial, the jury is going to find him not guilty. A verdict. I agree. And I mean, I get it as far as the bond. I wouldn't count it as the trial's still going on, so they may have lost the battle, but they haven't lost the war. And the main goal, and I get clients like that all the time, they're so worried about the short term. I want to get out, I want to get out, I want to get out right now. But the main focus is to keep you out, and that's by actually resolving the case, not temporary bond. Even though this bond is not temporary, I mean, nobody can call 2-3 years, temporary. 23 hours. And then she talking about they can't listen to music and they in a jail cell 23 hours a day. And she don't want headphones in her courtroom. She say sometimes different ain't better. Well, I will say, even though she denied bond, it's not like she's buddy with love. Let's see what else we got on here. Somebody had asked, has crime went down in Fulton County? I had put that in my notes. I think somebody's going to pull up those records to see if that's the. Yeah, she did cut Love off. Even the last time they were speaking, she kind of like interrupted to where Love sat down. It's just like, okay, that's enough. But it's crazy. I thought we were going to get some order in the court today. Some order in the court, but what we got is some disorder in the court. Judge said, I'm not giving y'all no bond. Somebody said about 6 people a week in Fulton. And if anybody wants to come up and have any comments, I got a camera and a microphone. Let me know, and I'll drop the link. And for the people popping in, we're on a lunch break right now. We're just waiting on the judge to come back. I'll drop a link anyway, just in case. Law Malcolm, where's your sources? He says since Jeff been locked up, crime is down, no killing or shooting. I doubt that. I mean, you're saying there's no crime in the whole county, so crime has went down 100% when it comes to shootings and homicides. He got to be a troll. We have some people that, stand firm that, that they should go down. But the state has to prove it beyond a reasonable doubt. Old folks used to say beyond a shadow of a doubt. You got to prove it. But it's not up to the defense to disprove it. The prosecutors got to prove their own case. And y'all heard what Love said. Love said if they win it, let's keep it rolling. Well, let's keep it rolling, Love. Let me see what else I got over here. Yeah. So I'm looking to see what other motions. Somebody said that she only granted one for the defense. Yeah, the defense really didn't get, nothing major. They wanted either the judge to grant a bond, that was denied. Who else? The mistrial motion denied. The motion objecting to the substitution of the trial judge mid-trial, that was denied. What else? I mean, she let the defense attorneys, she didn't issue a gag order. Yeah. Motion to remove the DAs. I think she said that's under advisement. She's going to go back and look at that, but that's denied. Yeah, there you go. Everything, yeah, she denied everything, basically. Everything that counted. Ms. Todd said the jury's been gone too long. Somebody is not coming back to stay. Yeah. Yeah, that's the word of the day. Denied. Everything denied. That's wild, though. Let me make sure that we're already with the end. Law Malcolm said they guilty. Yeah, she said Weinstein can still do interviews, but I'm sure his clients, the defendants had hope that they could have got out today. And then you got this judge. I don't know. Something was off about it. It didn't seem like it was a fair hearing. I'm not talking about her decision. She has the right to deny bond. But I don't think she can say with a straight face that no circumstances have changed when a whole new judge is sitting on the bench. That's the reason you're here. What you mean nothing changed? You wasn't here when this trial started. She said you should sign up to be part of the team. Well, I'm not licensed in the state of Georgia. You should do one. Is this Miss Lavanda's face? Somebody that stole Miss Lavanda's face, or she changed her name? Well, if that is Miss Lavanda, how you? She said now it's this judge. Oh, what you saying is we complained about Judge Glanville, now we mad at this judge? Is that what you saying? Is that what you saying, Miss Lavanda? If that's Miss Lavanda, that looked like her on the profile picture. But yeah. The problem is not the lawyers. The problem is the system in Fulton County. And Young Thug doesn't have any felony convictions. And guess what? He doesn't have a bond. He's still innocent until proven guilty. But guess what? He doesn't have a bond. And then you can go across the street to the Trump case, because Trump's case is also in the same county, same courthouse, the same building. And I believe all of them have bonds. And I'm sure because they don't have felony convictions. Now, albeit I know the charges are different, but I don't believe that Young Thug is implicated in any murders or anything like that. I think he only has one count, and that's the overall RICO. She say, check out that clip. Go ahead, open it up. It won't let you put links into the chat. They won't show up. So I don't know what link, what site is it. She say play the clip. Yeah. If you try to put a link in the chat, it won't show up. It won't let us let y'all put links in the chat. And for those who popping in, we're waiting on the judge to come back right now. We're at a lunch break. And if y'all don't mind liking the video, that'd be good. Unless you Law Malcolm or Miss Lavanda, I might have about 2-3 dislikes. We'll take that too. We'll take that too. Let's see. He said, get them drugs, say drop the. They're not going to come over. I'm trying to figure out who, no more tent. I don't know who this person is. They may be, you know how they steal people's pictures. Oh, I'm going to let Miss Lavana know y'all using her image. Okay, we got Melvin. Young Thug should not be granted bond. Is there any reason that you feel that way, Melvin Rigby? Thank you for your comment. And I know everybody have different opinions, so. I like hearing all sides of an argument. Like, why shouldn't he be granted bond at this point in time, since he still have the presumption of innocence? No felonies on his record. So why should he be denied bond? I mean, I just look at it from a personal standpoint. I hate for officers to arrest someone I know, arrest my client, even though they have no felony convictions, the evidence is weak, and then they have to sit in jail and deal with the backlog of the court and just sitting there and wait. I mean, because bond is not meant to be a punishment. It's just meant to ensure that the defendants return back to court. Melvin said he would be a threat to the community. I mean, I guess in that argument would be somewhat decent if the state could have proved what he has already done to be a threat to the community. We heard what they said, but what have they shown that he did in the past to make him a threat to the community now? Because right now I haven't seen any evidence. He's the mastermind of the team. He's the bank. Well, and I guess that's why Brian Steele said if he's on bond, he's not going to be going around doing concerts, making money. He's even willing to do house arrest. So I'm not sure, you know, as far as the bank, the money aspect of it. Because if he can make money on house arrest sitting in his house, then what's stopping him from, you know, making that same money right now in the jail off of like royalties and stuff like that? Because he is a known criminal with a negative ties to the community. But when you say known criminal, where are the convictions to make him a criminal? Where are those felony convictions? Miss Hillary said he will basically be in jail inside of his home. What he is doing now, they have proven that he will not flee and will show up to court. Yeah, it wouldn't make sense for him to flee now. If he's a mastermind of the bank, where's the paper trail? What did Lil Woody say exactly? You say Lil Woody told it. Because the last thing I heard from Woody is that he admitted to lying, and he said, I only lied to get out of jail. And that makes sense now, because the Fulton County will hold you for 3 years. So I'm sure it's a lot more lying going on to get out of jail. Miss Kelsey McDuffie, if he is the person y'all are saying he is, then it's not possible or impossible to do from jail as well. We haven't heard anything like that from my understanding. He deserves to bond for the time being. Tanya said, of course he would say he lied. Well, he said he lied multiple times. Not to mention, he said, I did these crimes. And that's on the transcript. She said, no more air piles, no more thugs sitting there eating tangerines. He might be eating one right now. This man has no connections to the murder of Donovan Thomas, really, and I've seen people with murder charges get bail. Yeah, from my understanding, someone from that county that's either been accused, got a bond of homicide. She said, well, quite honestly, in the real world, they weren't really supposed to be in there eating in court anyway, so I do agree with that. Judge said, no more up and down. She said, y'all walking too much. She told the church ushers, she said, hold the doors. She said, don't let them in. Don't let them in. If they get up and they walking too much while the pastor preaching while he praying, hold the door. He said they are talking just to be talking. A lot of people on here do that. They just be talking. Half of them don't know what they're talking about. And I just go along with them. Because I know they don't know no better. They don't know no better. And then I drop the link. And then they can't argue their position. She said, read my comment about the brother snitching, read my statement. His brother snitched too, read the statement, don't just get past it. She said, see, you want to play fair, I'm about to leave. I didn't drop the link for all of y'all. Anybody want to come that has something to say? Let me see, read my comment. Okay, let's see. Read my comment of the boy admitting that third gave them to play low money. What? I don't even. I'm listening on my TV and I don't know. Thank you, Amy. Oh, somebody say that's Love and Hilton in the chat. She said, oh, now somebody who told her to leave. Is that who that is? Law Malcolm and La Vida? Is that Hilton and Love on their lunch break? They came over here. 313 says it's airport. So they working for the prosecutors. For those popping in, we're on lunch break. We just see, she's talking about stuff that might be presented. It hasn't been presented yet. Miss Love is cleaning up the streets of Georgia. The chat is funny. She said, they losing, you losing, you'll never meet the. I don't know if that was anybody's goal, is to meet him. I'm not sure what that was about. He said, I would be remiss if I didn't mention Young Thug implicating himself with his own lyrics. I don't think that's what that was. And that was the big issue of rappers being rappers. Like, it was just somebody that, what's that guy name? I think his name was don't give me the line. Julio or something like that from Jacksonville. And it was another rapper that supposedly came out and took credit for it. And next thing you know, 5 random people that's not connected to the rapper, as far as we know, were arrested. So good thing the police didn't jump the gun and go arrest that rapper that, bragged about it when it wasn't really him, and really got the 5 people responsible. So just because somebody may rap about something or use their creative expression, that don't mean that they are guilty. And I don't even think Young Thug never said I killed Nut in any of his songs, or I shot Donovan Thomas. Somebody said that might be PBL Brown. Somebody said he was dancing or something. I don't know how true that was. Oh, no, you're all right, Amy. You good, you good. Carmela said, am I the only person that thinks that Judge is playing dumb? Oh, thank you, Amy. Yeah, you're all right. You're all right. I got it. I know it's hard trying to do it on the TV. So I said, or you might actually do your job and help the state present a better case. Somebody say, help DA Brown do his job better. Is this DA Brown? Are you in the building? Show yourself. Oh yeah, no problem. Thank you. She said, Jeffrey's old enough to be my son. My son probably listens to his music, so I'm not worried about meeting him. Just interested in the case. Yeah. Yeah, I don't know how they got that big of a stretch. I'm sure people in this comment can't name 5 of his songs. We just talking about the law. Where Jiggy at? Jiggy probably said, I can. Where Jiggy at? Thank you, Amy. If y'all don't mind hitting the like button, unless you miss LaVonda or Law Malcolm, then I know y'all ain't gonna hit that button. Y'all gonna hit the opposite button. Somebody say, yeah, okay, housewife. Somebody said, I'm with you, Melvin. I'm rocking with you, Melvin. Good sense prevails. Okay. YouTube needs chat AI. Hey, y'all, we got a few more minutes before the court is back. And the judge, I don't even know what motions are left. Anybody know? I mean, the main motions, the most important ones, she already denied. So hell, I don't know what we coming back for at this point. She just need to call it a day. She just need to call it a day at this point, because this is terrible. Hold on, Tiff. I don't know if I spoke earlier. Law Malcolm, how you know what he rapping about? You listening to him? People are weird. We have to be fans of his music. We want them to be treated fair. Right? Yeah. I don't think you got to be fans of his music for a fair trial. Melvin said he's still here, and his position hasn't changed. Melvin said they need to be locked up. But it's still, you know, and I hate to keep making the comparison to the Trump case, but Young Thug doesn't have any felony convictions. And some people may say Trump felonies are fake. But he do have the conviction for right now. You know, it's not through out yet. I think he got like, I don't know, is it 34 convictions for Trump? Even though that's a whole nother topic from the New York trial. But in any event, Young Thug doesn't have any convictions, but Young Thug doesn't have a bond. And everybody tied to the Trump case has a bond. Trump has the convictions right now, 34 felony convictions. Young Thug has 0 felony convictions. So the question is it really equal justice in Fulton County? And my argument is not that Trump shouldn't have a bond. My argument is that Young Thug should have a bond. Because Trump and Young Thug, and everybody else is presumed innocent unless and until proven guilty beyond a reasonable doubt. Oh, Car Global. Boy, y'all, we got the whole prosecutor's office today. LMAO, y'all didn't get your mistrial. Now what y'all gonna do? Who y'all gonna try and fire now? So we got Car Global, we got Law Malcolm, we got La Vida, Elise, Miss Jenkins, Vaughn, Shell. We got all these people in here. So I'm gonna have at least 3 dislikes on this video for sure. But everybody got a voice, so I'm not gonna silence y'all. But Batty QB, thank you for joining. She said her decisions have been terrible, to say the least. Jury done disconnected their phones. What's going on, Bound Facts? It ain't nothing much. We're just killing some time. We probably got about maybe 9 minutes before court comes back. So we're just killing some time. Somebody say, I'm just talking to the trolls. I'm just talking to the DA's office. Hopefully she has an ex parte meeting so y'all can keep the talking points. Oh, man. Shout out to Car Global. Car Global said, I'm gonna talk about you, but I'm gonna still send you a little change in your pocket. Thank you, Car Global. I forgot about that last time. Thank you. Somebody said, I bet some jurors are watching these motions today. I'm sure. She said, do your job, DA Love and Hilton. That's why y'all losing. Go eat some, maybe those tangerines. They saying Young Thug eating tangerines, but them tangerines got him winning. Yeah, I'm with Amy. Throw it out. Yeah, they want the, yep. Okay, Melvin may got a little sense in his head. He said, let us not lower our standards. Thank you. Melvin Rigby. I don't think I've seen you in the chat before. So thank you for popping in. And La Vida says she needs your help, Melvin. She needs some more arguments. I even say it should have been given bond. I agree. Okay, Melvin said Trump has not murdered anyone that we know about. Let's be clear. We don't. Hey, he older than all of us in here. We don't know what he did now, but I get what you mean. He's not accused of murder. But Young Thug's not accused of murder. He's not accused of murder in this indictment. I don't know if you had a chance to. You must didn't read the indictment, or maybe you jumping in at the end of the train like the new judge. Yeah, they could get. Yeah, it's a lot of different things they could have done to ensure. Bound facts, she will come back and give bond. So you don't listen to rappers? No, I don't listen to it, but that's all they do. all hear about rappers getting locked up. So you don't know about Young Thug specifically. You just saying they, any rapper. So we just gonna generalize them, throw them all in the same basket, huh? The case in New, yeah, I'm sure they're gonna throw that one out for sure. Hey, Lady Ray, thank you for joining the chat. Yeah, he's on the count one. Yeah, Young Thug is not accused of murder. Yeah, so that's what I'm saying. So, and that's what happens. Like me, people get bits and pieces, and then they jump on. So I don't think they fully informed. That's why I had to ask Melvin Rigby what he mean by charged with murder. Young Thug's not charged with murder. Knowing what you know now, is your position still the same as far as bond, Mr. Melvin? If you're still here. I'm not sure about the prosecution losing. I think the state already knows what the outcome is going to be. They just appeasing the people to make it seem like the jail is doing something different. Yeah, I don't know what you mean by what the outcome is going to be. I don't know what you mean by that part. Or do you mean like as far as the bond motions, but not the actual conclusion of the trial itself? Maybe they already know that the judge is going to deny the bond, but they don't know per se, if it's going to be a guilty verdict or not. Thank y'all to the new subscribers. Put that in the banner for a second. Thank y'all. Okay, so we have Tanya. Tanya said, I think he deserves a fair trial, but I also think his charges support no bond. He should have watched the people he associated with. Yeah, I mean, Tanya, as far as he should have watched the people he associated with, and I'm not sure how many people know, but bond is not supposed to be used as punishment. It's only used to make sure that someone shows up for trial. Now, let's say Young Thug he had a lot of felony convictions, or he was already out on bond for some felonies, and now he's accused of new felonies. Okay, that may be a different conversation because the courts have to protect the community some type of way. if you're out on bond, you should be, not doing anything to get in trouble. But if you're out on bond and you're picking up new charges, you're not what I call stand out the way, then the judges have an absolute right to think about the community, the safety of the community. But in this case, I don't see what's safe about how does the community need to be safe? Because even with the murder charge, that apparently happened in 2015 when Donovan Thomas was shot. So now all of a sudden, 9 years, 10 years later, the community needs to be safe. And to be clear, Young Thug is not charged with anything to do with that murder. And good point. Or if he jumped bail before, there's no record of him ever missing a court date. So court should be starting in about a few minutes. And we can get back to the action to see what's really going on. And some of y'all have said that y'all don't see when I go live, y'all have to catch the replay. I believe you have to turn on your notifications specifically for this channel. I believe it might be like 600. They may have the notifications on out of the few thousand. So that may be the issue. Oh, you got them all? Okay, okay. Thank you, Amy. You're probably part of that 600 crew. Somebody said, I'm sorry, but y'all are cracking me up. Yeah, they are funny. And I'm just watching. I don't know what they talking about. I just see Law Malcolm say, your mom, your mama, your mama, your father. And then y'all know what. But it looks like it's an all good fun. So I'm just... No, that's not the argument we making. Well, at least he's not charged with murder. We're not saying at least he's not charged with murder. He's not charged with murder. He never have been. And that was the argument that one of your co-conspirators, one of the people on your side was making. And he said Trump hasn't been charged with a bond. Mr. Melvin Rigby, or he said Trump hasn't been accused of murder. That's why he got a bond. Well, my argument was, well, Young Thug never was accused of murder. Let me see what the court is. Let's see. This is a definition of a diehard fan. I don't know what that means. Well, y'all be having this chat going. Johnny Shepherd said, I think they should give him a bond. Thank you, Johnny Shepherd, for writing. I'm trying to go through the comments to see some of the ones I missed. This is kind of relatively new. I believe some states are passing laws to make it where prosecutors cannot use music lyrics as evidence in the trial. Get them just out object till I'll be that long. Oh man, y'all are funny. Still thought he had a good mistrial talking point. The judge said, I understand that. Go sit down, little boy. Wal Macker said, I see Jeff getting about 15 years. I don't see it. I don't see Jeff getting convicted or Trump. I don't even know if they're going to even let her keep that other case, because the appeals court is trying to decide if she should hang on to that one. And by she, I mean Fonnie. She said still thought he was going to run to his mom and get a mistrial. And she said, and guess what? La Vida. And it still may end up in a mistrial. Now, I didn't see him jump out of his chair. You're right, Amy. You can't do nothing but laugh. You can't do nothing but laugh. Yeah. And everybody got their own sides. I mean, I think I've seen like around 4 or 5 people saying that he shouldn't get a bond. And Tanya said he should watch the company he keep. That's what Tanya said. But my thing, that's the thing about RICO. That's my thing. If the company are out there committing, crimes, charge the company. If somebody come visit me and they leave, then I need to be charged with them too. And there's nothing wrong. That's your opinion, Tanya. We all got different opinions, different backgrounds, different thought processes. So there's nothing wrong with that. We haven't seen any evidence of his brother. I don't know what you're talking about, La Vida. Has his brother took the stand yet? Or who you talking about? Whose brother? Oh, that is Ivana. Politicking with Mel. Let me see something real quick. Somebody's in the back. If y'all have a camera, so I can bring y'all up. It looks like they're making their way back in. I see love. All right, Judge watching YouTube. Which one, her or Glanville or both? Judge watching this on YouTube. Yeah, that's not gonna happen. The best thing for Thug is to fire Still and get another lawyer. Yeah, that's not gonna happen. Pika Justice said, I kind of agree with Ponytail Guy. I believe his last name is Harvey. She hasn't been here, so she is coming in, and a lot has happened that can't be undone. Yeah, I agree. She had both judges and the prosecution. All right, don't give him no idea. So you want to start charging Rico. But I think he in the West Coast. Don't go nowhere near that place if you can help it. Y'all are funny though. Y'all are funny. Somebody said, let me see if I can find that video. Somebody said Brown was dancing. I don't know if they was joking or for real. Oh, she said it's real. Yeah, we're gonna have to play that during one of our commercial breaks. He was dancing. Like, what kind of dancing? Let me see. Was it like a line dance? Bro, it's like the judge is on a bench.
The next evidentiary motion is Mr. Williams has filed a motion. And again, I don't know whether this is styled for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward, and that is concerning 801 and self-serving statements. So, Mr. Steele.
Still, that's denied too.
There's been a lot of objections. Can't change the past. I've objected to it all. Over objection, I've been prevented from trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor, is that changed with the new evidence code. And I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024, some cases, and I might have attached the cases actually to the motion. I can't remember now. Walker, W-A-L-K-E-R versus State, 306 Georgia, at page 44.
Can you give me just
Of course.
1 second? I'm
Of
sorry.
course. Okay. No apology ever, Your Honor. So Walker is W-A-L-K-E-R versus State, and it's 306 Georgia 44, specifically footnote 3. 829 Southeast 2D 121 2019 case, where our highest court wrote that and I'm quoting now, the blanket policy against self-serving statements might not have survived the passage of the Georgia New Evidence Code. Then in Jones versus State, it's 303 Georgia, 496, it's in Division 4, 813 Southeast 2D 360 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. So that's why I put that case in the motion. And then it's a good case of Hodges, which it's State actually versus Hodges, Hodges, 291-413, footnote 6, 728 Southeast 2D 582 2012. Obviously, that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, JCKSON, 780F2D, 1305, it's 7th Circuit, 1986. For over 40 years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106 and 822, or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded, even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801. You got, I'm looking, it could be 2B. I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I am not saying that there'll be issues going forward, but it like permeated this trial.
Okay, I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else.
Yeah.
We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, you know, I looked at all your case law and I've looked at the statute and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. So, I mean, that'll be my intention going forward is, to look and see, is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right,
That is the totality of that.
great. Thank you.
This is left. Can I ask a question?
Yes.
There's I don't know, I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yes.
Okay, I just want to make sure.
I don't know. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right. The state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's something that has been ruled on previously or what this one is really. Has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA action on behalf of the state. The state wanted to file that for the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay.
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
Okay.
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
Okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So Mr. Copeland wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating
So, Your Honor,
potentially?
yes, Your Honor. And I have some, let me draft these notes right here.
Okay.
Oh, no. I wanted to show these examples that I had. So, Your Honor, I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
Wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was, state, let me know what you're not playing. And
Right.
then defense counsel would bring up questions they were going to ask Mr.
Okay.
Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue. There's an individual by the name of Scooter. And it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case. And the case law and the state's motion on that is, explains all of that, I feel like, succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland
Okay.
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
Under what basis, if y'all had gotten that far, and maybe it's more fair to ask the defense.
I was
under
going to
what
say that, Your
basis,
Honor.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all right. Somebody from the defense want to let me know what they might intend to argue with regard to this type of evidence?
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends, having a good time and, just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up, that he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse because these are things that Mr. Copeland said in out-of-court statements. I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said, or Mr. Garlington's statements, alleged statements to Mr. Copeland are even admissible. But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew about Mr. Thomas as, a gang leader that may have been involved in other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stillwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals. And my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr. Thomas had a history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's
Mr.
not,
Copeland.
yeah, who is not alleged to have had by anybody, as far as I can tell from what y'all said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't know. That's not been the state's theory, and that
Okay.
has not been Mr. Stillwell's theory.
Okay.
But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be irrelevant.
Okay.
I don't want to speak for other counsel, but that's my recollection
all right.
of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are
Right.
even going to be admissible
Sure.
first.
Yeah.
But in general, Your Honor, the defense is not, we haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in the barber shop at the time of the shooting. The state's witness said that
I'm not sure what that's about.
Mr. Moss.
Okay.
Your Honor,
Yes.
I wanted to briefly, if the court would permit, I found my notes just to
Okay.
give the court some examples.
Sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about Nutt having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, I have, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who? Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief, that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence, and even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense, it still establishes it must be through reputation and opinion only. And so the state's it's a two-part motion specifically. Character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or a deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay. Well, I plan to follow 24-4, 404, and 405. That's
Thank you.
about as much as I can say about that right now until we get into specifics either. All right.
I'll wait till we get
But
up.
thank you for at least fleshing it out so I understand what we're talking about.
I can drop the link when we have a break.
All right. The state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally withheld and not timely disclosed. And I had via email asked specifically as to the authorship of this particular motion and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay.
Uh-oh.
So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell. And then the statement, quote, a defendant has a duty, underlined, to disclose prior to trial and an ongoing duty to timely disclose, in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases. Show me in either of those cases where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
She lied now.
I didn't say solely as impeachment. I said as both impeachment and as substantive evidence.
Which implies that the use of it as impeachment evidence triggers the reciprocal discovery obligation.
No, unless I wrote it inartfully. What I was saying.
Well, you wrote it inartfully.
I did then, because what I was saying was that it has to be both. That is the representation that
all right.
I made. And then when I amended it,
I didn't see an amendment.
I have a copy of the court.
Did you fix that?
What I did was.
Thank you.
She got caught.
Elaborate on it.
She got caught.
Yes, I guess you could say it was fixed.
Wow.
So you concede then that if evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
okay.
Yes, I was not saying that. I was saying.
Good to know.
My apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was.
Did you email the amendment to my chambers?
I did.
Okay.
Yesterday.
Yesterday. Okay.
Yes,
well, that may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop. Okay. It's in front of me now. So.
Lord, and got caught lying.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies, where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right. So it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay. So as long as we're all on the same page with that, and I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
yes,
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would recommend for everybody's reading pleasure, the court's exposition of that issue in the Waddell case.
And in this amendment, I did correct
All
the
right.
Waddell site.
Okay. All right, so we'll follow that law as well.
So, Your Honor,
So, yeah, and so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or
I
that
do.
exist and haven't been turned over.
Well,
Okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023.
Okay.
In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence, and further based upon information provided by Bean to the state upon information and belief. The recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand, in which that witness reportedly asserts, "We killed Nut," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that defendant Williams intends to use the recording, if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them, and we were given another set of recordings that contained some other files that maybe were missing in the first one. But the withholding, the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. Evidence. We are asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we've stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So with regard to the 3 things that you outlined specifically, you now have the recordings of witness being, is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that
edited.
And actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was the subject of any ex parte hearings or meetings with the court between counsel for multiple defendants and the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right, well, he already has been examined and cross-examined?
Yes.
Okay, and no such recording was used?
Right, they did not.
Okay, then
What's the point?
why would y'all be entitled to it?
It's just an example of something that we wouldn't, that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every aspect of a defendant's
I don't
case.
disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not,
The court is
right?
correct.
Okay, so that one doesn't
scratch it
matter.
off.
Okay. So the Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody. I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail. They were
Okay.
from a different, but we've been provided according to defendant Williams, counsel for defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there is no further issue.
Okay. That one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
And Ms. LaVon, I'll drop the link. We just can't talk while they talking. So, since I'm dropping it now, I'll wait on our next break. She say Lion Love strikes again.
May I have 1 second, Your Honor?
Sure.
Thank you.
Oh, she said Steele is great, y'all. Yeah, he is a good lawyer. You're right, Lovey. So now she team Steele. Yeah, I was trying to drop the link earlier when it was a break, or we can actually talk. But obviously, we can't talk when they over the video. The sound won't be right. Come on, Steele. Maybe he's talking to Weinstein. Come on, Still. Judge, her patience is short. She'll be like, you didn't know you was next.
This is a long second, Mr. Steele.
There you go. I knew it. I knew it. Like Steve. When Love was up there, you weren't going through these papers? Oh, man. Somebody help him. Somebody. Bro, at this point, what are you looking for? What is he looking for?
Your Honor, may I approach?
Yes.
Jiggy say this is strategy. Well,
Thank you.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
ooh,
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I hand her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United
got it.
States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is LEXIS 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor,
beautiful
on
analysis.
page 11 of 17 of the copy I've given this honorable court and the parties. And if you can turn to that page, if you don't mind.
I'm there.
On the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the 4th Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the 4th Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the 4th Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the Fourth Circuit held, encompassed both the party's case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The Fourth Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which the party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74, 889 Southeast 2D 190, 2023. And what the Honorable Judge Pipkin, which is Pipkin, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded it because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, we also agree with appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tally them, but TALON note was in fact a discovery violation, given that talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery, and we need not resolve the question or address any possible tension between, and then it gives the 2 code sections that we're dealing with, OCGA 17-16-4, little b as in Barry 1, and OCGA section 17-16-7. So if we look now, and I should have given this Honorable Court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this Honorable Court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 1716-4 in the copy I've given. And it says that the defendant within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, papers, documents, photographs, tangible objects, audio and video tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to Honorable Court and the parties.
Mhm.
And that has, if you give me 1 second, that has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel, that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with whose case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus state, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence the defense, I apologize, in the defense case in chief or rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus state. 353 Georgia Appeals 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of Guinness Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side. The first full paragraph, but counting from the bottom, 9 lines up on the right. I am quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts of other parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases, it's on page 8 of 17 of United States versus Harry, Your Honor. It's a well-written, it's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the fourth time in doing this, the state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
Thank you. So
In United States versus Waddle, which is Waddell, and it is 2016, U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go, and I'm not saying we have the same copy, so this is on I have page
maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one final point.
Mhm.
Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, that's, I think, I'm not saying that's
Right. Now I read it. Yep.
Then you're going to be in a lot of trouble or something
Right.
to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
that's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp.
What?
She told our investigator, she can call me, give me any recordings that you have of Mr. Bean. Now the investigator's skilled. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given you anything. Said, Mr. Steele's investigator's obstructing us. This is so wrong of the prosecution.
Wow.
4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. So she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her. But that I
Is there
said,
somebody on the state's case that you are able to talk to?
yeah, Ms.
Okay.
Willis.
All right.
Well, that's nasty work.
On
Go ahead.
the second page, and I'm just looking at the amendment to supplement.
She calling his
On page
investigator.
In the center of the page.
Right.
And I
Wow.
should start above, but I'll get to that if you don't mind. For another example, defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you know, you're going to have to, I don't have to give that to you. And I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth.
Tell us.
October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man.
Oh, I can't do
I
that.
said, I'm not going to do it. Judge Glanville said, you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this. And then to stand here and say, I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall.
Thank you, girl.
Did you say this? I don't recall. I don't recall. So the state got in his prior statements to Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt, I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous, outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive.
She trying to say
the legal analysis
he cut the tape.
Is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it. Because she sat here in court and I did the same thing without being tempered.
Let's go. Let's go.
That's 4 times.
Thank you for clarifying that.
You see how he pointed? This lawyer.
Yeah, when Mr. Steele clears the area.
Ah!
Yeah, go ahead, Ms. Love.
She want to respond. Say,
Do
wait
you
till-
have any Georgia law that
Nope.
represents
Nope.
what you have asserted in
No,
your
she don't.
motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and to
Which
the
I
extent that
just
it
got a
wasn't,
copy of.
yes.
Okay.
And also, I just
So
want to say that,
no Georgia law that.
right, Georgia law does not define, it does
Well,
not
sit down.
define case in chief. It does not break it
We all know
down.
what a case in chief is. Don't we? I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
No.
Your Honor, what I have said and what I maintain is that one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other two,
He
and what are they
said
going to
Vince.
represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Oh, just one second, Your Honor.
19
That's a
what?
78 case.
1978.
That's not relevant at all,
Old case.
because we have a new evidence code since 78. So, okay.
78.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance. That is,
Well, we've got a specific rule here now, don't we?
well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in
I
this
don't
motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we put that in our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia. But as there was this expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant is putting up his particular case. Right.
Okay, so do you have any case law
In Georgia,
that supports the position you took in your motion that reciprocal discovery requirements are triggered based on whether you're presenting something as substantive evidence?
No.
That's my question to you.
Your Honor, the only, what we have in support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly, that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is, in our position, a reasonable interpretation. And as we've
The judge laughing.
as we've said in our filing, Your Honor,
Yeah.
there was the requirement in Waddell
Sit down, woman.
that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell Court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position, that if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position.
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before. So
I don't mean in writing. Y'all have not had
we have
any
literally
discussion whatsoever in front of Judge Glanville about.
As I have said in my motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute.
So y'all have.
We do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. All right. Well,
It's denied now.
I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Ive.
Respectfully, I take it very seriously.
Oh, wow.
Okay, so
Y'all heard that?
anyway,
Judge
we'll
called
be
her a liar.
abiding by the discovery requirements set forth in our statutes.
Judge just
And
called her a
Mr.
liar.
Steele, thank you for the clarification.
Whoa.
All right, I think that brings us to the issue
That's
of
crazy.
when we first met, Mr. Shart had suggested that there might be, well, I don't know if it was Mr. Shart or Ms. Love, honestly, one or the other of you. We discussed the possibility that there might be outstanding discovery that maybe
That's crazy.
actually was required to be produced that either was missing or just hadn't been talked about. And I wanted us to kind of go through in detail what it is that everybody thinks maybe the other side has that they're entitled to that they haven't gotten yet. So are we in a position to be able to do that now?
She lied to the court and got caught. The judge said, remember your duty
If
of
not, we
candor.
can do it tomorrow or the next day and we can move on to, we've got other stuff to do too. Which exhibits have actually been admitted, if that's an easier one for this afternoon?
Wow. Judge said, quit lying. You need to be honest, DA Love. Remember your duty of candor to the
Which
court.
would y'all rather? We got to do them both, so I don't really care which order we take them in.
Speaking for the majority on this side of the room, we'd ask if we could take that up tomorrow.
Okay, so can we do then today? I think Mr. Steele provided as sort of as a starting point, a list or a chart or a spreadsheet or something of his understanding of what exhibits have actually been admitted. And for us to take this pause is a good time to make sure we're all on the same page about that. And I know that Ms. Weaver, the court reporter, had at least provided to me, but I don't know whether she copied y'all or not, a couple of places based on that chart where she thought she wanted some clarification, or she thought maybe it had been talked about but not actually admitted, so we can go through all of those. Do y'all have that, or do I need to get y'all that?
Your Honor, we have that. I believe that might be a rough draft. We have been keeping, a list as well. And
Okay.
we've been referencing, the recorded proceedings to ensure that we are accurately keeping note of what has been and hasn't been
All right.
admitted. As I stated earlier, there have been instances where it has been proffered that evidence has been admitted, it has been tendered.
Right.
That has not been the case. So we are still, and we would ask that the court allow us to get a little bit further along in checking all of these exhibits.
All right, so
what has really and truly been admitted.
so the question was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms. Percival,
No.
could you share that with everybody?
I don't know. Maybe not tonight. It just depends on how long we go. We're already been here 6.5 hours.
And I was hoping that we could do this today. If the state is not ready to yet, you know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we are going through each piece of evidence, and we are comparing our record
Okay.
with the actual physical piece of evidence that we have submitted or the defendant has submitted. So that endeavor is
I'm sure it's time consuming, voluminous.
and we have endeavored to make certain that it's accurate. So
Well, that'll be helpful.
Thank
We
you,
would
Eve.
want that. All right. So,
Thank you, Eve.
Ms.
OTM.
Percival will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side. I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it. And that it is difficult for the court reporter to then sort out what was that exhibit actually. And I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order
Appreciate it, 305.
filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we need—
Shout out to Miss
we
Winfrey.
actually need, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper. There's no way for the court reporter to capture sort of, I guess, a screenshot, unless y'all take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen. Okay, does everybody understand? Anybody have any questions about that? Okay. So we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on, if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. But you know, if there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue, so that we all know before we talk about it, what it is that we need to talk about. So can y'all do that this evening?
They're not going to get together and do nothing.
Thank you.
They
Okay.
do not like each other. Where don't she
All right,
understand?
very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called, or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but
Yeah.
those are everyone moving
Yeah, there
forward.
were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go then?
Yes.
Okay. And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well, we'll see. But,
Yeah, we'll see.
all right, are there any other, you know, we've got to figure out how we're going to deal with Mr. Copeland's sort of redo, but are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed in, because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer. I identified what they were, but they were noted. Essentially, I would think they're titled notices of objection. They were regarding, Your Honor may or may not know this, there was a wiretap in this case. There's, and then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some involving some with my client as a party to those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. When does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we had said at least the week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over in discovery. And I believe that we had previously said that did we say the week before? 2 weeks before we intend to use them, we would apprise defendants of which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial? And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using, and you've given me, you know, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, what is it, August 19th out. So, you know, this week might be taken up pretty much with sorting out the 2 things I just mentioned, and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't.
Uh-oh,
Whether
stay.
it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that, or do y'all understand your marching orders?
Yes, we understand what the court is asking.
All right. So, like, I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, you know, at least the next 30 witnesses worth of evidence, okay? And then maybe by the end of that week, the next 30. Okay? All right, and we're going to plan to be here all of the 19th, and I don't know when else we're taking breaks, but okay, so that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Mr. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful to say like witness Kenneth Copeland, jail calls, social media. I think you just covered that though.
Well, and, you know, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible, and ideally not while the jury's sitting there waiting on us.
That's perfect.
Okay.
We appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So Any other motions that are still needing to be addressed? And y'all, it's 3:30 and I plan for us to do work until 5:30 and we can take a little break, but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break, be back, well, it's 3:34. Be back at 3:45 and y'all think in the meantime, all right, what can we use this time productively to do? Thanks.
All right, so there we have it. Let's see something. Jiggy said, I told y'all. Yeah. Man, did y'all see that? She called Love a liar. She said, Love, you have a duty of candor to this court. You have a duty to be truthful and honest. I don't think she owned the Love's games, because in her motion, she accused Love of citing cases and saying stuff that the case did not say. That's why when you put stuff in your motion, don't put that in your motion that's not truthful, because when the judge go and read that case and she don't find what you said was there, then she's going to have a problem with you. I mean, that's basic. Why would you mislead the court, DA Love? Yeah. And I think now she over Love. And one thing about it, once a judge catch you doing something you have no business, then it's gonna be hard for them to trust you the rest of the trial. And they're gonna be watching her. If the lawyers come to the judge and say Love did something, they're gonna be like, yeah, she did it. She did it. If y'all got a camera and a mic and y'all want to come up for a few minutes, then I'll drop the link. But it'll be only for a few minutes, because once the judge come back, we can't all talk because the audio will be too convoluted. So we can only talk when the judge is not on the bench. Yeah, and if y'all have a camera so I can actually see y'all, because a lot of times you don't know who you pulling up and you don't know what they may show on the screen. So that's why I always request a camera and a mic. But we don't know what okay. Oh, okay. Hold on right quick. Okay, I think I see your camera popped on. Hold on. Hey, did you have something you want to add? Hello? I was trying to add her. Can you hear me?
Oh yeah, my mic was off.
Oh, okay, no, thank you for joining.
I didn't even mean to tap your button. I really didn't.
Oh, you didn't mean to come up.
No.
Okay, did you have anything you wanted to say while you was here?
You doing your interview? Is this a live interview for Brian Steele's apprentice?
No.
You trying to be Brian Steele's apprentice?
No.
But one question before I go: do you think the judge is doing a good job?
Oh, I recognize your voice now. Okay, what's going on? I didn't know who you was at first.
Do you think the judge is doing a good job?
She all right.
Okay, bye. Gotta go.
All right, thank you. Yeah, I didn't really like the judge with her denial of bond. Because I don't think she really took into account that they've been in there since 2021. But on the other hand, she's really not giving the state as much rope as they had at first. And she owned to Love's game. She said, "You got a duty of candor to this court." She said, "So you better quit lying." Let me see if we can find. Hold on, where is that? Let me see if this right here. Let me see.
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before, so he
I
has
don't mean
not.
in writing. Y'all have not
No,
had
we have
any
literally
discussion
not-
whatsoever
What we
in front of Judge Glanville about.
As I have
What
said in
that
my
means.
motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is stuff that we are entitled. And Mr. Steele has said no, in citing the Georgia statute. He said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms.
Your Honor,
Love.
respectfully, I take it very seriously.
Oh man, that's wild. And let's see. Let's see. And I'm gonna do a quick Google search. Some people might say, "What is candor to the court?" I'm just gonna do a Google search right quick. The responsibility of your attorney to be honest. That's pretty much it. Just tell the truth. The lawyer's obligation as an officer of the court. You can't mislead the court. Duty of candor. The rule of candor prohibits attorneys from making false statements. Y'all see what it say? And they say Love wasn't doing that. That's the translation politicking with Mel. That's what the translation is. What that song say? Why you always lying? Sit her down. Sit her down. What was wrong with her? And it wasn't just that one incident. Oh, let me make sure I hit the play button. It wasn't just that one. It was just throughout the hearing today. Certain stuff she was catching, Love and lies. She was asking Love, "Do you know what year the case came out?" Love was, let me find out. Love knew. Come to find out, the case is from 1978. But that was wild. for Love to contact Brian Steele's investigator and tell the defense investigator to hand over their evidence to her. That's crazy. See, what she tried to do was go to the investigator thinking he didn't know any better. But I'm sure as soon as the investigator hung up the phone with her, he called Brian Steele. She wouldn't even got me on the phone. You would have to, I'm gonna have to know what you're calling about first. You're gonna have to leave a voicemail, send a text message or something. Because I already know when you're calling Love, what type of time you on. I know you up to no good. But the investigator, he did the right thing. He told Brian Steele, hey, Love called me. There's been no evidence that Kayla called Steele. In fact, I believe that what we heard so far is they were outside the courthouse talking on video. So she didn't have to call him. But that still don't mean she was the person who told. And I believe at the beginning of this hearing, the judge reminded Love about her professionalism. And I believe Love took offense to that. Y'all saw how Steele pointed at her? Let's see if I can find that. That was wild. I didn't expect him to do all of that.
Scared, which I doubt. This is just me, doubt. I have no evidence. And then in the middle of that document says that Brian Steele and his investigator, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous. Outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the same thing without.
Wait, did the judge nod her head in agreement? Let's go. He said, this lawyer knows it.
Impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and
Brian ain't playing with him. He not playing with him today. Let me go back up forward. Okay. Yeah, we still on the break, y'all. We waiting for them to come back for the people that's popping in. Oh, golly, that was a fast break. Golly.
Only on one side, but not with me. But maybe I'm just coordinating. Somebody on this side of the courtroom actually has some kind of a speaking relationship with somebody.
Your Honor,
All right, attorneys, can I do that another time I say be back, okay?
Oh, she said be back.
To be back by the time that I say to be back.
Oh, she running a tight ship.
Thank you. There we go. Because I want to be efficient with y'all's time too. Okay, did anybody come up with anything else that we can be productive about today?
Oh, time to go home.
All right, what is it?
I don't think my mic works that well, so I'm going to come up here. There are, way back when, and we're looking for the filing right now.
Okay.
There's back in, I would estimate, June of 2023, maybe. There was discussion that we needed to know all the alleged co-conspirator statements that the state intended to use, as well as any and all extrinsic acts that the state intended to introduce evidence of at trial. My recollection, and I would defer to that filing, was that there was only 3 801D2E
I don't know.
co-conspirator statements.
Okay.
There was only 3 listed, and then there was also a certain number of extrinsic acts that were listed. Throughout this trial, the state has gone past that list, and that has led to much delay and litigation and sending the jury out. So I think that's something we could discuss.
Okay.
What if that is the entire list, which I submit it should be, we could discuss that. Also, there are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts
Okay.
that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
And they've called 3 at this point, is that right?
I believe that is correct. I believe
Okay.
it's 3.
So maybe explore what, if anything, the other 2 are going to add.
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay.
So that is another issue that's continuously come up in this case. Am I missing anything from our list? That was it? Okay.
Okay.
So
all
those
right.
are the
Okay.
issues that we came up with.
Thank you. All right. And if the state needs the evening to, sort out everything and make sure that you're being inclusive and answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say, give us till the morning.
Your Honor, I'd ask that the court just give me a moment. We're pulling up the.
Okay. All right. And while y'all are looking, I'm just going to make a general sort of admonition to not the parties in council, but anybody that wants to come in here to watch this case that, and I mentioned before, but I don't know, I may have to mention it a couple of different times. I don't expect there to be frequent up and down, in and out. That's distracting. So try to keep that to a minimum. There shouldn't be any talking in court other than the parties maybe whispering between the attorneys and the clients in the court. If you're watching the case in here with us, and you need to say something to somebody else, step outside to do that. There doesn't need to be any kind of, it's just distracting. There's a lot going on and there's a lot to pay attention to. And when we've got other conversations going on, it's that much harder to focus on what we and I need to be focusing on. And I also want to make clear that the deputies in here have my full authority to manage this courtroom. So if they give you an instruction, you need to abide by it, okay? And I'll probably, and I'm not talking about or to anybody specifically in here right now. Just some things I've noticed so far. And I, again, will probably make that announcement a couple of different times in the upcoming weeks so that everybody is clear on what the expectations are. Yeah. To whom should you what? Send it? Ms. Percival.
Your Honor, to the extent that the court's question was specifically, have we noticed the defense of the evidence of intrinsic acts? Is that the question of the court?
Well, no, I mean, maybe it wasn't very artfully formed, but to the extent you can, to the extent you know, and hopefully you know since you're in the middle of your case, I would like for you to make sure that you have given the defense notice of whatever co-conspirator statements you intend to use, and then separately, whatever extrinsic acts you intend to prove.
Okay.
Okay. And if you want to do that now, that's fine. Otherwise, that's something we can go over in detail tomorrow.
Judge, I'm looking at simply, I'll start with just the intrinsic acts, and I'm looking at 51 of them. I'm not sure about the 3 that were referenced, but within the intrinsic act notice that we filed on November the 6th of 2023,
okay,
we made specific references to 51. And we also said acts contained within this non-exhaustive list. We referenced that the list was non-exhaustive, and we noticed the defense of the state's intent to introduce evidence of these particular acts. If the court will permit me one moment, I just wanted to call the court's attention to the November 6th.
Okay, so given that you noticed 51 but said it was non-exhaustive, that sounds like there might be others. So at this point, can you make the list exhaustive?
Yes.
Okay. And then the 3 was co-conspirator statements. Well, we don't need to take court time now. How about you can you have tomorrow, by tomorrow, what all the co-conspirator statements are going to be? And then how much time do you need to make the other list exhaustive?
So Judge, what we're discussing is the number of co-conspirator statements that may be contained within the jail calls that we are also, jail calls and the wiretap calls that we are intending to introduce. And so to the extent that we reference simply what we filed, we can present that, but we would ask the court to allow us to address on the week that the jurors are out. The 19th?
So if it's anything with Mr. Copeland, that needs to get dealt with this week.
So with respect to Mr. Copeland.
Sure. Go ahead.
Okay, Your Honor. With respect to Kenneth Copeland, will the court permit the state to address in its entirety tomorrow the ones that we are intending to introduce? As we are discussing, those statements are contained within the videotape interviews and jail calls that we have intended to introduce and have noticed defendants of our intent to introduce. So in terms of what the specific statements are, I think we would best be.
Okay, so does everybody from the defense understand, at least with regard to Mr. Copeland, maybe not in detail, but what the universe of potential statements is for Mr. Copeland? I mean, y'all had gone through a lot of this and hashed it out once already, and you might not have gotten through everything, but y'all had done various statements and gone through in detail on what was in and what was out. And I know we might have to do that over again, and then there are jail calls that y'all had not reached yet, but I think the state had represented, there were 5 or 6 of them, and y'all know which ones they are. So that y'all all know, right?
So we know about the jail calls.
Okay.
That assuming that the state's not expanding that list.
They're not going to be expanding that list, are you?
And
Not the jail calls of Mr. Copeland, no.
Okay.
and when they say noticed of things that are in statement or past statements, I am aware that I'm not aware of any co-conspirator statements by Mr. Copeland I'm aware of the Garlington to Copeland
Right.
statement,
Yeah.
but
From Mr. Copeland himself.
I don't, when they say they've noticed us on statements by Copeland that are in his statement, in his prior statements, I don't know what that means specifically.
Okay. So are y'all including within that, like, here's what Garlington told me?
Yes.
Okay. So, all right. So that y'all do have, and how many of those are there?
How many statements of Garlington to?
How many co-conspirator statements from any alleged co-conspirator are there that y'all are going to be introducing through Mr. Copeland? Or potentially introducing through Mr. Copeland?
At least 3 co-conspirator statements, 2 from Garlington that is contained within the June 10th interview. And then there's a jail call with Mr. Copeland and other unindicted co-conspirators as well.
Okay. So defense.
If there's more, we can correct that tomorrow, but.
Okay.
I'm thinking of-
All right, so take a look at it tonight and make sure. Okay. And then with regard to the other acts, do you want me to I think it would be a good idea to have a deadline for giving the exhaustive list over. So do y'all want to make a suggestion as to how long y'all need to do that?
Just 1 second, Your Honor. Monday, Your Honor, is that?
That's great. Yes, that'll work. So that'll be Monday, August 5th.
For the intrinsic act.
Yes. Okay. Moving on to discovery reports of state's experts. Did you know specifically which reports or which experts you feel like you're missing reports from? Okay.
Your Honor, I just asked my coworker that I'm privileged to work with to email to your Honorable Court's coworker and everyone else the November 17, 2023 written order on this topic. And I don't know if this court has seen it, because and if you want the court reporter to be emailed out, I didn't do that either. Apologize. But we had a hearing on this on or about August 21, 2023. Opening statements were approximately November 27, 2023. And we have no reports of any gang expert. We got a PowerPoint the day of testimony from the first witness, is my memory, but if I'm wrong, I apologize and please correct me. And that PowerPoint had to be gone through and had to be excised. His name is Detective Belknap, which is B-E-L-K-N-A-P. Then Detective Dennis testified. He was allowed over strenuous objection to say that we did this work and we spoke with witnesses and we spoke with victims and we spoke with co-conspirators and we spoke with people who identify themselves as a gang member in IF or a gang member in YSL. And based upon that, we know that the following crimes occurred, and here's some 911 calls. I don't know who these people are. We have no background. That's a in my opinion, that's a confrontation clause violation because it's the police officer doing the work. We never got any reports. When I've asked for the reports, I was told that that's under lock and key by the City of Atlanta Police Department. And he, meaning Detective Dennis, no longer works there and cannot get, they have a gang book. He described it as a gang book, but they can't get it. Detective Belknap said he cannot get access to give out that gang book. So we're basically in the dark and we're hitting as best we can, but this is all over objection. I have no idea how to challenge. Like you heard earlier today, there's a lot of information for the court, but you heard earlier today that, God forbid, it's at 7:22 p.m. The 911 call goes out and Mr. Donovan Thomas is shot. He's killed. It's on video. It's bad. It's a drive-by shooting. He gets shot. Multiple gunfire. 2 other people shot as well, but thankfully not fatally. Within the next several hours, so it's 7:22, so within 5 hours, Mr. Copeland says that abodes that are close to his family members, and you heard a representation that Mr. Williams, they said stepfather's home was shot. I have no idea who shot that stepfather's home. I have no idea who to speak with about it. There's a 911 call about it. I'm not conceding that it was done by a gang member. That's why it's impossible to cross-examine. The next witness who is deemed an expert by Judge Glanville is a detective Gaither, which is Gaither. And she testified as well. I didn't make a report, but she goes into, I spoke with people, they're unnamed people. It's the same thing. I would like to know who these people are because I'd like to talk with them. Because if they say, no, I never said that, that's important for the jury to make credibility determinations. That has all been kept away from us. Judge Glanville ordered the state, and it's just, it's easy to read the order, but I wrote the order after the argument, but he signed it. In order to permit a meaningful opportunity to cross-examine, all expert notes, reports, documents, statements, basis of opinion are required to be disclosed by each expert for the prosecution as to the underlying facts or data so cross-examination can properly, lawfully, and constitutionally occur. That's right out of the case of Harris, Harris versus State, which is 314 Georgia 238. It's in Division 6A, is in Elisa 875 Southeast 2D 659 2022 case, where our Supreme Court said that is not the rule in Georgia, but we encourage trial judges who can control the proceedings to order that to be done, and Judge Glanville ordered it. The state never gave us those witnesses. Then you have Detective Belknap talking about, well, at APD, meaning Atlanta Police Department, we have six criteria that we designate someone a criminal street gang member and a criminal street gang. Then you have Detective Dennis. He gave those same policy requirements. Then you have Detective Gaither. She gave the same ones.
Mm-hmm.
It is my understanding that the next two, which is Detective Underwood, which is UNDERWOOD, and she's going to testify, I assume. I don't know because I have no reports. Similar policy. And then you have Investigator Viverito, which is VIVERITO, also with the City of Atlanta Gang Division of their policy. All of this is cumulative. All of this, I have zero, none of us has any type of documentation. And the way I understand the rules, an expert, yes, they can rely on hearsay, they can rely on the opinions of others. I understand that. But when asked and when you testify, you can challenge those opinions and those statements. So you have to know who said them to you, and all that has been kept from us. So that is, I filed a subsequent motion that it's cumulative, that how many experts you need. Judge Glanville said, it may be getting cumulative, but he did not rule that way. But he said this could be getting cumulative, but he allowed the next expert to testify, which was Detective Gaither. And then I don't know how we have no reports when there's a written order. We have zero on it. It's hard when the expert is just saying, or the witness is just saying, well, I do this, I'm on the street, I know these people. Brian Steele, you don't know how streets work. And I go out and this is how I get information. People will talk to me because they know that I won't put it in a report. Well, that makes it pretty hard to say, well, I don't think the jurors should just rely on your word. I'd like to know who that witness was. Well, I'm not able to tell you. I don't want to tell you. I can't tell you because I left the office. That's the issue I'd like you to address.
Okay, well, I mean, I understand the frustration. If there is no report, there is no report. But what was the date of the order that Judge Glanville issued that you referenced?
It is, and it was emailed to your honorable court's coworker
thank you.
at 11, which is November 17, 2023.
Okay, 24,
No.
23, 22,
23.
23. Okay.
Thank you.
All right. And that's, unless I specifically change what's been directed in an order, all of the orders that have been issued continue to apply. So I'll expect the state to abide by the requirements of that order. And we'll have to address whether the other experts might be cumulative. Besides these gang experts, are there other experts who you believe there should be reports for that you don't have?
My knowledge,
Unless my mind is not working, I believe I have reports on everyone else.
Okay.
That's-
Anybody else?
That's my, if I misspoke, but that's my understanding.
For any of the other defendants, anybody believe there are other outstanding expert reports that you don't have? Hearing silence, I assume it's just those. Okay.
Your Honor,
Yes,
may I briefly address the court related to this matter?
you may. And one thing before you start, I want to ask, and I could be entirely wrong, but with regard to the experts that are being recalled, I would assume y'all are trying to present your case kind of in some semblance of order. So it may be that right now they're testifying as to ABC count and later they'll testify to XYZ count.
Correct, Your Honor.
Okay.
There's some witnesses who were fact witnesses, so to speak.
Okay.
For a specific part of the investigation. And then they also will testify down the road about another.
Okay. All right. Is that all? Yeah, go ahead. And if there was something else you wanted to say, yes.
Your Honor, just briefly, I wanted to kind of orient that as different gang experts that the state have called to the stand, this argument has been addressed or raised to Judge Glanville. And part of it is gang experts, unlike GBI experts on blood or touch DNA, the police reports that the state has related to the underlying crimes. This is obviously a crimes that span a decade. So the gang detectives, specifically Detective Gaither, Detective Dennis, they worked, I think, approximately 26 retaliatory shootings after the January 10th murder of Donna Thomas. So they worked as the lead detectives. For example, we have put evidence, you've heard about D'Angelo White. That was a shooting, attempted murder that happened that Detective Gaither and Dennis picked up after essentially an aggravated assault detective within APD had it, because they're gang detectives. So when they talk about, they don't have, as you would have in, say, a scientific report like a 50-page treatise of the Young Slime Life Street Gang. They have worked these crimes, and their reports or warrants that the state has have been turned over. And so the basis that they state their opinions to the, they speak it's from working the case, it's from talking to people. So
they're
that's
experts based on their experience.
yes, Your Honor. And part of the issue arises is the reports that the defense is requesting, they do not have. And so, for example, I believe it was Detective Gaither and or Dennis, they mentioned, they know they are retired from APD. So when you ask them, well, do you have some other additional reports? They say all the reports I made, were in my file. So the state is not aware of any reports from these gang experts that we have that has not been turned over. The state believes that those kind of four corners from this decade of acts in the case don't exist, of like Detective Gaither or Dennis didn't write some large report in total.
Okay. Has the state asked, not the individual detectives who have since retired, but APD? Do we have all of the reports relevant to this case?
Yes, Your Honor, and I will defer to my co-counsel because I came on this case in December, but my understanding is that that has been Chief Deputy Love or Hilton, correct me if I'm wrong, to the court.
Yes, Your Honor, the reports, this is an issue that has been addressed multiple times after the order was entered. Every time that we address either Gaither, Dennis, or Belknap, the issue is raised that there is an absence of a report. Judge Glanville, the court can search the transcript for this. Judge Glanville has addressed repeatedly Mr. Steele's motions and his assertions regarding their lack of a report from various experts. I'd ask that the court review that portion. You do a search for the word expert or report.
I'm not going to do that. Sorry.
No, I don't have any problem with that, Your Honor. My point only is that we've addressed
Got
that.
enough to read.
We've
Searching
addressed
for
that issue
expert.
multiple times.
Okay.
And Judge Glanville has ruled on Defendant Williams' repeated motions for a report of detectives Gaither, Dennis, Belknap, our gang experts. Judge Glanville has ruled on that even after the order that was entered. So I don't believe at this point that there is any further ruling unless the court wishes to reconsider the rulings that Judge Glanville has previously made. I don't believe that there is any further matters to be ruled on as they relate to expert reports and the gang experts that the state has identified for the defense.
All right, just make sure that you have abided by and continue to abide by the order issued on November 17th, granting the motion for complete witness list and expert reports and analysis and findings, okay?
Your Honor, may I respond to that briefly?
Yes.
And I was going to provide one case to the court.
So,
Either before or after.
okay, all right,
Mr.
yeah,
Sharp.
no, we'll let Mr. Atkins
Thank you.
finish. Let me, and Mr. Steele quoted it for us, but what the order says is all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person accused instanter, which means immediately. So the way I read that, that means even though this goes beyond what our discovery statutes might require, this order is what controls. And so even if there is not a written report, you need to give to the defense any findings that these experts have made and the basis for those findings. Okay, just make sure y'all understand that.
Yes,
All
Your
right.
Honor.
Okay, go ahead.
The case, and I apologize, but it's Hassan v. State, which is a March 19th, 2024 Supreme Court of Georgia, Hassan v. State. The version I pulled up is from when it was just pronounced, so it has
What's the
site.
S24 number?
It is, Your Honor. So I need to pull up another version. I have the version I saved when it first got published. So I have a 2024 Georgia Lexus 7.4.
Well, that'll work. 2024 Georgia Lexus
7.4, and then it gives a Westlaw.
7.4?
Yes, Your Honor.
All right, I don't use Whistle.
But what I wanted
I
to,
used to, I just don't anymore.
I've only used primarily Lexus, Your Honor.
All right.
What has came up briefly in defense counsel argument, but gets brought up is this case is important because it discusses when, for example, gang detectives are speaking about. Typically, experts can talk about or rely on hearsay to make their expert opinion. So when you have gang investigators who have spoken, talked with a number of people, part of their response or expert opinion on XYZ is based on years of experience. And so this case has an important holding in relation to specifically, neither witness expressly repeated the out-of-court statements of any other person, although the detective testified that he was familiar with the Ramsey investigation, which was some other investigation he was talking about, and referred to speaking with another detective who worked on it. He did not specifically state what the other detective told him or how he developed his familiarity. So it was not obvious that the evidence was hearsay, such that the trial court should have sua sponte excluded it. And this was a gang case where, kind of like how Detective Gaither, Dennis, and then Detective Viverito down the road, they reached their conclusions. And so if they are not directly deriving what their statement is from hearsay, as an expert, this case is helpful to illustrate in the context of a gang expert, how that can come up. So I just wanted to share that, Your Honor.
Appreciate it.
Thank you. Thank you, Mr. Sharp.
Okay.
So, Your Honor,
Yes.
I don't want to be taken as crying over spilled milk, but I'm really just trying to bring things to your attention. Miss Love referenced in kind of, I feel like I was the one that was making the most noise about the reports, especially investigators' reports. And the reason I was doing that, and we're not talking about expert testimony right now, reports by an expert. These experts were also testifying as fact witnesses.
Right.
And there were several times, it was Investigator Gaither, and I believe it was Investigator Dennis. I could be wrong on that, but it was definitely Investigator Gaither and another investigator. I think it was Dennis. And they testified to doing things in these cases. And we're looking at a lack of reports indicating that these tasks were done, showing photo lineups to certain people, interviewing witnesses. And I complained about that. And I said, well, where are the reports? Because at first I was, in cross-examination, well, wouldn't that have been something you would write a report about? And they said, well, we did write the reports. And so we met out in that side room with Investigator Gaither, but I believe Investigator Dennis, we also talked to him, and they insisted that they wrote reports about this work. And it is correct when they said, when we left, we're retired, we cannot access the reports, but we left them with APD.
Okay.
The state has stated that they don't have these reports.
All right, that should not be happening. We'll take that back up when she comes back in here, whoever she is.
The state has stated repeatedly that they don't have the reports, and I think all of us are left in this quandary where the state's saying they don't have reports, but the witnesses are saying we wrote reports. And
Okay, do you have dates for any of that? Or have you previously discussed with counsel for the state
well, when I brought this up to,
what you think is missing?
yes, well, unfortunately, those witnesses have already testified. So of course I would like the reports, but going forward, and the part of my frustration is when the state says we don't have reports, and the witnesses are swearing there's reports,
Right.
So we can't really nail the witnesses on it, and the state's saying, well, we can't hand anything over either. Then we talk about it, and the court at the time just kind of said, well, there was a hack in 2018. And
That's actually what I was literally about to say, is it's possible that for some of these things, I mean, we all remember, we were all around in 2018, the city of Atlanta there was some huge cyber attack, and lots of things got disappeared from everywhere, wiped out. So if that is the excuse for some of it, it's probably legit.
well, I'm
Yeah,
not
it's
saying
gonna
it is
depend on
or
the
isn't
dates.
legit. I'm not saying it is or isn't
Right.
legit, but
I'm happy to bore down on it some more and talk
Because-
specifics.
I mean, it wasn't even, I can't recall if that was even suggested by the state, but that was just thrown out there. Well, reports are missing because of the hack. And I'm like, well, how do
I'm
we know that?
happy, yeah. If you want to get together a list, and I mean, maybe more so for the witnesses going forward, and these, we're at this point not really talking about expert reports, we're talking about police reports, fact basis that ought to be out there. And if you want to in detail get that, because that is frustrating for everybody. I mean, yeah, it's out there. You wrote it down. So unless it disappeared in the cyber attack, it ought to still be able to be gotten, even if not by that witness, because that witness is retired, by the state, because the police and law enforcement are a part of the state. And so it is within the control, if not the custody of the state. So I'm happy for us to bear down and bore down and drill down some more on that. If y'all want to give me specifics, or if you want to, well, give both to me and share with the state specifics, because that will help them as well, to not just say, hey, APD, please give me everything about this case. But there should be a report from Detective Gaither dated August 2nd, 2000, about a lineup she did. And then they can actually search for something. So let's, to the extent y'all want that, and you're certainly entitled to it, let's get details together so that we can give that to the state, so they can give that to APD, and we can actually hopefully find something if there is something out there but missing.
Yes, Sean. Thank
Okay.
you.
All right. Yes.
We
Yes.
turned over to defense. Every report from 2015, every report that the experts have referred to or will testify about, and the complete case files that exist for each of those reports.
Okay.
So we've turned that over. If I will await defense giving to us what they now posit they don't have,
Okay.
that we have not already addressed.
Okay.
And Your Honor, I am asking the court to refer to Hassan versus the state, 318 Georgia 673. It's a 2024 case that that's the full citation of the case that
Okay.
Mr. Atkins just.
Oh, perfect. Thank you.
Your Honor, I mean, with all due respect to everyone here, that's a bit disingenuous
I think
because
is your mic on?
I'm turning it on.
Maybe we need to take a look at that and see if it's still working.
With respect to everyone here, that's a bit disingenuous to say, well, we're raising this for the first time. We had the issue in court with Investigator Gaither. The state is very aware of what those reports are. I'm not saying I know all the answers here. All I'm saying on those previous occasions, there wasn't, in my estimation, from my vantage point, there wasn't a lot of effort, and it was just blame the hack.
Okay,
And-
well, thank you.
Yeah.
And I don't want to keep going back and forth with blame or bashing. I want us to be productive and talk detail so that we can make things happen. So thank you. All right, what else? If anything, that we can deal with today? It's okay to say that's about it for today because I've got some homework anyway. All right, so we will adjourn for the day and we will see everybody's smiling faces at 8:45 tomorrow morning. Thank y'all.
Your Honor, before the court.
Oh, yep, there's one more thing for me too. Go ahead.
There is a scheduling matter that we would like to address with the court.
Okay,
With a member of the bench at the bench.
okay, come on up. And I guess one person from each team. Earbuds and what have you over here that I have never used before. And if we're going to be using those during the trial, I would like a little bit of practice on them before we get in front of the jury. So maybe, the next day we end at 4:30. Y'all remind me and let's all figure out how those work because I don't know yet. All right. Are you just going to be representative of everyone?
Yes.
Sounds good.
Somebody say, what a report said. That's what we want to know. What a report said. And then somebody is Fonnie Willis. Where the money at? Where the money at, Fonnie? Where the money? Somebody tell her to look under her mattress, under her boyfriend's mattress. We need that money back to the county. That's what we want to know.
The state, due to a scheduling matter, may want to, whenever we do pick back up with the jury, which hopefully will be soon, but I'm not sure yet what all we're going to get finished with this week. If we bring the jury back next week, there is a request for the court to consider having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland. Now, we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're going to have to come up with whatever we're going to say with regard to, you may be hearing a lot of this again, and you're going to need to disregard what you heard before. We'll have to work on that, and y'all be thinking about that. That's y'all's homework. But is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not.
We're not going to be jumping around. Let's close them out.
There's an objection to going back and telling the jury anything about disregarding Mr. Copeland and having to do it all over again. It's impossible.
Right, that's crazy.
There's no way in the world.
All right, well,
The jury
yeah.
just disregard Mr. Copeland.
Okay, but that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand. But that aside, just with regard to scheduling, assuming we are going to go forward for the purposes of this discussion, and assuming that, I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony, well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Yeah, I object to that.
Yes.
Keith Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. And I don't purport to speak for anyone else. We do object to that. We believe that given the complexity of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to going to another witness.
All right, I appreciate it. And I think with that objection, you know, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will pick back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
No,
no. Considering that we're going to have to.
You got to do it.
Well,
you can't do that.
As I understand it, there are a couple of days of, and I don't know whether y'all got testimony out of him or not, or if it was just a discussion of whether he was going to plead the fifth or all of that. If there was there testimony from Mr. Copeland prior to the motion to recuse on the 12th?
Yes, Your Honor.
Okay. All right. Considering that Ms. Hilton handled that testimony, and we don't normally switch attorneys mid-witness,
Exactly.
there is now a request on the floor to do just that, to switch
Make us suffer.
attorneys mid-witness.
Nope.
We're switching judges anyway, and we're redoing some things, so it's a little out of the ordinary anyway, but if there are objections to that, I will entertain those.
Make us suffer. Somebody object, please.
Yes.
I would hope that that's not as of tomorrow when you rule on qualification, so that Ms. Hilton can go wherever she would like to go. As far as I'm concerned, we will not call her for several months. Who's the witness that would be substitute? I heard what Ms.
I don't know. Do y'all have another witness in mind?
What is the hiatus? Is it a week?
I don't know that either.
Will be 1 week, Your Honor, will be my absence, will be 1 week. Your Honor, we do have several witnesses. It would be the state's intent to potentially just go in order of who we have kind of listed. So we wouldn't be calling anyone from the bottom of our witness list, but it would be someone within the same acts that we're.
So you just essentially skip over him and go to the next witness on your list and then come back to him.
Yeah.
Oh, she gotta go.
I've already entertained an objection to that and said, no, you can't do that. So the question on the floor at this point then is if we're continuing with Mr. Copeland and not picking up with another witness in the middle, is there an objection to another prosecutor handling the remainder of his testimony and whatever needs to get redone?
She gotta go out of town. I guess if she gotta go out of town, I mean, she gonna be gone a whole week? Where you going?
We just have a movie.
Sure.
Hey, y'all heard what Brian said? He said, well, if you disqualify her and Lawyer Love, she can go wherever she want to go. He said, if you disqualify them tomorrow, she can go wherever she want to go. She ain't got to question the witness. But it's going to be a tough situation now because if Hilton got to be out of town for a week, but they want Woody to go next, then that could potentially stall a trial another week or two. So I'm like, at this point, she got to be out of town if it's an important reason or if she got a medical emergency or some surgery or something, then just let somebody else do it. There's no sense in delaying the trial. But if she gonna be there and she just gonna sit at the table and let somebody else do it, no, I object to that. She already know Woody gonna get right on her. He gonna get right with her. Brown, you gonna do it? Look at Brown. Y'all think he gonna take it up? Woody show will get on him. Man.
Speaking only for Mr. Kendrick. Mr. Kendrick objects.
Okay. And on what basis? Because you want to make it difficult for the state.
No,
right.
It's fair.
Well, no, Your Honor. This whole thing is messed up.
All right.
We've got to redo this witness. We
All right.
can't redo the witness.
Okay.
I don't even want to get started. So switching out the questioning attorney
All right.
is just even more complicated.
Okay. So
That is crazy.
let me take that part of this under consideration.
I've never seen that happen.
All right.
You just can't be
Okay.
switching
So the
lawyers.
other thing that I had
Your Honor.
is I
Your Honor.
asked.
Judge,
Yes.
I'm sorry.
yes.
I'm sorry. Didn't speak
Oh, I'm
quick-
sorry.
No, that's
Did you-
okay. I didn't speak quickly enough, or my microphone didn't come on quickly enough.
We'll blame it on that.
Yeah, it's the microphone. Just to be clear, on behalf of Mr. Williams, we don't have an objection.
Okay.
Okay. see?
And I don't believe, I'll let everyone else speak for themselves, but I don't believe there are any other objections back here.
Other than the one already voiced by Mr. Harvey.
All right, so that's just us.
Okay.
I object to Mr. Adams making me look bad.
Okay, well, so noted.
All
All right.
It's-
Well, I'll think about that one. Okay, so there had been Miss Love put on the record this morning that she had made the request for the Monday morning meeting. That was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything. Okay. So if y'all all want to come up here and get a copy from Ms. Persfield, after that, we will be in recess for the day. Thank you.
All right. This is insanity. This is absolute insanity. Hold on. All right, there we go. I think they're so there we have it. What y'all think? I'm gonna drop the link. If y'all have a camera and a mic, feel free to join it and express your comments. And they don't have to align with my views. Y'all might have a different opinion than me. That's fine.
Relates to the ex parte.
Yeah.
I could be wrong about this, but I'm asking my colleagues, and no one has the written motion for immunity for Mr. Copeland.
Okay, I think that probably got filed ex parte, but is there any objection at this point in time in the defense having that as well?
No, Your Honor. Not
Okay.
the defense.
I thought I seen that already.
No objection to the defense.
Okay, so I'll email y'all if that's okay, because I don't have hard copies of that available. A copy of that. Do y'all have the order?
We have the order.
Okay, yeah, I'll make sure y'all have a copy of the motion. Okay. Third time's a charm. We're in recess. Okay.
Thank you, Your Honor.
Thank y'all.
Well, hey, how's it going?
What's up? Oh, what's up there? Talk that law.
I can't call it. Thank you.
Man, look, what's up there? Talk that law. Hold on, talk that law. Hold on.
All right, I'm gonna just mute your mic while you get that other one closed out. Oh, you got it? Okay.
Hey, listen, this is my question is, I'm trying to figure out why is it that they holding up the court with all the stuff that she know that is wrong. She know it's wrong. Why is they holding it up? Did she see that that was previously trying to stop her from putting Woody on the stand and go to somebody else? How do they do that? They know what Woody finna do. That's what I'm thinking, talk that low. I feel like they know what Woody finna do.
I mean, it's strange, and I mean, they have a point to object to that. How are you going to skip Woody and put him down at the back burner and then bring him back? I mean, it's going to be too confusing as it is.
Man, talk that law. I'm a 5-time convicted felon. I've been to trial 3 times, right? For capital offenses. And I can't understand. I've never seen this here. Never seen this here. I mean, I've been in the courts all my life, and I've never seen this done before. Never.
And I wonder, maybe they perhaps are trying to silence Woody, because they know as long as he's a witness, he really can't say too much.
Listen,
But
Woody's going to destroy it. Woody's going to destroy the whole case.
Once he's done testifying, then he'll be free to talk openly.
Right.
I don't know if they're trying to tie him up or what the case may be, but the lawyers had a good point. It don't make no sense to skip him and then come back to him. And then on top of that, they're going to change the lawyer that was questioning him. So it'll be a new lawyer, a new witness, and a new judge when the jury gets back. That's going to be too much.
That's crazy, man. That is so weird, man.
Right. Yeah, that's
You got a bunch of guys that's sitting in there don't even have felons. If you take a look back, I seen a guy just get a $50,000 bond in Mississippi. Come to Florida, just got arrested the other day for another murder.
Oh,
in a Julio case. So come on now. This man is a multi-millionaire, ain't never been convicted of a felon in his life. And everything that they have presented to the courts has nothing to do with Young Thug.
Right. Yeah, they haven't implicated anything.
Make it make sense. Make it make sense for me, talk that long. I'm gonna get off the line so somebody else can come up, man. But I want you to know, man, on the real talk, man, I appreciate you, man. You and Miss Sylvia, shout out to Miss Sylvia, shout out to Sid, shout out to what's the little red lady just came on, AB to the 7. Shout out to all them people, man. But hey man, keep doing what you're doing, man. You know what I'm saying? I'm here to support you every chance I get, man.
You got on here earlier. You was early today.
First one. Yeah,
Appreciate
first one, man. Hey man, I'm waiting on you to put that thing up where we could be officially. Official.
All right. What
Yeah,
you
man,
mean?
come on, man. Cause you real, man. Now I see other people on blogging doing their thing, but let me tell you something. You know, now you ain't ask for nan dime. You ain't trying to get nothing. You just, you let it do what it do. You understand what I'm saying? That's love, man, for the people. You know what I'm saying? That's love for the people. I don't see nobody throwing no cash apps up there, which they should. I know I am, but they should throw at least a couple dollars or something. You know what I'm saying? To keep the channel going. But that
every once in a while, people do support. They ask, they do.
Hey, is you cool with that dude out of Atlanta? That other lawyer that we wearing the blue suit all the time?
The other lawyer that wearing the blue suit.
Be on live with AB to the 7.
Oh yeah, AB to the 7. Are you talking about the lead attorney?
Yeah, man.
Well, I've never been on his channel before. As far as the guest.
I ain't trying to get to the man. Do he ever change the suit though?
Oh, you know what? I don't know.
Is he a crip? Is he a crip? Because he always got blue on.
Some custom made suits over there.
Hey man, but blue. Hey man, everything in that.
Oh my God.
Everything in his house must be blue.
I don't know. You know what? I'm gonna have to see if I can find out. I'm gonna have to find out through AB.
Hey, tell Nisha to come on up, man. Y'all let Nisha come on up. I want to hear what she got to say. Nisha, come on up. I'm gonna get on up. Talk that law. Let Nisha come on up.
I appreciate you.
I appreciate you, man. Nothing but love.
Thank you again, 305, for popping in the chat and on the screen. You never know what you might get on these live streams. I'll tell you, you never know what. You never know. Oh man. Oh, thank you. Thank you so much, Slick So Famous TV. This just to get OG. You know what? Y'all are funny. What are y'all even talking about? Oh, let's see. I think we got Tasha up here. Shout out to the lead attorney, him and AB. Every time I get a chance, I'll try to stop by their channel and support. But I'll be over here so much, I haven't got a chance to stop by there in a while. And when I first started off, the lead and AB was supported. What's going on? Simply Todd.
I just came up here to be petty. First off, we do not shout out other channels. I'm just joking.
Hey, I'll tell you what, but they do the same. They do the same over there.
I'm just joking, y'all.
I do not got no beef with them in Georgia. Now I do have beef with their court system in Fulton County.
Now I have a question for 305 OG. Now, he said he been in court all his life and capital offenses. What you been doing? Because I'm confused.
305, come back up if you can.
305 said he done been in jail all his life.
I think he said he said 5 felonies and he been to trial 3 times.
On capital offenses. I need to know the charges. So if you here, come back so we can talk about this.
What's going on, Rob? For real, thank you for supporting. Let's see. So, how do they think it's a fair trial when they? Who even knows? We don't even know what. Even the judge is like, at the end, she was like, "Okay, this is a new judge. Everything's kind of already out of whack. You might as well let a new lawyer question Woody. Why not? We breaking all the rules anyway." Oh man. Okay, look at it. She said, I heard him shout you out a few times.
She heard who shout you out?
She's talking about
the lead.
Leading AB.
Oh.
I think AB stopped by a few times and supported the channel. And we try to do that back and forth since we're all like in the same space. They just got more years in the game. I'm still learning all the ropes, the YouTube ropes.
So I mean, I just came up here, just to get some questions to answer. But the day was it was pretty interesting. I think it kept us on our toes. I'm mad she denied some of the motions. But I'm glad that she put love in her place a lot to where she knows that she can't mess with her.
Man, I think so too. I think that because throughout the day, she was noticing that Love got a character trait for untruthfulness. Even in her motions, she was like, okay, you cited 2 cases, and the judge said I had sent an email to whoever wrote this case. I wanted them in court, and then DA Love said, I wrote the motion. The judge said, okay, well, the stuff you put in here is simply not true.
So do you think she actually wrote that motion?
I think so.
I believe Fannie wrote it.
You think so?
I believe Fannie wrote it. Yeah, because Love couldn't even cite some of the stuff that was in that motion.
That's probably why she was struggling to try to.
There was no way she wrote that motion to not be able to argue it effectively to know what she said in that motion. Because when you're handling something like that, you don't easily like mischaracterize case law. Not necessarily saying that they don't, but when you're arguing a case law, you're gonna know the point at which you're arguing it and what it represents for. Not saying I meant to say it this way.
That makes sense. I mean, because if you're writing it, then you're reading it. So
that's like you writing the paper and you don't know the substance of the paper. It doesn't make any sense.
So, and I was kind of thinking that And then I was thinking that she was nervous because she was caught. So now she's fumbling and bumbling because she know, okay, the judge actually read the case law that I cited. And she probably got used to Glenn, but not actually reading it. But, you know, when you are dealing with a judge that's detailed, she said, I read both of these cases. And in both of these cases, I didn't see anything that you cited. And that's bad business if you're any type of lawyer. I mean, sometimes you're going to have cases out there that don't support your position. And it's always best to list those cases. Yes, there's a case that says this. However, my case is distinguished from that case because the facts in my case are different. Oh, thank you, 305, for the super sticker. That is kind of you. Definitely appreciate it. She said she had a question for you. If you had a chance to come back up, 305.
I definitely got a question for you because we need to know what the capital charges were that you were charged with.
He said, I'm a chat sponsor right now. What that mean?
That's you saying $4.99 and he only said $3.
I got you. You doing that's play on the lead, the chat, the sponsor. Come on. He said that nice blue suit coat is part of the lead attorney set, my man. Yeah, that's his signature. Yeah. Hey, talk that law, chat. Peace and blessings. What's going on, Ken Goddess? Thank you for joining. Appreciate you popping in to support. He 305 said he gone. You didn't he gone.
I mean, you got up here and outed yourself to the world. Now we curious and we want to know what's going on. Now you want to run, but it's okay. I was just asking.
He might have had to go for the day. I don't know.
Don't try and cover for him. We don't.
He probably have to go.
I'm not accepting any proffers from Talk That Law on his behalf. Okay.
It seemed like he was waiting. He was waiting on you to come, and then when you came, he was gone.
It's all right. I'm gonna leave too.
Good move, 305. Let's see. If she wrote it, then she would have known. Oh, you got a cosigner. If she wrote it, then she would have known that she wrote. And it's like, okay. So this Fanny wrote it for her. Fanny, what you writing? And y'all see how she tried to write that one motion where she signed her name at the front or by and through the district attorney. She wanted the judge to know that she's actually writing. She didn't want her assistants to be disqualified.
Did you see the style of that writing for the motion that Love stood up for? It's the same. It's the same style. Because think about it. Any motion that Love has wrote has had no absolute substance in it. No explanation. She just says exactly what and why she wants to do whatever. She has no actual substance.
I'm gonna go read it. I'll go read it in detail so I can get a feel for how. Cause I already kind of know how Love write. That's a given, but as far as fine, I gotta go read a few of her motions to get a taste of her style. Then I'll know.
Well, just know that was Fanny. Bonnie.
All right. And Thunder Drop said the same thing.
Because if you gotta think, the judge was so smart that she asked to see whoever wrote this motion. I want them to appear today.
That was strange because if Adrian signed it, why would you assume she didn't write it?
Right.
That was strange that the judge said that.
And it was like she was waiting to stand up to say, okay, I wrote this. But if you wrote it, then why couldn't you articulate what you wrote?
Which is wild because the judge had already said that she sent an email requesting that whoever wrote this motion need to appear in court. So that means that they had noticed that, okay, the judge is on to something because she want to know who wrote this motion. She sent an email to them. So that means at the very least, DA Love should have been prepared to address it. Y'all asking me about everybody today. I think Kayla went live on her channel today.
Kayla is live on her channel.
Kayla's live.
At the
I don't know
courthouse.
if she at the courthouse. I don't know if the Lee's live or not. Y'all asking me about and they actually in Atlanta or in Georgia. I'm way over here in Texas.
Don't worry, Slick is live too at the courthouse.
Oh, Slick at the courthouse?
Mm-hmm.
Oh, wow.
He gonna be on the state's witness list next if he don't stop playing.
Not the state witness list.
LaVonda said they is innocent.
About time. There you go. She said, send them all home. They're innocent. Yeah.
Lavita Alizé, Miss Jenkins, Vaughn Chelsea.
Okay, he didn't go live today. Okay. Yeah, but it's a lot sometimes to sit here all day long, 8 hours, 10 hours, you lose the whole day.
Question, because I know it's on my TV, but I'm not sure is what color suit did Doug have on today, y'all? Was it like gray? Oh, that's an old interview. Sorry, I thought he was interviewing now live, but that was an old interview with when Glanfield was on the bench. So fine.
Oh, okay.
That is LaVonda. Don't do that, Slick.
The judge knows finding writing. Let's see.
I'm telling you, it was something up with that. I don't know what it was, but the reason she asked that had to have some type of significance to it, enough to say the person that wrote this needs to come to court. Because what other reason would you have to believe that Love didn't write that versus
right,
somebody?
if her name's on the bottom of it.
Correct. So even if, like, let's say even if somebody started it and she finished it, or like let's say she had a paralegal write it out and she reviewed it. Like,
right, but the attorneys are still responsible for whatever submitted.
correct.
So I mean, yeah, so it would have been wild for her to say my paralegal wrote this, even though that would have been better than the excuse she tried to do today.
I don't know.
Awesome.
She made note that candor was a big thing. I think that hurt Love more than anything. I'm gonna go back and look at it. Mm-hmm. But her facial expression, she still has not learned how to behave herself in court to where she does not make reactions to statements that are made about her. I don't like that.
Between that and when Brian still pointed at her, he wasn't playing where he said, this lawyer.
That hand would have got slapped by the right person.
Ooh, but I don't know. She kind of like wasn't looking directly at him when he did that. The judge is watching. The judge is watching.
I don't know. When she called her out and said she was not being candid with the court, I felt like that was a direct shot because she already knew that she had been labeled like a liar. And then like the fact that she got up there and lied again. And it was about to make me mad because sitting there and watching her say about the tapes that she said that were missing pieces, I thought she was going to go through that whole spiel again about them taking out parts of it. She did say a piece of it, but it's like, come on now. At what point are you going to just say, Well, we just didn't get the whole thing.
Yeah. I mean, but the thing is, Brian still was basically saying, I didn't have to give you anything. And you're going to go and say that I'm chopping it up and taking out certain stuff. Talking about that's not how an iPhone record. That's not the quality of an iPhone. What are you even talking about? A lot of stuff can affect the quality of an iPhone recording. It can be, if it's outside, there's traffic in the background.
First off, it can be just a dysfunctional phone that does not record where the speaker can be broken. Like quality of an iPhone. iPhones are
right.
They're good, but they're trash.
We don't even know what year it was. It could have been an older model. You don't know. She don't know what we don't know. She just assuming. And that's why he said I shouldn't have gave you. He should have gave a nut. And that's the nice way of saying it. That's what Brian really wanted to say. Thank you again, Slick So Famous TV. You taking all my money, but Mr. Green siblings tied down.
I wish. Slick.
Shout out to Slick.
Slick, you know
what?
Slick
said I'm gonna hit you back to back.
Guess what? Them little $4.99 requests that you sent and talk that long, and you still have not yet to pay me my money. I can't believe it.
Shout out to Slick So Famous TV.
Don't shout him. Don't shout him out.
You say you want me to take a what?
Go put me down. Go put me down. Put me down. Go drop me down. Do what Slick paid for. No. I bet y'all one thing. No. It's the only thing I'm gonna add Slick for that $4.99 stand up.
Slick, you gonna count him up?
Lady Red, he is acting up. But when I make it to Atlanta, let's see if he act up then.
Oh, he in Atlanta?
Mm-hmm. The #1 hood reporter.
Oh, yeah, he did. Yeah. Because he had came up.
Now, y'all not finna talk about Miss Lavonda like that, talking about bring up Lavaca.
Who said what?
They said bring up Lavaca.
I don't even know if that. Well, yeah, she called in earlier, but I think from a different channel. I recognize her voice, but I don't know whose screen name this one is.
That's her channel. She just changed her name.
Oh, so she actually has a YouTube channel.
Yeah. She made her channel. She ain't started going live yet, but that's Lavonda. Don't do her. You know.
Yo, yeah, I think somebody had told me she had got upset because sometimes my editor will go back and crop the videos down. And if there's like a lot of stuff going on, like a lot of cussing and stuff like that, they'll crop it out. She think we cropping it out because we don't want
you cropping it out.
We don't want her in the video.
Silence her.
Yeah, no, that ain't the case.
So is that why you crop me and Slick out?
Y'all got cropped out?
I'm just joking. I don't know.
Oh, I was gonna say normally if it's like regular talk, regular conversation, then it's not. What I need to do is give me a separate channel where we can just really talk. But when it's on the main channel, then YouTube might act.
Slick say we
crazy,
did.
Take the whole thing and.
Slick say we did get cut off.
Oh, what y'all be doing? Going back to look at it?
Huh?
Y'all be going back to look at it? He said,
might reference it. We may reference it. Oh, he said, give me his. Now, Slick, you ain't finna do that now. You's not finna do that. It's no, look, you need to put your banner up and say no refunds or exchanges.
She said, yeah, you got to be professional. Yeah, just give me my money.
Mel, this is professional.
Yeah, you can't, but yeah, it don't work like that.
Hold on, it look like
that YouTube.
Is Lavonda in that back chat?
I don't know if that's her or not, because that picture is different than the picture.
That is her. If it's a lady with the bun at the top, that's her. Lavonda,
Okay.
if you back there, oh yeah,
It's
that's her.
me.
How you doing, Miss Lavonda?
How you doing, Talk That Law?
I'm doing good. So what do
Can
you
we
think about?
agree that I like you? We just have a difference of opinion.
Oh, right. Yeah, we ain't got no problem with each other.
And you already know if you give me the ammunition, I'ma shoot. So I don't be disrespectful to nobody in your chat till they start saying something to me. Like the girl said, your mother, your father, your neighbor, your uncle, all that. It
Yeah.
doesn't bother me when somebody say something about that, but then don't get upset when I become 15 instead of 58, because I can do that.
Well, the thing is, anything that's going on in the chat, it's better to keep it in the chat, and that way we don't have to worry about taking a video down because of the
Right. I
disagreement.
was just letting you know. I'm not even gonna curse on your chat. Not one curse word.
Now, every once in a while, I might have a slip of myself, but if I get took down on my own, then that'll be my own fault. It won't be blamed on you. But
but mine's be intentional, so I'm just saying I'm not gonna do it.
Come on. So what you think about this no good judge and why she doing Young Thug wrong?
See, that's what I'm saying. Talk that law. I'm going back to Simply Top when she first met me. You are what is wrong with this world.
Me?
Yeah, you. You. Instead of her saying me, no, because I could be. You think I'm biased, but I could be unbiased. I like that they got rid of Judge Glanville because he did not have control of his court, whether it was love or steel. Love or steel. That man did not have the capacity to run his courtroom. Steele went and got his mama, and she got Love, Hilton, the other man in check, Brian Steele, Sharp, the one with the long ponytail. She running her courtroom. That's all you can ask.
I didn't know that you were in agreement with Glanville getting removed.
Why not? I don't sleep with him. If he ain't doing his job, go. But what I did say is they're going to wish that they would have kept Glanville.
Yeah, I remember you did say that. Somebody said y'all may get somebody worse. What's going on, Nurse Shells? Oh, man. But do you think that Young Thug should have got a bond today?
Why you going to put me out there like that? Yes, I really think that man should have got on house arrest because he has the capacity to pay, even though it's not fair to other people who don't have the income. But I think him losing out on $50,000 should be enough of an Iola factor to let him get out. Now, I will say that. See, you were shocked. You were shocked. You was ready. You was ready to say something. Oh.
No. I'm reading. I want to thank Slick before it slipped my mind. Before it slipped my mind. Thank you so much again for another donation. Okay, I'm broke now. Bring oh my God, y'all are funny.
Miss Lavonda.
Go ahead.
Make sure you read this because I want you to know.
No, I want you to tell me because I can't read it. I can't read it. I have to
screen.
He
said he broke. Bring Miss Vaca down now.
Thank you, Slick,
So
for the third donation. Go ahead, Slick.
The next time you see him, get him. But that just stupid.
Wait. Oh wow, he didn't throw money in the wishing well.
Straight to the chat for him. But Amber said something.
You made her get down, Slick. She said, "I'm done, y'all. I promise."
It said Georgia law. She said Georgia law must be very different from California because out here he would not get a bond. I mean, they haven't considered bond at all. I mean, from what they're saying, he's a danger to society in Atlanta, so they're not considering giving him or any of the defendants bond, which is crazy because all the other defendants that were attached to this case, they received a plea deal, then they're out. So if they were so dangerous, why did you?
Yeah, that makes sense. And it makes sense because you're saying these people are dangerous, but if they take a plea deal today, they get to go home. All right, what happened to the dangerousness and what happened to protecting the welfare of the community? All that go out the window as long as they get them on some papers. Because they know if they get them on some papers and give them a plea deal, then they can always get them on the back end. And you give them 20 years probation, they know these boys are gonna mess up in 20 years time. So it's easy. Give them probation now, let them mess up. I mean, because a lot of these young boys being in and out of jail or in and out of trouble their whole lives. Some of them. So it's nothing to give them 20 years probation and then the state to sit back and wait.
That was slick. He sent his goons to turn off my internet.
Oh, well, let me go find the super chat for you. What he said? That boy is funny. He's
sent it to get me down. But yeah, I mean, I think that honest to God, I don't know if she is considering the mistrial because she leaves it like it's a possibility. Like she's teetering on the possibility of the mistrial. And I feel like the more love spoke, the more it started teetering a little bit, especially with that not being candid with the court. It brought all of the things that they said in their emotions to light, because now you're seeing it in real time to where she's saying something in front of you. And you're not just reading what somebody else said that she potentially said. You can actually see her stance and how she's trying to miscalculate specifics of the case. And it's like, well, what do you do in that instant? Like, am I going to side with the defense or am I going to side with the state? I mean, I get the state pays her. And like some people have said, the state pays her. So, of course, she's going to side with the state. But I don't feel like that. Once she wants to grant a mistrial, I feel like that she feels like this is an opportunity for her to stand firm and reassure the state of Georgia that they can conduct a fair trial and try and save face for this case. Even though, I mean, it should be the right thing that I think would be done, but then it's just my thoughts.
Yeah.
At Amber, no, the jury is not sequestered, so they are out living their normal lives.
Right.
They're able to watch YouTube, even though they receive instructions not to, follow the case or follow the trial outside of what they hear inside of court. So no, they're not sequestered. They literally can be watching this trial with us as we're watching it. And I feel like they are, like, if not one of them, at least all of them are, because you got one person that's gonna be like, and
that judge is gone. They know he gone. So who told us we can't watch it?
I don't know. You think they know that if he gone?
Yeah, they know he gone. How they not gonna know he gone?
So I wonder why they haven't brought the jury in to poll them to see if they can even still continue to go on with this trial. Because typically that's done by now, especially with like a long pause. Before even starting this, they would get the jury to see, or maybe they've done it on the back end where they haven't said anything in open court, just to verify, to make sure they're all still willing to come in. But it kind of just doesn't make any sense.
Yeah, I mean, I can't wait till they come in because I want to see how they will be able to move forward. Are they going to question the jury? Hey, jury, have y'all been watching? Do they expect the jury to tell the truth? What happened to the old judge? Why he gone? What type of reason they going to give for that? And if it's not a truthful reason, then that's going to be an issue.
It's just a super, it makes it like, it's just a super, I mean, it makes it like, 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 it makes it like the state is like intentionally, as Weinstein has said, goading them to do this mistrial, even though she's saying that she doesn't want it, and she made this like theatrics, like let's keep the trial rolling then, like. But how can you roll even successfully? Like, because me as a juror, if I'm coming in, and first off, I know that this was an African American male that was sitting on the bench, and I come in and I see this bubbly, Caucasian woman sitting, I'm gonna be like, okay, what's happening? If I don't already know, like, you might have that one-off person that's like, okay, I haven't really been following. I'm gonna follow this like to the nail. You might have that one person that's like that won't do it, but then everybody else gonna be like, oh, well, y'all know he gone. Like, I mean, somebody said something, like they've had some type of conversation or something. I don't care if it's on lunch or something where they said something. Somebody just ain't told it yet.
Yeah. I mean, they're going to have to tell them something because they won't even be able to concentrate on the trial trying to figure out where the judge at. So, I mean, they're going to have to tell them something. What they will tell them, I don't know. But I think
they have their phones? Like, why they sitting there in the box? Do they have their phones?
I don't think they have their phones with them. They got to put them up. But
because I'd be Googling it right then. Like, what happened to, like, I would have been Googling it first day after we got, like, we got that long pause of culture. They said they was going to go through that stuff. But I do have a question. Did she say that they were going to have to go back from the day that Weinstein put in the motion to recuse and start all of that over again?
That's what it sounds like, but that sounds like that'll be Woody's testimony. And because I don't know, because Woody was the one still on the stand when all this happened. When they found out about
continue if Hilton has some trip that she has to go
on. Yeah, it sounds like the judge is going to take it under advisement, but she's going to think about it. But I don't know how they're going to be able to do it. Yeah, I don't know how they're going to be able to do that. Oh, go ahead.
Oh, I just had a question before you talk that long. When she was talking about candor, when she said, Ms. Love, blah, 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 and she said that was what Steele had referenced. So she had to say that. But when Love stood up and she said, are you saying that I'm not? And she said no. So we can't misunderstand what she's saying. She was addressing what Steele put in his motion, and she spoke it out loud. So I'm not saying that. I'm just saying let's just get the facts straight. To what we were talking about was only one thing, candor, that they was talking about, and that was something that she had to address because Steele had said it.
Okay. Well, what you're talking about is two separate times.
Okay, well maybe I missed the first time, sir. That's why I was asking the question.
What you said the first time was it was a motion, and she reminded Attorney Love about the professionalism, and she said, have I, not been professional? And just like, no, I was just saying it because Brian still made the argument. But the next time, the one that we just seen, this last one, she was getting on Attorney Love. That didn't have nothing to do with Brian Steele's motion. That actually had to do with her motion, where she was misleading the judge. And the judge got upset with her specifically, and the judge told her about candor to the court. That was her own doing. That had nothing to do with a motion.
Okay, I didn't see that. No, I was just asking a question. I wasn't even, for real, I was just asking a question because that's the only one that I had saw.
Tasha, was that right? Was that your summation of what you got? You muted.
I said, sorry, y'all, I'm having an attack.
Oh, okay.
But Ms. Lavonda, I think that you were referring to the question of where the first day when they did the status hearing, when he brought it up and just was in reference saying that, she hasn't been forthcoming with a lot of information. And she just reminded everybody, because it was a break, that they had time enough to, let all that stuff go. This is a new start. Everybody has been professional thus far. And today, Attorney Love got up, and when she directed her, because she wanted her to go over the motion, she wanted to see who actually wrote the motion, and they wanted them to be in court. Love stood up and attested that she was the one who wrote the motion. And some of the statements that she made in the motion were mischaracterizations of the case that she was citing. And she called her out on it and said that some of the things that she's saying isn't true. And then when Brian Steele got up and he told them that this is the 4th time that he's went over the information with her pertaining to this, I know for a fact that that happened a couple times. And even just recently, last week, this motion was brought up. Like, it's the same motion. Even if she didn't write it down, it's still the same thing. You're still bringing up the same thing over and over again, saying that you want him to hand over everything. And he said right before Glanville got recused that I've handed her everything. And just in fact, I don't have to give her anything.
Mhm.
This is her case. So technically, he doesn't have to provide her the material that she's referencing. Because what if he doesn't use it? And it's really up to her direct or the state's direct of how he presents the evidence that he needs to clear his client. So if the person doesn't say, like, let's say, for example, Woody says such and such, he doesn't know anything about the murder. Now they say they got a recording of him saying that he did the murder with other people. We did the murder. He might not have used that if Woody never said, I didn't do this.
Okay, I didn't hear that second part. I heard the part about candor, and that's why I asked, what did she get in trouble for anything else? And tell Miss KJ, whoever that is, I do know what I'm talking about. I did ask a question. Tell her just block me so then she won't hear my comments. She don't know what she talking about.
Yeah. So that's what I was thinking, that it was 2 separate events. But that second time, not only did Love line her motion, but she tried to mislead the judge about it being the 4th time that motion was being addressed, a separate motion.
Oh, okay.
And she tried to tell the judge, no, we haven't went over 4 times. When the judge asked her, then she tried to have a play on words.
Did she get in trouble?
I mean, I would say, if the judge is telling you to stop lying, that sounds like, you get in trouble.
Okay.
Now, I mean, she ain't gonna lose her license and get kicked out the case tomorrow, but the judge telling her, like, hey, I see you. Yeah.
So I think Lady Red said, yes, he also said Hilton emailed him saying that they can't find it, but the state has evidence. Has evidence or recordings, and Love tried to say something different. I mean, I feel like that she's continuously saying things that are not true, or she tries to like exaggerate parts of the truth to make it fit her narrative of what she needs. And I feel like that this whole case has been that way. And I was on Twitter yesterday and I seen Thugger Daily had wrote something saying, that they want this case to be over. And I seen that somebody else like, no, we want this case to go on for a few weeks. And I'm like, at this point, I feel like anybody who wants this case to continue is looking at it from their benefit, not the benefit of these actual defendants. Because at the end of the day, it's people's lives that are being like mishandled by this judicial system. Like, you want to have faith that, like, if this happens to you or happens to someone that is directly affected by you, that they wouldn't have this happen to them. And a lot of times it does. And this is we're saying, okay, we want this to continue, but is it for our benefit or theirs? Because they're sitting down there in what they say is the worst prison or the worst jail in Georgia and constantly having to be on lockdown 23 hours a day. When is that good?
Are you talking to Miss Lamont or me?
I'm just saying in general, anybody. I mean,
yeah, I can't believe they got him locked down 23 hours a day. I mean, that's insane. especially for him not having been convicted of a crime. That's almost like being in the hole. If you're in prison, you're in the hole, you did something like crazy.
Right.
Not in the local county jail where he haven't been convicted of anything.
But we see murderers every day. This man is not even convicted of a murder. And I'm speaking of Thug only. Well, we'll say Mr. Williams. But he hasn't even been convicted of a crime, like, or charged with a crime that is a violent offense besides this RICO organization. So regardless of whatever, you got people that's convicted of murder, like they're not even convicted, like they have done crimes, and you're pleading them out and letting them go free back into society. And you holding this man without a bond. And the fact that she says now that's the only thing that I did not agree with from this judge, saying the circumstances have not changed. Like, these are big circumstances. Like, for one, and I have a question, and I don't know if you can answer this or not. But somebody said, I'm not going to mention their name, but somebody said that the state said that they were going to rest their case in August, right?
Right, that's not
and
true, obviously.
They said that, they will rest their case in August. Somebody who, goes to the courthouse or whatever. And they said they got this firsthand information from Attorney Love. And then today, when the witness list came out, it was like 105 more witnesses. Right. So is that information inaccurate? Like, do you feel like that it was exaggerated that she's going to rest her case in August? Or like, because how can we not have went through any witnesses to get that number down? Like, I don't.
Well, if we look at it, we already lost a month and a half. So how many witnesses could we have got through in a month and a half?
We would have still been on Woody.
We would have still been on Woody, right? Could they take 5 days for one witness?
No, sometimes it was like 2. Remember, like it was like a week and a half.
But the thing is,
recalls, like all the hearings, he was on the stand for like 2 weeks.
Right. So my thing is, will those other witnesses be as important as, like the Woodies, or because, Woody is supposedly the main star witness. So after him, you may not have anybody more significant than him. So they may be quick witnesses, an hour or 2. So if you can get 4 or 5 witnesses a day, an hour each.
Who has been an hour? Name one witness that was on this trial that was an hour.
Well, what I'm saying is those are like the star witnesses, like the Beans and the Tick and Woody. But after them, who else is that important to be up there for 5 days? I'm gonna mute it. It's an echo.
I really don't know. I know they had Dolly on their witness list. They had
well, yeah, like what all would she know?
I mean, she was a part of some stuff, like, and we don't know what statements that they have from her.
I mean, so it's a chance she might plead the fifth.
I mean, it is.
I don't know what they're accusing her of. I'm not familiar with her.
I don't think that they're accusing her of anything, but she was a part of what was that?
See, if they said she a part of anything, no, she would have plead.
I mean, I just feel like all of them are just talking. Like they all are, like everybody in this case, like except the defendants, are all talking on social media. And I feel like at some point, when are we gonna shut up? Not saying that you can't like talk, but it's just all the indirects, like the comments, like it's becoming a little bit too much. And then
wait a minute. Who is that girl?
Who is
that? Is she a witness that got supposedly robbed?
Dolly is Young Thug's sister.
Right? But who he talking about? I mean, and Regina said a witness. Well, we know she. Yeah,
I haven't been reading the comments, so I don't know. Yes, Malcolm, it's me.
But yeah, my thing is with the sister. If the sister, is she an unindicted like co-conspirator, or is she actually?
They say she's an unindicted co-conspirator.
Right. That's it. And if you're an unindicted co-conspirator, then they are accusing you of a crime without charging you for a crime. Yeah, they're just saying you a co-conspirator, you just unindicted. We didn't indict you. So that sounds like some Fifth Amendment, areas for me if she was a client of mine. But I don't know, all the details. What they want out of her, is it basic stuff or is it stuff that can hurt the young thug? Because the last thing we want them to do is to force her to get immunity.
So do you think that they will come back to ask to grant her that use immunity?
It depends on how bad they need whatever she has to say, but I don't know what could she say that's more important than what Woody, Bean, Tick, all them said.
But none of them have said a thing to my knowledge. I can't pick out one thing of substance that Tick, like DK, Woody, like they were funny, they were memorable because of some of the key terms that they used. But I can't think of one thing that they testified to that proves this conspiracy. Besides, I don't recall. And then playing any jail conversations or any statements they've made to the police. But then even still with DK, just going back to his testimony, he was so quick on his feet with answering questions that he was able to make up acronyms that I couldn't have thought of on the spot for YSL. Or what does such and such stand? Like, these boys have been well thought out I can't say well thought out because some of the things that they did was very stupid. Like, I'm not going to even sit up here and lie to you. They did things that were very dumb and uncalculated for these high stake criminals that they're potentially trying to portray them as. Because I don't remember RICO cases involving like gangs that they could prove like, and they're using social media. Most of the mob or like any other potential like cases of that nature, when they bring those cases up, they have mountains of evidence. And this is ballistics. Like, they have like testimony. They have witnesses that are not scared to testify. I don't know if these boys live by oath or not, but they oath is not that high because highly regarded in that sense, because most of the time they're telling on each other.
Miss LaVonna, you was finna say something?
Oh, sorry, my phone. I thought my mute was still on. It's just so confusing still. Like, what's going to happen with it?
Yeah.
If the state can't prove their case, they just can't prove their case. But
we know DA Love, that's your girl.
Oh, I like Hilton.
Oh, you like? I thought you said I love. Didn't you say that in the chat?
I was just trolling right then. I like Hilton.
Oh, okay. I was like, hold on. Yeah, Hilton. Now Hilton all of a sudden got to be away for a whole week. Where's she going?
You didn't say that when Melnick had to be away.
Oh, I did. I definitely did.
That's what I wanted to ask you. Has Kayla been back on your channel since she became famous?
Since he became famous?
Who became famous?
I said since she became famous. YouTube famous. Has she been back on your channel?
Actually, we never talked about her coming back. We actually we linked up on 2 separate channels since then. It was on Dear Woke Christian channel, and then right after that, she invited me to her first live. So that's the last time that we actually talked. But it ain't no bad blood, no beef.
Oh no! I knew y'all was gonna become budding friends.
Come on now.
I could see y'all becoming. For real, I could see y'all becoming good friends.
Yeah, I ain't got no. I haven't spoke with her, but I actually think we ended up on the same plane about a couple of weeks ago. But I didn't get a chance to talk to her. It was so much going on, a whole lot of people. But yeah. Well, so what you trying to say? She forgot about the small channels and she done got a 10,000,
no.
12,000.
You're not gonna do that to me. You're not gonna do. I just asked the question. I'm not accusing that woman. I'm not doing nothing.
LaVonna, what you
trying to say?
What was you doing? You was just goading me into trying to say something else other than the question I asked to see what my response was going to be.
No, because You asked the same question earlier today in the chat.
Because and it never got answered. So
Right.
I'm asking you now, have Kayla, because you could have said, yeah, we link up all the time. We doing something behind
But
the
I'm trying to
scenes.
figure out what was the premise of the question. Like, what difference does it make? In other words,
It doesn't make any difference. I was just asking, has she been back on your channel?
yeah,
That's
but
all.
you had a reason now. Come on.
The
Don't try to
reason
play
is
me.
because I feel like she should come back on your channel and support you and give you some of the exclusives like she go on them other channels, since you was the one lobbying for her saying, man, she getting ready to break the story. That's what you said.
That's how I did it. How I do it.
Man, she about to break the story. She
No!
got it.
You can't
LeVon,
make
you
this
can't
up.
be serious.
You can't.
You can't be serious for real.
I'm here for it, though. I'm here for it. No, but I haven't. I'm sure if I get her on the phone and ask her, ask her. She's trying to grow her own channel right now. So, it's hard to try to keep going to other people's channel when you're trying to grow your own. So I didn't haven't asked her to come back over here. That don't mean that, that she wouldn't be open to it. I don't think.
Now, Lavonda, she has stated that she's not giving any exclusives to any channel anymore because of the simple fact she can just use it to grow her own YouTube channel. So I don't think that she probably has a problem with talking that long. And I think maybe she might visit. Who knows? But
that's not what I was insinuating at all. I was just asking, has she been back?
No, she ain't been back. She said she don't got time for us. That's basically, she doesn't have time. Well, yeah, y'all got to think that lady's a lawyer. She travels. She has kids, so she might be a little busy.
Right, but at the same time, I understand that she's trying to grow her, and then she was live today. So what sense would she have to do? Shut her channel down?
It's over. We don't have to defend anything. I was just asking because it seemed like y'all had developed a chemistry. So I just asked the question.
Not a chemistry off
a YouTube like kind of chemistry.
Oh,
I mean, I have a chemistry with Tasha, and she told me that I was the worst kind of a black woman. So
she told you that
on your channel. And then we got the same bathroom set. Same bedroom set, and then we follow each other on all platforms. So I was just wondering about her.
Lavonda, now
yes,
I just had a time in my life.
She funny.
But we got chemistry. Ooh, we got chemistry, girl. Thank you.
Okay, well,
no, I'm just messing with you, girl.
Okay, because I was going to say we just have a like-ship or a YouTube ship.
We have a like-ship. Yeah, we have a like-ship, not a like-ship. I'm just
no,
they're trying to misconstrue your words. Y'all don't be thinking that me and Miss Lavonda got no chemistry like that. Yeah,
please, y'all leave that alone because I don't want to say anything to make that man take his channel down.
But yeah, I get what you're saying though. But I tell you what, the next time we do talk, I'm gonna make sure that I send you an email.
It has to be on the backdoor channel. It cannot if you expect to stay monetized or to get that channel monetized. Do not even do it.
What you talking about?
Lavonda said she gonna say whatever she want to say, and she gonna say it in the raw form. Is basically what she's saying. So she said, if you want to have that conversation with her,
it got to be on that back channel that you say you create. And I can wait.
Wait a minute. I thought you had asked me when me and Kayla speak again. You're saying that you want to come up and speak to her?
Oh no! Oh, I thought. I jumped the gun. I thought you were saying the next time I speak, I'll bring you up or invite you. So I jumped the gun. I'm sorry.
Yeah, Miss Lavonda, he not putting you on the phone with Kayla Bumpers at all. Jesus, that would be
and I'm not even mad at him.
Would be horrible. You hear me? It would be good, but Lavonda will try and read Kayla to the fifth. So please don't do that.
I like these braids. You got a new picture. I didn't know who you was. I couldn't tell if them micro braids or.
You see Lavonda?
What they call them? Is it singlies?
No, these particular ones are box braids.
Oh, box braids.
And they're not even with the. Yeah.
Look at you, well versed in hair.
Come on, I know.
Well versed in hair. What you?
A family. Come on now.
Box braids.
Box, yeah,
You
come
say,
on.
is it singlets? Okay.
Is that what it's called?
2007. I got you.
Is it 2007?
Yeah, I ain't seen nobody with no singlets twist in a long time.
I was getting ready to say I ain't seen them since like, yeah.
Don't
Yeah,
do that.
Since I graduated from high school.
But that's good though, because most people might have like a 27 piece or something, but she actually got the braid thing.
Okay, you trying to show us that you got your card. You got your. All right, now we know that talk that lot of been around the neighborhood.
Come on, a little something.
Now you gotta use some up to date like terms. Now you gotta say the lays. Like we gotta get you up there. Like
what's the new ones?
Huh?
What's the new ones?
What's the new one? You said 27 pieces. Now 27 pieces they come up every once in a blue moon, but ain't nobody. These girls where they had them helmets on their head.
Yeah, you said the single is 2007. What's 2024?
2024 is the helmets.
So talk that law.
I don't know what that is. Okay, yeah. I'm gonna
You think Woody?
Kinfolk, what is a helmet?
Oh my bad. You think Woody gonna just go up there and plead the fifth and take the jail time? That would be the right thing and the loyal thing to do, right?
No.
Why?
Well, why would he take the fifth or plead the fifth now? Because the jury already heard from him.
I'm talking about so that he can no longer have to testify.
He's not gonna plead the fifth.
Uh-huh.
What I think he might do is he might change up his testimony now from saying I don't recall to maybe saying that was a statement that I made and it was incorrect. Because if he says that I don't recall, that allows them to play his tapes. And I don't think that he wants to sit through those tapes. So he may change up his testimony then. And if he does have an attorney, then that attorney might inform him, hey, when you get on the stand, instead of saying I don't recall, now you can change your testimony and say, basically, I said those statements. I was lying. I wasn't being truthful. And that way they can't use that blanket statement saying he doesn't recall and allow everything to come through.
So the fact that he already got his testimony, if he don't give the answer that's on the recordings, they can't play the recordings.
I mean, no. So
are you sure? Ask the lawyer. Ask the lawyer that's sitting right there.
I'm positive.
Well, what's the question?
She's saying if he doesn't testify to what he's already testified to, would they be able to play his recording?
What he's already made statements to that they have on tape. That's the reason for the impeachment. That's why Steele said they goaded him because they know he wasn't going to testify. So everything that he said, I don't remember, or I was lying, they can bring up his statement to impeach him in front of the jury. So that's why I was saying I would just go ahead and plead the fifth and go to jail.
Well, we don't even know if this new judge would put him in jail.
Oh.
But the thing is, at this point, I mean, I don't see why he should plead the fifth. I mean, he's doing a good job. He could say, yeah, I sit all that on that tape, but them tapes I was lying.
Right? See?
I mean,
that's simple.
Right, I got you. No, my question was, will they still be able to play his statement in court?
Well, they could introduce it perhaps through the detective because the detective was the one there. It's like a police. Let's say a police go to a crime scene, they have a body cam on, and they record an interaction with the public or with you. Then the police can go on the stand and testify about his body camera and what was said on the tape.
Mm-hmm.
And it won't be and that's the same thing. They recorded with the police equipment in the interrogation room, and the detective can come in and testify to that fact. So, but what they need Woody to do first is to say, I don't recall. And then they can then they can go in and play the tapes. Now, if he answered the question truthfully and say, yeah, I do recall, I did say that, but I was lying, then I don't see no need to play the tape. But they could try to use the tape to I won't say impeach, because impeach, you normally impeach a witness that's not your own witness, but they can use the tapes to, the proper term is refresh his recollection.
Can they treat him as a hostile witness?
Yeah, they can treat him as a hostile witness, but all that does is allow the state to ask him leading questions. So that's all that does. And they have to get permission from the judge. Can we treat him as a hostile witness? And then if the judge grant that, then they can ask him leading questions. And normally you can't ask leading questions unless you're on cross-examination. You can't lead your own witness, but if he's a hostile witness, then you can lead him. But I mean, I don't really see that playing a factor into what they trying to bring in. They want the tapes, but I wonder I don't think have we heard all the tapes yet, or not all of them, because we were interrupted with the.
We haven't, because they were supposed to be finishing them, and then
right.
the recusal came through.
The recusal came, so we had to stop. So we haven't even heard.
Yep, they had only got to one talk that low.
Okay, I thought so.
And then Judge Glanville decided to argue.
Yeah, Mikey, B, you can't lead your own witness when you're asking a question. Like, basically what I mean by that, you will have to ask your witness
what day. You have a pretty house. Sorry, talk that low.
No, you good. It is a nice house. You will have to ask the witness, what day of the week is it? And then the witness will say, today is Tuesday. But if you're cross-examining that witness, you can say, isn't it true today is Tuesday? Then you can lead the witness. You can kind of give them the answer because you're cross-examining them. You can lead the witness on cross-examination. And the only way you can lead a witness on direct examination is if you're given permission to treat them as a hostile witness. So it's more technical than anything. I don't think that's going to affect this trial with Woody. All they need Woody to do is get on the stand so they can play those tapes, and then Woody can get on the stand and say, yeah, I said that, but I was lying. Who knows what's on the tapes? I'm interested to see what's on the tapes. Yeah, no problem. That's what I want to know. What's on the tapes? It may not even be nothing on the tape that's of importance. Yeah, especially when Woody say he was lying, but Ms. Levon, I think you said Woody already admitted that, or not Woody admitted, you think Woody is lying now about lying then. So you're saying, Ms. Levon, that Woody's lying at trial by saying he was lying then, but he was really telling the truth at the police station. Is that right?
I keep forgetting that you put me on mute. Yeah, that's just my honest opinion. I just think that they were running amok. They got caught up, and he was the weakest link, and he told as much as he can tell true. I mean, bad enough, but to get himself off of trouble. But then when it came down to the trial itself, I think it was hard for him to get in there and look that man in the eye and snitch. That's just my opinion. Because as a lawyer yourself, even though you go in there and snitch, and there's some things that you can exaggerate or whatever, they did their investigation to put some of it apart. Like, they have evidence that can tie to some of the stuff that he said, which puts them there. It's not just on Woody's statement. And my position is that this trial, Woody was like the weak link that they wanted to put in to introduce everything else, because Thug's brother is the worst snitch. And the other man who said that they gave him the money to lay low, like, all that stuff is coming into evidence once we finish with Woody. Like Scarface, he was there. He said it. He's the one who told the police. Woody just repeated what he said. They have it in black and white. The boy Scarface with the red bandana told that they killed Nut. Thug gave them the money to go and lay low, and then took them to Miami. Now, he could be lying, but I'm telling you, that's what what is in evidence.
Someone said the full tapes were on YouTube, but we're not talking about the interrogation. we're actually talking about like the jail calls.
Yeah, they got jail calls too.
Yeah, the jail calls.
Like the jail calls, they told you what some of the jail calls was. Like when he said y'all ain't beat him up or shot him yet, y'all niggas getting soft. They wanted to take that out when he was saying there's a whole lot of stuff that they want to play that is incriminating. How they handle it, I don't know. I'm not a lawyer. I'm just telling you what's out there for everybody to see. So we're talking about it. But when you get a man brother to tell on him.
But we haven't seen that yet though.
I know. How could we see it yet if we ain't got to it, Lord? Come on.
Oh, that's what I'm saying. So you keep saying his brother going to tell on him, but we don't know it yet.
That's his brother. They let him out of jail on one of them plea bargains to snitch on his brother. How you gonna be a lawyer and running the YouTube channel? You ain't, whether you believe it or not, you ain't even looked it up.
No, what I'm saying is,
when we come up here to talk to you, you want to rebuke what we saying without you doing your own research to find out if that's out there. Because it's out there.
And listen to what I'm saying. Gunner took a plea deal. And Gunner's lawyer did an interview and said, even though he took a plea deal, he will not be testifying. I can pull up that if you want me to.
Okay, that may not been a stipulation for Gunner, but in the other plea work, go look it up. You don't have to argue with me. Go look it up. And if I'm telling you something wrong, then we can rebuttal. Go look up the plea deals. Go look up Thug's brother plea deal. We can get his paperwork like we can get anybody else's. Go look up Scarface. Go look up Umfung. Go look up the
who that second name you said?
His brother name is Umfung, and the other boy who told about the money, Thug giving them money, is named Mufung. Is a Umfung and a Munktunk.
Umfung and
a Munktunk. I sent you to go look at I sent it to you. I sent it to Simply.
Mikey Reese said, who is Scarface?
What is his real name? I'm getting ready to tell you. I don't know if that's Demikian Garlington. I think that's Demikian Garlington. I think, but like I said, I may be getting the names mixed up.
And thank you, politicking Mel. And I think what you're saying is just because they took a plea deal, you can guarantee they're going to come and testify.
No, what I said is we don't, in a plea deal, some of them you don't have to testify, some of them you do. I don't know what Gunner's circumstances is. All I know is the recording that we seen in court with Gunner pleading and saying that YSL is a criminal organization. I don't know if he's going to testify or if that was in his deal. I'm just stating what we all around America heard him say. Yes, ma'am. Yes, ma'am. Yes, ma'am.
Hold on, let me see something. All right. And you say you sent it to my email?
Yeah, wait a minute. What is it?
Did LaVonda get down?
I don't know what happened. I think her thing was lagging and it pulled the StreamYard. I don't know.
I watched those videos. It was not. It was. I don't know how informative that will be.
But was it what she said or no?
What did she say? I wasn't really listening. I'm sorry.
No, she's saying that those videos or whatever I don't know if it's a video. She said whatever she sent you, it's the plea deal of Young Thug's brother agreeing to testify against Young Thug.
Yeah, so
but I didn't see.
Yeah, she sent them to me. So from what it was like it was Unfunk. Let me see if I can open it and forward it to myself. It's from a YouTube clip, but it's what it seems like, and I don't know if this is the one she's referring to, is a guy that is talking about his case. And he's giving his opinion of his case, and then she sent another one, which is the clip of him attesting to, like, you know how the DA goes through once you take a plea deal, you attest to whatever they write down and say that you agree to that YSL is a gang, and
right. The normal,
that was just a testament that he was attesting to, saying that this stuff is true. Now, I haven't seen any interrogation videos where he snitched or where he said that he did this or he caught this type of like thing and he actually snitched on him. I haven't seen that, so I'm not sure.
Okay, I'm trying to see if I can find that.
Yeah, so Muntu and Unfung are two different people, and Unfung is the one that I think and I might be mischaracterizing people, so y'all tell me if I'm wrong. I think the guy that Thug's brother went to whatever situation he happened, he got out on bail, and then he went back and had some kind of offense with some gun, and they took him back to jail.
Okay.
Hey, Jiggy. Correct. So I know one of Thug's brothers has like some kind of disability.
I do want to say thank you to Alicia for the kind cash out. Thank you, Alicia, for that. And also to Danielle. And y'all sent this like an hour ago. And I didn't even see it come in. But
look at you.
Right, it showed on my email when I was looking at my email. So thank y'all so much for that. If y'all
also
still
sorry,
here.
y'all. Thank you for keeping me honest. That butterfly said the disabled guy is the nephew, so that's correct. Unfung is the brother that went to jail, that got out on bond, and then he caught the separate gun charge. And they said that he wasn't even the one with the gun. He took the gun from somebody else that was in a heated argument, and even the police said that he didn't have the gun. So it's just, I don't know. It's just a lot.
But I mean, that's still just because, I mean, I can't find it, but even if that's true, that don't mean he's going to come and get on the stand and testify.
Correct.
I mean, people take deals all the time. That don't mean they're going to get on the stand and say what she's saying. And that's why I'm saying you can't use that as evidence yet until it happens.
Right. So the thing is, and this is my opinion, and me and Miss Lavonda, we have our differences of how we see the case, but I always let her express her views. But my stance on it is until and she said this as well, until the full case is presented, we have no clue if the state is going to meet their burden of proof. I don't see it. I don't think it's going to happen. I don't know where Rico is. I don't know if we found him as of yet, but he has not arrived in Fulton County. The thing of the matter is, it's just in general, like it's always a what if scenario. Like the jury may convict these guys. And I'm not saying they're going to convict every person, but they're presenting this case as a whole. So with the lack of evidence that they have in situations, I mean, I think it's best for all of us to just look at it with a broad scape of like our viewpoints, understand that people going to have a difference of opinion. I was the first person to call Lavonda when she came up here with her mindset. But then I had to think like she has her own viewpoints as to why she thinks that this case hasn't been presented the way that she thinks that the state is presenting it. She thinks the state is doing a great job of presenting their case. I mean, I think that she does have some valid points on some situations, but then we agree to disagree.
Right. Yeah, the thing is, she's saying Thug's brother's going to testify against him, but he hasn't done so far yet. And until that time, that's not evidence in this trial. So I know she want to convict them so bad, but until they get on the stand and raise their hand, then you can't say his own brother is testifying against him. You can't put the cart in front of the horse. If this would, I doubt the Fed's gonna touch this. This is too sloppy. This don't seem like this don't seem like nothing the Fed's gonna touch. The Feds like to actually win, and maybe they 313 the best side, but the hostility and the questioning of his profession is unwarranted. Yeah. And some people get worked up in their arguments. Yeah, I mean, but just because he hasn't just because he entered into a plea agreement, and from my understanding, did he enter into a plea agreement, but then the plea agreement was violated and he's in prison now?
Yeah, that was the plea agreement with the gun charge.
So his plea agreement was pulled back and he's in prison.
Correct.
So
and
so the plea agreement is revoked.
Correct, which makes it still, his statement is still there, but most of their statements is attesting that they're part of a gang, which being
right,
a part of
everybody
a gang
said
is
that
not illegal.
it's not illegal. Right. So I mean, I don't understand what she was getting so worked up about.
I don't know. She said she asked you to drop the link. I really wasn't listening. I would love to hear her viewpoint as to what she was referencing. But I honestly don't know, y'all. So he takes the fifth, and I mean, he can take the fifth, correct? I mean, if they do try and get him to testify, he has that right. He's already in jail. I mean, even the guy, I don't even know what his name was. I think his name was Dwight White or something. Dwight. I can't. D'Angelo, I think White. He could.
Oh yeah, that's the name.
He was in jail, right? He could have took the fifth and just said, instead of saying why I'm here, he could have just took the fifth and just went back to jail. They couldn't threaten him with more time.
Yeah, I mean, he would have been in jail no matter what. Yeah, and it's not like they were agreeing to knock his sentence down or let him out of prison.
Right.
Yeah. Slick, so you can't plead the fifth in jail.
Yes, you can.
What they gonna do to you, Slick?
Lock me up. I'm already locked up.
Yeah, I don't know where Slick got that from. Slick said you in jail, you don't have those rights.
We do have rights in jail. I have the right to shut up. I have the right to sit down and not say nothing. I have the right to tell you that if I want to. You get mad, you can place me in a hole like I'm already in jail. And he said he only had, let me do the rest of my time so I can go home. I wouldn't even been there.
She said Rico is like Batman.
Not
I'm
informed.
just reading. Yeah, I'm trying to read some of the comments, catch
Bree
up.
say, yeah, Bree, B say Rico's not coming.
Jiggy say, I just peeped. The state wanted to pause Woody testimony again to question another witness first. Yeah, that was wild. Like, what? Like, why? I don't understand any logical reason to do that. We're going to stop Woody testimony. So Woody, we got to remember when the jury left last, it was Judge Glanville, it was Woody, and it was Lawyer Hilton questioning Woody. Now what the state is trying to do is when they come back, there's going to be a new judge. So Judge Glanville gone, Judge Whitaker. Judge Hilton going to be out of town for a week, so she's going to be gone. And a whole different witness, Woody's going to be gone. They want to question another witness. Like, what?
So wouldn't that make sense to just recuse Lawyer Love and Lawyer Hilton Hyatt Hotel?
Kiki said, we ain't seen Hilton yet. Yeah, I mean, it would make sense. And what the judge was essentially saying, it's already a mess. We already got a new judge. We might as well have a new lawyer questioning the witness. Like, yeah. And that's when lawyer what's his name, Harvey jumped up and said, you can't do this. It's not this is not right. The judge is trying her best not to let this case go, but it's gone. It's gone all the way. Yeah. Well, somebody said that him and Love don't get along. He won't talk to Love. Oh, you're muted. Hold up. You muted yourself.
Did you not hear him say, I don't talk to Love? I don't talk to her at all.
I think they're talking about Woody.
Oh.
They're saying why can't Woody question him?
I don't know. I want to know the answer to that. Everybody gives their speculation on what they think for some case with his brother, but I haven't heard a legal standing as to why. Because who are they going to put on the stand? Were they going to put BBL Brown on the stand to direct Woody?
Somebody said they got a video of him dancing or something.
It is. You got to watch it.
I haven't seen it on no social media.
You got to watch it. I think it was from Instagram. He was dancing at a wedding. He gets very much. I can't say the word, but he gets very much.
Oh, I got you. Oh, okay. So it wasn't like a line dance, or the whole crowd is dancing.
Nah, he was shaking, and every part of him was shaking too.
Oh, okay.
That's all I say.
Oh, okay.
That's all I'll say. But I mean, he's not. Aside from that, he's not confident enough. He gets easily flustered when you go after him or a witness does not do what he wants them to do. He doesn't know how to conduct himself. He says too many ums. And Woody is a character. So I feel like that Woody would play on that. And Woody would, like, unfortunately, he would like discombobulate Brown so much that he would make him lose what he's trying to pull from him.
That makes sense.
Because look at his testimony before. The judge was like, get it out. He was saying, he was like, get it out, Brown. And like, if he can't, you see how he got on to Hilton when she said, Officer Copeland, he said, oh, I'm a detective now.
Right.
So he's really good with comebacks. So I don't think Brown would be good. I don't think Atkins, I think that's his name. I don't think Atkins would be fluent enough to handle him because Atkins doesn't have enough soul to even understand half the things that Woody's going to say.
So who you think should do it? Fonnie Willis herself?
I think so.
She'll get rid of him.
I think she needs to come down.
Come down.
Because I mean, who else would be able to do it if what they're saying is correct with Love gone And could you imagine Fanny coming down to that courtroom and cross-examining him? The theatrics of that that direct would be horrible.
Right.
Because I'm not gonna lie, she's good. She's good at definitely what she does. But he's gonna read her to the filth.
Right. Yeah, that ain't gonna work. That ain't gonna work. Especially if you have some type of inside knowledge as to her
what
previous.
Has happened,
yeah.
What he could say. And
mm-hmm.
I think that, I don't know how you might feel, but I'm waiting on the cross-examination from Steele. I feel like he should be the first one that stands up. I don't want Shard to stand up. I don't care about Weinstein. I want Steele to stand up and cross-examine him. The only reason I want that is because of the simple fact that I think Woody's going to cooperate more than we think that he is. Because I feel like it's so much that he wants to say that he might get up there on the stand and say, yeah, they forced me. And even without him asking that question, he can answer that. He could have answered that question, but I think that he can't answer it for the state because he's afraid of what they would do to him.
That makes sense.
India, I think that he will cooperate. The only reason I say that is because he has a disdain and a hate for the state so much that even with them talking, I feel like people think that Woody's dumb. I actually think that he's very smart and he's very calculated. Now, I don't think that his approach is very smart, but I do think that he's smart in what he's doing. The reason why I say that is because think of it from this standpoint. Everything that he's done, he's twisted to where he's now able to say he was lying. I don't feel like he was lying in some of those tapes. I feel like what he did, he exaggerated the truth to benefit whatever they wanted to happen. That's why he was able to teeter on the lines. Okay, I'm going to tell them something, and then I'm going to follow it up with a lie. So I'm going to say, talk that law, went out and made a run for me, and he going to pick up whatever at such and such time. Let's say he is going to actually go to that place. But then I'm going to follow it up and say, well, you also know because they want Thug to be involved in it so bad, he going to pick the stuff up from Thug. Knowing Thug ain't going to be nowhere around, knowing Thug don't got nothing to do with this, and then say on top of that, Thug ordered him to do a hit on such and such. Slick, I'm going to say Slick because I'm sick of Slick. But like, you add pieces to a story to make it legit because such and such is finna go do whatever kind of play they going to do. But then I'm going to add something to it to make it seem like my story is legit. And they fell for it.
Yeah.
Can you hear me?
Oh yeah. Hey, how's it going?
Hey y'all. But I don't think he's going to cooperate. Like, he don't want to be on the stand, period. One. And then for two, even if the only thing that would be good for the defense is him saying that he was pressured. But him cooperating with them don't really help them none because all it makes them think is, oh, well, they really are in cahoots, or, oh, he really is part of this gang, and da-da-da-da-da. Like, it just makes not only him look less credible, it almost makes it look true that the defense was in cahoots with like his lawyer and him and all that kind of stuff. So I don't really think it would benefit the defense for him to cooperate. Like, I don't know. The only thing that would have helped them was for him to plead the fifth because they would have never got the tapes in. But to be completely honest, with the tapes in, he don't have to do nothing.
Yeah, I mean, when the tapes come in, I don't know what the tape's going to show or what the jail calls will say.
Talking for 18 hours.
Yeah,
just talking, and they're going to take from that what they want. Like, they might believe it, they might not. They might believe some, they might not. They might think he was telling the truth then and lying now. Like, you just never really know.
Let me see. I think Brooklyn NYC has a few questions she want to ask. I'm gonna mute the mic just so I don't have feedback. Let me see. You can go ahead, Brooklyn. Thank you for joining.
Hi. Well, kind of just had a question based on what the other young lady said. I forgot her name. About Woody's testimony. So, can you hear me okay?
Oh yeah. If you want to ask the question, and then I can unmute so I don't have the feedback.
Oh, okay. Yeah. So, if Woody you know how like if a witness says something and it's it can hurt the defense, they can, you know, maybe they'll object and they might either the judge might have to stop it or give a curative statement to the jury to disregard or whatever. But does anything happen if the witness says something that hurts the state in the same type of way or no?
And was you asking that to
you?
Are you asking me? Oh,
Yes.
I thought you were asking one of them. Oh, okay. I mean, I think Woody will help because if they play some tapes, then the jury might believe what's on the tapes. But if they play the tapes and then Woody get on the stand and say a lot about those tapes and that goes against the state, then I think, you know, then it will balance each other out. Is that what you asked, or is it a different question?
No, it isn't not specific to Woody, but I just brought it up because she made me think of it. I know the defense, they have, you know, the rights because they have the right, you know, they have to prove their innocence. Well, they don't have to prove their innocence, but the state has to prove a case against them. But if a witness says something, just insert the state where you would insert the defense. If a witness says something that you want to say, hold on, you know, jury, please disregard, but it's really hurtful that, let's say if it was a defense, it may cause a mistrial, but in this case, it hurts the state. Do they have those same protections or no?
So you're saying if the defense?
No, if a witness says something on the stand, an open court,
that causes a mistrial.
That could cause a mistrial if it hurt the defense. But in this case, if it hurt the state in some way, like their evidence, or they don't have the same protections, right? Do you understand what I'm asking? Like, would the judge just, you know, say disregard that or dismiss the witness, or does that? It's not a deal. It's not a big deal.
I mean, well, yeah, because it's kind of different because the state has the burden of proof, and the state cannot simply cause a mistrial because we have a constitutional right, a double jeopardy, where you can't be tried twice for the same thing. So jeopardy could attach if the prosecutors cause a mistrial, but if the defense, you know, calls a mistrial, then the only thing you could do is recharge them or refile the charges and start the case over. If it's bad enough to where the jury cannot simply ignore it. If it's something
the defense could cause a mistrial if their witness says something so egregious against the state's case, they can cause their own mistrial.
Right. If it's something that's just so egregious to where, to where it can't be. But the thing is, I mean, you're really not doing yourself a favor because, I mean, the state's not losing out on anything because all they have to do is retry you. So it's not like a not guilty or where it's jeopardy attaches and you can't be tried again. So it's no benefit to cause a mistrial.
No, like, let's say, see how like Woody has been so unpredictable. God forbid, you know, the defense has a witness, and this is just like in a horrible situation. And please, not this case, but just in general, you know, if the defense had a witness that blurted out something that they didn't expect. And I just wonder if the state had those kind of protections where the judge could say, "Oh, wait, hold on, stop."
Well, yeah, but the state is not similarly situated as the defendant is. I mean, the defendant has a right to, you know, double jeopardy, not to be tried twice. So the state, they're not in danger of getting tried twice or going to prison for life. So they don't have anything to lose per se. The only thing they have to lose is they have to start the case over again. And normally trials don't last this long. So starting the case over again may be a 2, 3, maybe a week trial at the most. So that's all they have to lose. But with a defendant, they have way more to lose because now you are infringing upon their rights to not be tried twice for the same thing, if that makes sense.
Yes, kinda.
Okay.
That's it.
Yeah, it's common. Yeah. It's a lot of legalese in there.
That's what you're here for. Okay.
Yeah. Thank you so much.
Bye bye.
All right. Thanks so much. India, I don't know what India has said. And India was kind enough to read for us a couple of streams ago. So thank you, India, for that. You had muted yourself. I can't unmute you when you mute yourself. Or
don't try to unmute me. I'm just joking.
Right. Anybody?
But I mean,
Like,
so I was listening to y'all, but I'm gonna be honest with y'all. Brooklyn.
She not up. Oh, there she go. Okay.
I think you were talking to me when you stated that. Like, I agree with you wholeheartedly in some things, but what I can say is that I think with the state directly, I don't know if their intentions are pure in this situation where it comes to be that they're willing to let this case go. Like if the defense did something to stir a mistrial. Like I feel like they're going to retry even if they did something. So the only way that this could not go on any further would be if the judge dismissed it and she has to do it to where they can't retry this case again. Because if not, Fulton County residents, please know that your taxes are going to double because they're going to retry this again.
Oh, yeah, for sure.
Fannie's going to ask for more money. She's going to fundraise. She's going to do whatever she has to do to get more money to try this case again. But go ahead, India.
Oh, I forgot what I was even going to say. But my whole thing with Woody and just the other defendants, not defendants, the other witnesses in general is anytime they make a statement, like it's up to the jury's interpretation. Like I'm pretty sure, just like how we interpret everything different, just us four up here see things and interpret them different. The jury's the same way. So while we might think, oh, it looks bad for the defense, or oh, they're not saying what the prosecution wants them to say, the jury could really believe what the state's saying, that they're scared and that they were threatened or whatever. You really don't know.
Yeah, that's true. And I'm not sure the jury pool in Fulton County, Georgia, but it's hard for me to believe that they can get 12. You might get a few people to go along with you, but all 12, I don't see that happening for the state.
Because I know people, like, I'm like, Thug and them's age, like, I'm that age group. I'm a millennial. But, like, I'm telling you, like, if they was to ask, like, my mom's age and them, like, they're the type that just kind of believe, like, they trust certain systems and believe them. Like, they'll believe, well, maybe not the cops, but, like, I don't know, they'll believe certain things. Like, they don't have the critical thinking that we have.
India, I have a question. So you don't make me feel old because now I feel old. What's your mama generation?
I think X. I was born in the 90s, so.
Okay. Never mind. I'm fine. Never mind. Okay. Go ahead. Continue.
But yeah, like the Gen X, and then like, yeah, I would say the Gen X, like they just don't have the same critical thinking or like the same maybe distrust in the system that we have, being a part of like the age of information, where we have more than just the news. Like we don't just watch the news. We could research and look up things for ourselves. Like we can critically think and like, oh, that doesn't make sense. Like I'm just not going to take your word for it. Whereas some of those older people, and some people just in general who just, I don't know, aren't critical thinkers, they just kind of will believe a person because it's a state or because it's the judge or because it's a officer or whoever. Like they'll just believe and trust in those people and believe what they say, whatever, still however good they are. Like they just automatically, come into it thinking, well, they wouldn't be here if they didn't do anything wrong.
Well, we're getting a lot of pushback in the chat from that generation. Now, speaking to that generation.
Oh, well, let me talk about just my mom specifically.
Okay, here you go.
It's okay, y'all. She's giving a broad aspect of what she was thinking regarding that generation.
Yeah,
She was
they
not
like,
talking about anybody specifically.
they like, wait, what generation?
My
What are you
mom
talking
is
about?
tech savvy, and she is in her 60s.
I'm
late
born in
60s.
'70. That's
So
not
you have
true.
some
We
people
trust
that are
less
not
than you are.
tech
Oh, I was
savvy.
thinking more of born
That's it,
60s.
girl. What?
I was thinking more of people born like 60s and prior.
60 and
So I
prior.
guess that's like what boomers.
She's
Wait
saying
a minute.
60. Hold on,
Wait a
wait.
minute. So you saying your parents are born prior to 60?
My mom was born in
No,
60.
like right at 60.
No, my mom, sorry, was 56. I apologize. And
No, you said what?
My mom was 56, 1956. She's older. But
Yeah,
she's
mine was
tech savvy.
59.
Yeah, they was like, hold on now.
Okay,
Hey,
y'all
y'all.
relax.
Right. They said, okay, safe. You the touch base. You safe now.
Look, all right, Deborah, go ahead now. Listen, y'all, she is not saying that all of our older generation people are not tech savvy and they agree with this. But you have some people that have that mindset that they're stuck, that the state is actually right in a sense, because they look at it from the government standpoint. The government is here to help us, protect us. But sometimes the government doesn't have our best interests at heart. And the sooner people learn that, the sooner they'll be more informed as to what's going on in the world, because you don't want it to be when you get in a situation or somebody in your family gets in a situation that you understand that the government is not here to protect you, because of the simple fact that even in Love's argument today, where she said in her motion that she didn't want them to victimize the victim or mischaracterize the victim of Nut, but she mischaracterized him in the statements that she made about him. Like, how do you say that somebody is the largest gang member and he was the head of If Gang and he's not committed any crimes, but then they're characterized in their trials as the same thing YSL is? So what's the difference? He's probably done some hits. He's done something that, they're going to say that he did. And now you're trying to suppress it because you want to gain sympathy for the victim. But then even having his mom get on there and act like she was oblivious to what her son was doing is dangerous, because you're going to act like you don't know. Like, talk that long. How did you feel about Nut Mama getting up there?
What did she say, God? What did she say the letters meant? What did the shirt say?
The who?
There was like some shirts or something he was selling, and she said it meant God something. I was like,
Something
now,
like
ma'am.
God first or something.
Yeah,
The
like,
lies that
ma'am,
she
cut it
tells.
out.
The lies that she tells.
Cut it out.
Yeah, so well, yeah, I mean, I wouldn't, and I know you limited to your parent, but yeah, they a lot of them, they don't put nothing past the police just because they're the police.
But they're more trusting in the government.
Yeah, I don't even know if that. Yeah,
Todd articulated what I was trying to say perfectly. Like, she articulated it well, because that's what I was trying to say.
I got you. I think Brooklyn, New York City, NYC, was trying to come back up, but I don't know what happened to her. Well,
and I had a question for you. I put it in the chat, but I don't know if you've seen it. How do you think they're going to, like, what do you think they're going to say to the jury when they bring them back? Like, what are they going to say? It's a whole new set of people.
Yeah, that's going to be wild. I don't even know, because this is unprecedented. I don't know what they'll be able to say that's not going to, move the jury from their neutral spot. I mean, are you going to say that the judge was found to have engaged in misconduct, or the judge was recused for an undisclosed reason, which will make them more curious as to search and see why he was kicked off the case, if they haven't already? I mean, I don't know what they can do that's going to be in the best interest of the trial, for a fair trial. So I know the judge, she's trying to hang on to it. I don't know if she's trying to build her career off of presiding over the longest case in Georgia, but as most of the attorneys was telling her now, it's not going to work.
And also, she didn't mention if she was going to, what is it called when they question them? Like, voir dire? Is that what it would be called in this situation too? Like, are they going to come back and ask them like, has anything changed, or if they heard anything? Like, are they going to question them upon their return? Because I noticed that she didn't mention anything about that.
Well, they're going to still be meeting all week. So I don't think the jury is going to come back until August 5th. So, I mean, she'll have 4 days to address that. So I don't think there's nothing that needed to like be said today. So what, 3 more days? Yeah, Wednesday, Thursday, Friday. Yeah. But I mean, I'm sure they're going to ask them something as far as how much have they been exposed to. And I'm sure it's a lot. I mean, it's been over a month and a half. If they didn't look it up themselves, the family member, somebody told them. I mean, and they live in Georgia, so I'm sure it's even pushed more down there in the news cycle, the news media, than it is in the other states. She said, I'm going to stay in the background. She said, y'all realize how many motions they did today? Glanville would have needed 2 weeks. Yeah, for sure.
We probably would have only had like 1 and like 5 or 10 breaks today.
Right. She is moving. She getting through all of this stuff.
Listen, it was at least 11 or 12 motions that she went through today. She referred 2 of, I think 3 total. But she still went over them. She didn't allow them to over extenuate themselves. They weren't able to keep coming back and readdressing the same thing over and over again. She was like, that's not what I asked you. Like, let's stick to what I asked you about this specific motion, not letting them gauge on to something totally different. And that was with both the state and the defense, I feel like. Because they both would.
Yeah, I love the efficiency.
Yeah, I mean, at first, we're still kind of like, okay, why didn't you entertain the bond motion more thoroughly? But she still was getting on Love. And I think that gave us a little satisfaction to know that Love is not getting away with the same stuff she was getting away with in Glanville's court. Because I'm sure her and this judge are going to butt heads eventually. But Love is trying to tread carefully right now because right now it's still under advisement. The judge is still considering whether to kick off Love and Hilton. I think she said she will decide that tomorrow as well. So, you know, if Love get the popping off today, then that might influence the judge to kick her off tomorrow. So that's why Love was kind of like, you know, I'm not going to go off on her. I'm going to keep it cool. But just know that Love gonna remember that.
Well, I hope she know that none of them is ever going to endorse her to run for office again.
Oh yeah.
As long as she know.
And might even go a step further, not only not endorse her, but actively put somebody up against her to campaign against her for her seat. Or maybe even I've seen it happen. Get a DA out of your office, out of the DA's office, and have that DA run for judge.
Okay, can you pull up Karen is my name's comment?
Karen is my name.
I'm just jumping into your feed. Have you discussed a Love? And Love said she didn't know if the sealed transcript from the ex parte Friday, wherein she requested the hearing. I didn't hear that.
I don't think it was sealed. It was just a transcript from Friday when she requested it at the end of the day. And I guess the court reporter did end up taking it down. Y'all remember? At the end of the day, and she told the judge, I would like to discuss the ex parte matter on the 7th, but they didn't have the actual ex parte until that Monday.
Oh, okay, so she didn't have it.
That was that transcript that she passed out at the end of the day. It was a transcript from Ms. Weaver for Friday the 7th.
Okay, now then I have a question. So, in a sense, with the state, right? How is it that the judge didn't entertain the possibility of it was like she didn't entertain the proposed motions for bond with the reconsideration, but then entertain like Love's motion for like things that were already like they already went over. Like I feel like that at some point she's still kind of teetering on the line of, you know, wanting to like stay away from the Glanville situation a lot, because she keeps saying like, okay, well, he's not a part of the case anymore, so it doesn't matter. Not disclosing Brady material does matter, even if it's given to them like after, correct? Like, is there still a cause for a mistrial?
But what she's trying to say is it's not Brady anymore because they have it before the trial is over with. So long as they get it before the trial is over with, then.
Okay, so it doesn't matter when they get it; they just have to get it. But is it not a problem that they got it and they tried to conceal Brady evidence? Because isn't that the same thing that happened in the case against Alec Baldwin?
Now that might be an ethical situation right there. As far as if they're breaking the rules or they're hiding evidence, then they probably can file a bar complaint. But what happened with Alec Baldwin?
Alec Baldwin, you know, they withheld evidence from like the guns, the bullets that they received from the other guy, and they didn't file it under.
It was under a separate case number.
The case. So they put it under another case name and log. So when the defense asked for all materials or all evidence regarding the case, they sent everything except that. The defense ended up finding out that the man gave them the bullets and then brought it to the attention of the court. And then they dismissed the case because they withheld Brady evidence, like evidence that they would have needed. So she said it's no way she couldn't give any curative instructions. She felt like the only way that it would like satisfy the court was to dismiss it, and they can't retry him again.
Yeah, I think from my understanding, some guy took some bullets to the police station and said these are the bullets from the set, and they never turned those bullets over to the defense. And that judge she wasn't going to play. If you didn't turn it over evidence, now she could have said turn it over now, and let's go forward. But she like, y'all withheld evidence. Now the defense won't have time to hire experts to test the bullets and all that stuff. Is going to delay the trial. So she said, for y'all hiding it, I got a trick for y'all. I'm going to throw the whole trial out. See, them the old school judges like that. They don't play. This judge here, she's dancing around, trying to please both sides. And she's trying to wrestle a case that's too far gone. So I don't think that's going to happen as far as, even if she do get a conviction or the prosecutor's get a conviction, I doubt it's going to last. India want to jump in? India had a comment.
Oh, about Alec Baldwin?
Yeah.
Oh, yeah. Well, the judge, if you watched it, everything kind of changed. Like the judge, basically, you could kind of almost see when she changed her mind, but it was because she viewed it as intentional. Because apparently there was some meeting. Basically, the DA knew that she knew about those bullets, and I believe she even knew that it was going to be filed under a different case number, because when the crime lab lady was up there, she was like, yeah, there was a meeting, something, something, something. And then they asked her, I think the judge had asked, somebody asked her, was the DA in that meeting? And the DA was in that meeting. So it was like, you knew. It wasn't like the lab took it upon herself to put it under a separate case number. The DA knew that. So the judge viewed that as like basically being intentional. Like you intentionally did that, which is also why the other prosecutor recused herself, because she was just learning of that and she didn't want any parts of it. So she recused herself.
Okay. So I guess
she requested that. She was right. India's right. She requested that happened.
So I guess we can distinguish between the YSL case. It wasn't quite egregious because what they were requesting was the transcript. And at that point, the judge had not released the transcript. And he released it before the jury came back. So now the lawyers have a chance to cross-examine Woody based on that transcript. Now, let's say Woody already testified and Woody out the country and we can't get him back. I think that's a problem. I mean, but so I guess there is distinct differences. But if the prosecutors intentionally withheld it in the Baldwin trial, then I think the judge is right. I mean, you were really, I mean, that's illegal. I mean, if they filed it under a different case on purpose, which really goes to show maybe they thought he was innocent the whole time, or they knew that the defense could have used this to their advantage, but they still wanted to put him in prison anyway. So that's why you got to watch, you know, certain prosecutors. And just because somebody's on trial, that don't mean that they did something. It could be an overzealous district attorney that's trying to make a name for themselves. Somebody said, how long has a judge been a judge? I believe this one was 2017, Judge Whitaker. Private. And normally, see, Miss Lavonna said, I never said Thug Brother would testify. I only said he took a plea. And then she said the man took a plea, and in his plea that he has to testify. Well, we don't know.
I never was making the argument that the man was going to testify. I was just saying that they had other people that testified against him. It wasn't just Woody. I don't know. They can get on the stand and say, I don't recall, just like Woody. I was just stating what, I wasn't making a point.
And now we're even seeing that even though Gunner took a plea deal and said these things, why still a gang? Apparently, Young Thug's dad was out at one of Gunner's concerts. So it's not like Gunner and Young Thug are, beefing with each other because of the plea deal. For all we know, he probably was given the okay to take a plea deal. Thug's brother probably was given the okay to take a plea deal. But the thing is, they took a plea deal to avoid going to prison, but then to get probation. But now his probation is revoked, and Young Thug's brother's in prison anyway. So I don't think that plea deal, is valid now, because the plea deal was to stop him from going to prison and to get probation, but he messed up on his probation allegedly, and now he's in prison. So I don't think he's going to hold weight to force him to testify. Somebody said,
I don't even know if they made him testify. I just seen the deal. Yeah, I don't.
No. I know everybody get passionate in their arguments. I'm not mad at you, Miss Lavonda.
Oh, I wouldn't be worried about that. You got.
I know some of the chat was getting ready to light you up.
No, they ain't getting ready to do shit. But we want to keep this. I'm not doing nothing to them. They making the sideways comeback, and I'm a fighter. I'm going to throw my jabs back. When you say stuff about uneducated and all this stuff, when we don't know each other, we just all up here voicing our opinion. That's all it is your opinion.
I think they just took exception to when you said how you supposed to call yourself a lawyer and you don't know what you're talking about. I think that's what they took exception to.
Okay, but they don't have the right to. You do. If you take offense to it, but they don't have the right to take offense to it, because at the same time that they defending you and they say something out the way to me, I'm going to defend me. I was talking to you.
Somebody said we must protect the tree of law.
Okay, well, as long as they type their fingers and say something directed to Levita, Alizé, Miss Jenkins, Vaughn, or Shell, I am going to respond. If you have the power to put me off of your channel or tell me to go. I'm not paying attention to them. I'm up here to talk to you, but I'm also looking in the chat. So if something is said about me, I'm going to respond.
So you're not paying attention, but you're reading it. You know I'm gonna give you a hard time.
No, don't give me no hard time, because I still say whatever I want to say until you put me off. So,
and to be clear, I didn't put you off earlier. You had got off.
I know I said that. I said they did.
Oh, okay. I was just making sure.
Accidentally pushed done.
Oh, okay. Yeah, we good. What you was gonna say?
Ty is a little instigator. She don't know what, girl.
Listen, I'm just laughing at y'all. I don't want to laugh. I'm trying to be professional. I don't want to laugh at y'all. Y'all know, y'all can't get when she said Bon and shit.
Right, I don't know who is what. I don't know these people. Who is Bon and I don't know.
Lavita steps in for Lavonda. Shell is there for Michelle. Alizé drink that dark. Miss Jenkins try to keep everything on pocket, but she always say go. And then you got that bitch you got that girl Bob. She don't even care nothing about. I changed it.
Now you see,
it.
Now when my editor come through and they crop this part out, you gonna swear I don't want you on my camera, and I took you out.
I said you slip up sometime too. That's one time. Don't.
But that was a heavy cuss word. That wasn't no light one.
Just put some beats over it.
But back to Vaughn, that's the one that want to go to jail. That's the one want to be thugger.
So they all got different personalities.
All of them.
Auntie outside.
Okay. Now I don't want you to skip over. If somebody had wrote something to you, taught that law. It was a paralegal. Somebody, she asked, "What are you discussing?" So answer her question, please.
Let me see. Brooklyn NYC FY at the end of the court. The judge handed out the transcript. Okay. No, we're just talking about the trial and everything that happened today. Where'd she go? I don't know where she go.
Who? Oh, the lady.
Oh, Brooklyn. Wait, who was it? Oh, the paralegal Barbara. Well, y'all discussing. Thank you. Let me bring back up. She popped back up. Brooklyn NYC. Hey, you want to add something else?
No, I was just sending you that information. No, I'm just in the background. I just wanted to send you that information. He handed it out at the end of court, so I didn't see it on the video or on the stream. The meeting that Ms. Love referenced this morning about, she said, "Oh, we don't know if it was there was a transcriber there. I mean, not a transcriber, a court reporter there, but we don't know if it was the details have been taken down." Remember, she was fumbling over it,
right.
And I got the information, and so she handed it to the judge, and the judge handed it out to everyone in the courtroom at the end. So
what was it? It was just basically saying that her requesting the meeting that happened that following Monday.
Supposedly it was the details of it. I don't know. It was handed out. It wasn't discussed. I didn't see it, so I just.
Oh, got you. Okay.
I just that I don't know if it's something that's going to come up, or if that's I don't know if that's public or if that's something internal, but it was right at the end of court.
Okay. Well, maybe it'll circulate.
Yeah, I'm curious that is what that meeting was about.
Well, thank you for that.
Okay, sorry. Bye-bye.
No, you okay. You're good. He said it was a rough drive of the side meeting with Woody. The rough drive? What final copy? We need the final copy. Yeah, Love has calmed down a whole lot. The paralegal Barbara said the state has not met their burden of proof, in my professional opinion. Y'all heard what she said. Thank you, the paralegal Barbie.
Would you trust love
Yeah,
to prosecute a case for you? If somebody did something wrong with you, would you ask her to be removed off your case if she was prosecuting your criminal, the criminal that did something to you?
see
You
what
think, I say, do you think, I meant to say, do you think she that unethical that you
yeah.
wouldn't even want her to?
Yeah,
Dang.
exactly. Because what happens is when you start cutting corners and crossing lines, now could possibly have messed up the whole case. Now Donovan Thomas' family may never get justice because she didn't want to do it the right way. She wanted to take the shortcut.
Mm.
So I wouldn't want a prosecutor like that. And now she done gave these people false hope. Probably for the last 2 years to 2021. Oh yeah, we got them now. We're going to trial. We're gonna get them, and they've been coming to court, sitting in the courtroom every day, waiting for justice. And now they sit up there and look. Now we got a new judge. Hilton gonna be out. They're probably gonna have a new lawyer. The jury been gone. The jury's turning against the state. They haven't even been getting paid while they were on a break this whole time, even if it was only $25 a day. So now all of a sudden, the jury's supposed to come in and vote a guilty verdict after all this happened. I don't see it. Talking about they have 100 witnesses left, they can have 1,000. And I don't even think the judge is going to let them call all those witnesses. She want to know every witness that's left and what are they testifying to which counts. And if she find any duplicate witnesses in there, I think she's gonna scratch them out. So this trial could possibly be over soon.
So she, meaning the judge, because earlier you was like iffy about her. So as long as she do everything that you feel she should do, she all right. But say if she don't throw that out, the trial shouldn't go on then.
Well, I don't think this trial should go on anyway because it's too much has been done and said without her being there. So she just trying to jump in the middle. And I know she made the analogy, if it's a sports game and a new referee comes in, well, yeah, a new referee can come in the middle of a basketball game or in the middle of a football game. They don't need to know what happened in the first quarter, second quarter. But in the case in the courtroom, you have to know all the stuff that happened in the past because it's going to apply to future stuff. So it's not as easy as bringing in a new referee. And I know she's trying, but she ain't over her head. And in her mind, she's probably thinking, I'm not going to give these guys a bond. They've been in jail for 2 years. They can last one more month or two. And it's probably easy for her to say because she's not sitting in that Fulton County jail. But
I'm sorry.
No, I was going to say it's still good, though. I mean, all is not lost. I mean, because not granting a mistrial could be a good thing because the jury can find them not guilty and then it's done forever. We don't have to wait and go through years of appeals. The jury can send them home, the next month or two and it's done forever. So by her not granting the mistrial could be a good thing in and of itself without anybody even realizing it.
Mm-hmm.
What were you going to ask me?
It's just hypothetical because we seem to be, it's hypothetically. So let's say Judge Glanville, knock on wood, had a stroke and he was out. Because we know what happened, does that make it any less that court can go on? Because remember, the judge is not making a choice on their guilt or their innocence. So by her coming in and taking up from where they left off and quote unquote making the things right, why can't she go on with the trial? It's just like you having to substitute out a lawyer, and then I'm gonna be quiet.
Well, I was gonna say, one of the lawyers, I believe it was a lawyer, the attorney Harvey with the ponytail, and he made a good point because at the end of the state's case, the defense attorneys have a right to ask the judge to enter a finding of not guilty, a verdict of not guilty. Basically, what they're going to tell the judge at the end, all the defense lawyers will go to the judge when the state's case is over and say, "Hey, judge, the state did not prove each and every element in their indictment, so we want you to find our clients not guilty without submitting it to the jury." And the only way the judge would know if the state proved each and every element of their indictment is by being there since day one, not after 100 witnesses have testified. So what they're saying is the judge won't be able to enter a finding of not guilty because the state hasn't been able to prove each element of their counts. But the state could have proved that, count one with the first witness. They could have proved count two with the second witness, but the judge wasn't there for that. So I think he made a good point saying that the judge won't be able to enter a finding of not guilty on the defendant's behalf because she wasn't there to know if the state proved their case or not.
So now that you said that, I will go ahead and finish, but I want you to answer my question regarding that situation. They said something regarding that, saying that she wouldn't be able to judge if they wanted to do the 13th jury instead of sending it off to the jury, that she would have to decide if the state has proven their case. Was Harvey correct when he said she wouldn't know like what would happen, what has happened in the past, even like with going over like video footage or whatever? She couldn't accurately rule to see if the state has proven their case, or would it go into appeal as that being an appealable option because she made a decision saying, let's say that it doesn't go to jury and they ask for that 13th juror, and she makes the determination that the state did prove their case from the information that they received during this part of the case, but then she couldn't consider the beginning because she wasn't there, or she makes speculation as to what she thought was this person's findings or the reasoning behind it.
Yeah, I don't think it's going to be able to work because, he was right. She wasn't there. So there's no way she's going to be able to just to pick up. And people think that she's a referee. Yeah, I know she's a referee. I understand that. But she's not only just a referee, she can make a decision to find them not guilty. And that's what the lawyers were arguing, that she can find them not guilty single-handedly by herself. But in order to do that, she need all the evidence. I'm gonna mute. There's an echo. Oh, there we go. Yeah. In order for her to do that, she would have needed to be present since the beginning. Now, let's say the court reporter. I had a trial, and the court reporter went missing, and they were looking to try to bring in another court reporter. And I don't know what happened with the court reporter. I don't know what they said. I don't know if she was going through something or whatever the case may be. And they were bringing in somebody else. That's okay, because the court reporter is not going to make a decision at the end of trial if my client should be found not guilty or not. So you can bring another court reporter and they can just start taking the notes, and then you can just add their notes to the notes of the old court reporter. But in this case, with a judge, it's not that simple. And needless to say, the court reporter ended up showing back up the next day, and we kept the trial going, so we didn't have to bring in another court reporter.
Because isn't that like at the end of the is that when the prosecution rests their case or when the defense rests their case and they do the motion for a directed verdict? Isn't that what Harvey was talking about?
Right, correct. Well, the prosecution cannot do a directed verdict.
But is it after? It's after the defense rests their case?
No, after the state.
Okay.
Yeah. So after the state rests, you can just say the state hasn't proved their case, and then you ask the judge for a directed verdict. Basically, what you're saying, telling the judge, we don't have to put on a defense. The state didn't do enough to meet their burden. They didn't prove the elements of their of the indictment. So we don't even have to put on a case. You can find our client guilty, not guilty right now. Now, the state cannot do that. The state cannot go to the judge and say, hey, can you find him guilty? because then that'll violate the defendant's right to a jury trial. So it only works one way. Directed verdict only works for the defendants, but not against them. And what they're telling the judge, you wasn't here. We can have a good shot at a directed verdict, but you would have to guess what you thought happened in trial the first 9 months. You won't know for a fact. Well, not 9 months when it actually started. But yeah, that's why she gotta go. But if she stayed, we have to deal with it. And I mean, I doubt they're gonna ask her to recuse herself.
Y'all catch that word will. You on the defense side. I thought you wasn't biased.
Wait, what you mean by?
You said we'll have to deal with it.
We'll have to deal with it.
That's what you said. I was being funny because that's what Judge Glanville said. We need you to testify. So when you said we'll deal with it, I was being funny.
Oh, I'm talking about, we as in the watchers. Like we don't deal with we got to deal with the trial. If she gonna keep going, we just deal
right.
with it.
I was just real. I was being funny because the Glanville said we need you to testify.
Well, Glanville said we because he was part of the prosecution team.
Talk that law. Amber said, is she required by law to go back and review previous testimony and evidence?
According to her, she said she's not doing that.
She said she was doing that, and Harvey kind of misinterpreted her.
She sure did. She said she wasn't going back over the
rulings.
rulings.
Said that she wasn't going back over his rulings at all.
I'm gonna go find it.
The rulings, but she said she was going to catch up, do her homework. She already got some of the transcript. She already seen some of the YouTube channels. She gonna go back and look at all the testimony and catch her up as she presiding.
But
she said rulings.
Yeah, she did say that.
But if we recall, some of the witnesses wasn't even on camera. So how is she going to go back and be able to judge that person's demeanor and when they testify if she can't even see them? Like Harvey said, dry reading the transcript is not the same thing as watching somebody, their body language. Are they telling a lie? Are they looking up, looking down? You can't see all of that with a transcript.
And I have another question too.
Oh, yeah, go ahead.
So you know how she said how they had all these motion and limines and all these evidentiary rulings happening throughout the trial, and that was basically going to stop. So they're going to have to do all of that. Do you think the jury's going to be back on the 5th? Because
I think so.
Seems like they have a lot as far as the motions, as far as what evidence is coming up. I still feel like they have a lot to get through, because she said she's not doing how Glanville was, where it was kind of as they went along and when we get to it, we'll cross that bridge when it comes, all that. She's not doing that.
I think
that's
so.
That's why I like her.
But she's moving pretty quick.
Because the motions is done now. She moving into the evidence.
You're right.
She's not playing with them, not even with love, and I love it. She is not playing with them.
It's a few outstanding things that she said she's going to consider tomorrow, but that'll be easy. She come in the morning, make a ruling, and to get them out the way quick.
And she told them, you better do some homework. If y'all can't talk, you better email. She not playing. Hey, and she already went up for this, what is the highest court again? The Supreme Court before. So this her audition.
Oh, I didn't know that. She tried to run for the Supreme Court.
Yeah, she did. She ran for the Supreme Court before.
And this was the part where you say, how you a lawyer and you don't know that?
No, see, there you go. I was being funny the last time.
I can't know everything in Georgia. I got to keep up with Texas. In my own clients. But for real, though, I didn't know she was trying to run for a higher court, but she can give this one up. Somebody was going to say something.
I like her temperament. I like her.
I like her too. She is no nonsense with both people. When she got on Love, she said, so are you meaning to tell me, and raise that voice? I'm like, she is not playing.
You see how she told Brian Steele? Brian Steele said, I don't talk to, lawyer Love. She said, well, is there anybody over there you do talk to?
Miss Willis.
Yeah, I think he said Miss Willis.
Yeah, I had to screen record that. That was my favorite part of the day.
That was funny.
And when she said, please take your candor to the court more seriously, like basically calling her a liar. Like, who do you think you're talking to? Like, they're all lawyers in there. Like, cut it out. Like, and Glanville was letting her get away with that. Like, she's not an amateur. Like, what's going on?
Yeah, the judge, she's shady too. Don't think she ain't slick. She know what she doing.
What she slick about? She getting on Love about all this stuff that we all saw Love getting away with, and she's correcting it.
Well,
what else can she do? She still, like you said, talk that law. Just because Love went a little bit crooked, and it was crooked enough for it not to her not to get caught, basically. It shouldn't be held against everybody. I think that judge came in and she's showing that she's willing to be fair and impartial.
Yeah. I mean, yeah.
We ain't never seen, we haven't, I said ain't, we haven't never seen Glanville even stick to, he was just his ego. I can't say nothing about being a judge because I don't know, but his ego, like Love, all of it was out of control. The
They was too
yelling,
emotional.
you see, they wasn't yelling like that in there. That lady, no matter what she ruled, they tried to talk, but they shut up.
Yeah. I mean, she's running her courtroom. I just hope she's not being influenced by outside opinions, because that bond motion seemed like it was dead on arrival. She didn't really want to hear too many arguments on it. But
I agree with what you said before about how she's not really planning for this to go on much longer, so she don't really, but I don't know, because I didn't agree with there wasn't a change in circumstance, because if this ain't a change in circumstance, then what's a change in circumstance? Like, I'm confused.
But that's
nothing
something
apparently.
that's something you lawyers have to file for, because they got the IOLA rule. So that stuff that matters to us, like you said, it doesn't matter in the court of law. That's just our public opinion. You've been saying that the whole time. It doesn't matter what we know is what you can prove. They need to change. They need to change the rules. You can't just make them change the rules for Thug or for whomever. You have to go in there and change the rules and make being able to afford that bail a factor.
Yeah. Jason Garrett said it's going to be a mistrial with prejudice. That's why she's not granting bond. I don't know about that one. Jason, we'll see. I haven't seen it. Miss Lavonda, you got a hamster?
No, that's my son playing. I mean, my dog playing with his little toy thing. I'm gonna turn it close.
Oh no, you're all right.
I couldn't even hear it. I tuned it out because he be going run it, turn that living room up. But I'll close the door and I'm on mute. I'm sorry about that, chat.
No, you're all right. You're all right. I was just trying to figure out what was that squeaking noise. Oh yeah. YSL still is bringing the heat on the DA, where the judge is more listening to the defense today. Not only that, let's see.
They were able to get their motions out, the defense was, because Glanville will always cut them off. It was so annoying.
And I believe attorney Matthews had made a argument similar to this, the paralegal Barbie. And the paralegal Barbie is basically saying, Judge Glanville was crooked at the end. Who's to say that he wasn't crooked at the beginning? And that's what the Matthews attorney argued when he was arguing for bond. He said when he was arguing for bond, he had no idea that Judge Glanville was playing for the prosecution team. And that's why his client didn't get a fair bond hearing the first time. And now that they know what they know, that Glanville is a prosecutor, behind closed doors, then this judge, Judge Whitaker, should have gave him his first fair bond hearing because Glanville didn't do it. And Black Butterfly said he had an excellent argument. Yeah, I liked his argument a lot too. The only thing I would have added was the cost to house the defendants. I mean, that's kind of irrelevant. I think the judge jumped in and said that was an improper argument. But, you know, him being locked down 23 hours a day, Judge Glanville playing for the prosecution. The trial was extended through no fault of the defendants. It was extended because the prosecutors went in the back room and requested an illegal meeting that the judge granted. And now Young Thug and them have to sit in jail an extra 2 months because of what the prosecutors did.
But see, people can also flip it and say something the defense said, because when they came back and said the judge did nothing wrong in that case, but I'm gonna go ahead and take them off. Then all this stuff started. They really was hoping for a mistrial. They thought that was the thing that was gonna get them a mistrial. They drug this on just as fair. We have to call a spade a spade. Brian Steele has been in there with antics just as well. Screaming, hollering, jumping up in his seat.
But then he delayed the trial by 2 months.
Yeah, by filing all them unnecessary motions they got denied.
Well, those are not
the
necessary.
Same motion saying the same thing, all in hopes for a mistrial. One don't want a mistrial, the other one do want a mistrial. But I adopted. They played games with the motions.
Well, that's what happened when the state want to try all these defendants at one time. Then you're gonna have lawyers that don't agree. But as far as the mistrial itself, I don't think that Brian Steele he didn't have a secret meeting with the judge that delayed the trial for 2 months. If anybody delayed the trial, it was Glanville with these long breaks and these vacations and whatever else he be doing. Now we speeding along. Now we moving. So even though the judge didn't grant, no, I'll say even though she didn't grant bond, if she's willing to push the DAs to get this case over with, then you know, that's the second best thing that could happen.
Yeah, the best thing she did today is when Love said that she was gonna give her the discovery 2 weeks prior. She said, "Oh no, we not." She didn't put no blame. Said, "I don't know why the judge didn't allow this. I don't know why this." She said, "No, we're not going to do it that way." So I think she's going to be as fair as possible. And again, you saying I'm side with, I want them to lock Thug up. That is such a unfair statement. No, it's not. That is an unfair statement. I am saying, just like you, I am looking at the law. So you're telling me that it's crooked. Everybody else can have their opinion that it's crooked, and I'm not knocking that. But I'm also looking at the court of law. So now we got Glanville out. We got this new judge in. If she didn't find that they did anything illegal, she didn't throw the case out yet, she still made them all. Then why would I believe that it's crooked? Or that I shouldn't believe the prosecution here, there, everywhere? Because if it's corruption, it's not just going on with that prosecution, and this show ain't just going on with the state. It has to be going on with the defense too. Like, you don't think defense lawyers know when their clients are really guilty, and they have to go in there and present the best defense?
Irrelevant.
I know what you're saying. I'm talking about if we're giving just public opinion, if we're not going to rely on the justice system, infallible as it is, we still have to rely on them. Everything we're doing is just public opinion.
But Nelson says she agreed with Yolanda. Who is Yolanda? Hold on, let me scroll up. Or is she talking about you?
I think she's talking about Miss Lavonda.
Oh, okay.
Dang, it ain't like I'm saying nothing outright. Oh, talk that law. You
no, she said she
agreed with you.
She said she agreed with you.
No, I'm talking about talk that law. He act like somebody agreeing with me is just so. What's that word? Asinine. What's that word, y'all? That little girl. I ain't mean to call you a little girl. She know, but I keep trying to tell you, I'm just looking at the trial.
No, you're all right. No, she said Yolanda. I was trying to figure. I thought I missed the comment. I'm trying to scroll up. Y'all funny. Oh, she go. See, look, even she said I was confused for a minute too. Yeah, so it wasn't just me. Goodness. You thought I was being throwing some shade in there. They couldn't have possibly been talking about Miss LaWanda.
Right, not her.
Nah. Oh man, that's crazy.
But let me ask
She
you a
said
question. Could the judge make a decision that this is not a RICO and you need to because she come in and step in that, like, what is her authority?
To be the referee.
Yeah.
Okay,
Yeah, I
so
think the
she can't step
referee.
in and say, well, this is not a RICO charge.
No,
It's
and
too
I think the most she'll be able to do after the case is over with from the state, then she can say, okay, I haven't met y'all verdict and find them not guilty with what's called a directed verdict, where the judge makes the decision. But yeah, right now, yeah, she can't. Her
Okay.
hands are tied. Yeah, I mean, it's an indicted case, so the state has a right to at least try to prove their case. And right now, they still have more. I think they said 100 and something more witnesses. So it'll be premature for the judge to try to throw it out when they still have witnesses to prove that it is a RICO case.
I think she's going to definitely cut down that witness list, especially with the quote unquote experts. Like, I think if she doesn't throw them out completely, she's going to limit their testimonies to where they could only be like the fact witnesses for like the crimes they investigated. But I don't think she's going to let them come in as experts over and over. Like, because they're all saying the same thing.
Yeah. Yeah, I agree. Judges do have the right to exclude testimony that's like repetitive, cumulative, it repeats itself over and over again, and it's a waste of time. Oh, look, somebody put it, yeah, black butterfly. Y'all see, y'all own it. Y'all know these terms. So yeah, it's a rule, and most states have it because most states adopt the rules from the federal rules. And it's Woody and Triple Play son driving. So when that happens, oh, you talking about when he was in that black car? When he tore up that I don't even know what kind of car that was. Hellcat, Scat Pack, all that, whatever they call it. Yeah, she want to know what are they going to testify to? What witnesses are going to say what? Because it don't take 100 people to say the same stuff. Now, if it's individual crimes, if it's two, let's say it's two separate crimes, two separate witnesses, okay, that's perfectly fine. But you don't need 10 witnesses for the same one crime. Just get the alleged victim in, maybe a police officer, to say what he seen, he put up on the scene, and that's it. Move on to the next one. You don't got to bring in the witness, the police officer, the dispatcher, the 911 record keeper. I mean, now you're just getting way out of control. Just get the meat of every alleged count, and leave the rest. Yeah, still would bring up the Hellcat at Woody with a pocket full of money. See, I don't know. Woody been, making his rounds.
He been turning up.
And I mean, I don't see nothing wrong with him making legal money. If he's going around doing interviews and he's promoting products for his social media, marketing and stuff like that, I don't see why he can't enjoy the money from that. I mean, he can't go back to work. He can't get a regular quote unquote job because he may be called in to testify any day. And now it's looking like Monday is when they're going to call him back, the 5th. Which is going to be wild. I mean, because now he's been out for so long, he almost feel like a free man. So now when they try to question him. He's not the same Woody that was trying to get out of jail. You know, a lot of people didn't know about him. He went to go see his daughter. Now he got a pocket full of money. He got notoriety. He already celebrated his daughter's birthday, so he's good on that. Ain't no telling what Woody might come in there and say. He might be on go mode. We thought he was being smart with D.A. Hilton. But I don't know what other prosecutor will be able to question him besides Hilton.
I think Atkins could do it.
But my thing, I need to find out, like, Hilton, what do you have to do?
She's going on vacation.
But trial has been stopped.
That lady asked him, was anybody going on vacation? This better be you better be having surgery, girl.
But trial's been paused for a month and a half. She could have got all that out the way before when the trial getting ready to start.
Yeah, because the judge had, oh no, she said if the whole team was going to be gone. So I guess it's just going to be her.
But the thing is,
I just found it funny how the defense had asked, well, during, not the defense, during the ex parte, Kayla had asked if they could bring another witness before Woody, and they told her no, but now they wanted to put him out of order. They could have did that the whole time. But now, I don't know. They want everything to go their way. Like what they say.
Yeah, they want everything to go their way. But my thing is, Hilton could have been gone. Love been doing all the talking. So Hilton could have moved up her, whatever she got to go do.
But she gonna have to change hers, just like she gonna have to change it because that judge and Brian Steele already, Adams already rejected to putting another witness in Woody's place because he has the right. You didn't let us do it. And then number two is you can't legally let one. Now, if she was dead, knock on wood, but you can't just let another prosecutor start prosecuting her.
Right, and I believe that
him.
Adams just didn't want Woody to go out of order, but he didn't object to Hilton leaving. I think that was Weinstein that objected to Hilton leaving. But I get it, because what will happen is if Hilton has to go and the judge saying, okay, it can only be Hilton, then we will have to wait possibly until after August 5th. So that means the jury will be out an additional week. And then on top of that, somebody had already gave them the week of the 19th off. So they're going to be out the week of August 19th. So we're going to be in September. So that's why I think Adam said.
But she didn't rule on it, because I think she going to make them rearrange. She didn't rule on that, did she?
No, she didn't rule on it yet, but that's why I think Adams, they didn't object to her, somebody else questioning Woody. If she got to go, they said let her go. But the thing is, Weinstein is objecting to her leaving or objecting to somebody else questioning Woody.
Yeah, that's why she said, I already made a ruling on the floor, so we have to rethink this. Because she had already said, yeah.
But what's going to happen is, since Weinstein made that, Doug Weinstein made that objection to that, the trial can be delayed even further. So it would have been best for him to withdraw his objection and let somebody else question Woody. At this point, not because you want to do Hilton a favor, but because you don't want to delay the trial any further and have your client sitting in jail a day longer than they have to.
That makes sense.
It's coming tomorrow. Yeah, somebody said, yeah. Somebody said.
Did she start at 8:45?
On the dot.
Did she?
On the dot. She made it a point to do it because, she hyped it up that she was going to start on time. So.
Because I just remember when she left, she said, okay, I see everybody at 8:45. I was like, did she start at 8:45?
She sure did. And here in Texas, it's an hour ahead, 7:45. So, yeah.
So you had to get up at around 6 to prep to get
early.
into the camp.
Oh, yeah. And I thought it was going to start at 7:30, so I actually had a little bit more time to get on. But I know by the time I was getting ready to start up and turn the camera on and get everything situated, she was sitting down. So, yeah, we've been going for I think I'm gonna stand for like 10 more minutes. Almost 11 hours. That's about right, yeah. That's when we that's when we started. But I don't think. Do you think Woody going around giving interviews, Miss Lavonda, you think that's a bad thing, or it's okay? I mean, now he got cars, he got a pocket full of money.
I'm I'm not torn, but I'm just want you to answer the question I asked just like love. Now this man, regardless, he went in there and snitched on a whole crew of people, right, wrong, or indifferent. They are sitting in jail, the same jails that we say are unfit, but yet he is celebrated. Forget snitching. The fact that he went in there and let's say lied and then lied on the innocent people, because remember, that's the plight. They're innocent. They're being held in the Rice Street jail, and he is getting thousands of dollars to go on the Danza report to for his daughter, for his birthday party, to spin around in the street, and we're watching it. So at the same time, we rooting for Thug, but we say we could forget about what Woody did to put Thug here. So I don't like Woody. I don't like for what he's standing for. So I think it's wrong that people are putting
I got
him
a
out
question.
front and he's
Yeah.
not even saying anything. He's not saying anything. So
I
that's the culture.
I'm sorry, Miss Lavonda. I have a question when you're done. This for you and Talk That Law. This is the problem I have, right? So, how do y'all feel about people who insert themselves into trials to make themselves like get some type of notoriety regarding it, as well as with this particular witness? Like, I mean, I think that he's doing this, of course, to get money and some type of like notoriety within the situation, because now he is becoming famous and he is a public figure. But like, I think we're exacerbating like his existence in the world, because like before he even got on singing, he was quiet, mouth quiet. Nobody heard from him. His social medias were wiped. He never really posted anything, saying anything of any substance. So it's like now we're celebrating that he's saying everything that he said was a lie, when initially this is the start of this case. So how do y'all feel?
The same sentiments. Like, how can we free Thug and celebrate Woody? It goes. I mean, it doesn't make any sense. That's the Levita in me. Make that make sense.
Wait a
And
minute,
then
your name Levita or Lavonda?
my name is. Didn't I just tell him? See, he don't be listening. Levita is that make it make sense of Lavonda. And but for real, that doesn't make any sense. Now I'm not saying that a person does not have a right to change. I've changed. I had 2 kids out of wedlock. Y'all know my story, the little story, but still turn yourself, I mean, do the right thing and go and do your time then. And tell them and stand on it that I did this or I lied. He's playing games on the stand. He's slithering his way around it, because after this is after he gets off the stand, we do understand that he's a free man, right? It ain't like he's just gonna go up there and get on the stand and he's gonna be held with his friends. He's going to go out to do some more racing and having birthday parties for his kids. So yeah, it's just messed up all around to me, but that's a cultural thing. That's a culture thing. We mixed up what being loyal to each other is. Then we're doing it for the money. So the gang was poorly ran, in my opinion.
So you blaming so I don't even know how to take that. So Young Thug is responsible for the gang, but at the same time, he wasn't running it good enough. He ran it.
What all I'm saying to you is I was born in 68. And all I know about hustling and in the streets, if I'm the one getting the money, you not gonna have my name in nothing. Absolutely nothing, especially where I already got the billions. You may be able to tell what you know before the billions, but I'm gonna pay you off and get you out of there. All I'm saying is it was too messy. Let's say he ain't had nothing to do with it being poorly ran. It was too messy. When you got all them people that grew up together, did what they did together, and now they're all telling. We just, like I said, we only focusing on Woody. Everybody in that YSL organization snitched. They have paperwork on it.
And we don't know, like I said, Gunna and Young Thug's dad was seen at Gunna's concert. So to me, that makes it seem as if Young Thug is not upset with Gunna or his dad wouldn't be there.
Again, there we go again. We picking and choosing. Let's take Thug out of it. Let's say this. If you are up for a RICO charge and they are saying that YSL is a criminal gang, that means 3 or more committing crimes. I don't want no one to go up there and say YSL is a gang. I would rather for them to go to jail. Go to jail, brother. Don't get up there and say what they want you to say. That alone is going to hurt him. In my opinion, I could be wrong.
I mean, yeah, because we don't know what we don't know. We don't know what they talked about.
We know what the paperwork. Okay. Well, then YSL is not a gang, is a gang, and he'd be all right then.
You're right. They probably said, "Hey, you can go and say YSL a gang. It's not going to hurt our case because they got to prove more than we were just a gang. They got to actually prove that we committed crime."
You a lawyer. Talk that law, but I'm telling you, ain't been out there. Ain't nobody gonna want their name in that. And I'm telling you, Thug didn't give nobody permission to say that. When it first come out, go to that recording when he told Dirk, "If you want to diss little buddy, don't do it. Wait. Let's drop it on the album. We gonna drop it on my album." I mean, the way you saying it, Thug father could have been there watching Gunna.
No, that ain't look like they was
taking pictures together.
Yeah, he was jamming.
I understand what you're saying, but does that take away from him saying that YSL is a street game? And I hate that I use my music in furtherance of that game. That's what he said. I wouldn't have never said it.
Right, but he's not required to come to court to testify. So how's that hurting, Young Thug at trial? Man, he could tell the judge what he wanted to tell the judge as long as the jury don't hear it. So that's what I'm saying. I think that Young Thug probably was okay with that. And I can't obviously speak for Young Thug, but if the jury won't hear about it, how is that hurting me if I'm Young Thug?
Okay, do you know for a fact, or can you pull, being a lawyer or being someone, can you pull Gunner's paperwork and does it say that he does not have to testify? I know his lawyer said it, but before his lawyer said that and Gunner said that, the secret tape came out. And that's when his lawyer say, well, he might have said this, but he's not going to testify. Have you seen the paperwork that say he doesn't have to testify?
No.
Oh,
I haven't read
the.
Yeah, I haven't read the actual plea agreement. I don't even know if it's been released. We'll try to find it, but I mean, it's clear as day. If it's already understood, he's not going to testify. I don't even know if he's on the witness list.
He's not.
Oh, okay, I don't think he's on the witness list. Yeah, so that's another sign that he won't be testifying, and I can see that that happening in real life. You say this, do what you got to do, get your plea deal, as long as it's not going to be used against me in my trial. You go out, you tour, you make some money, you send some of that money back to me, my dad, and we can keep this fight going. And then I'll be out to join you in the next year or two when my trial over. So I can see that happening. I'm not saying that it did happen.
No, but I could see it
I'm
now
just
that you broke it
speculating,
down that way.
I'm just speculating, but I mean, it's possible.
That was
So
a good speculation.
yeah, but I don't think I don't see no bad blood because I can see my father hanging around a dude that putting, his son away for life. And then especially when the dad's at the trial, like all the time. Because I mean, if I was gonna, I'd be like, what you doing? If I had beef with him, I would tell him, what you doing, hanging with the ops? He's trying to put your son away for life. But I don't think that's the case. It's too friendly with the family.
Who was that walked out the courtroom when she said, no, this is unacceptable? I thought she was talking to Love, but she said, I'll deal with her when she come back in. Who was it?
No, I
Did
think
y'all
somebody,
ever see it?
Yeah, I think somebody's phone rung and interrupted the court. And she basically said
I think it was somebody in the who was
gallery.
watching.
Okay.
Yeah.
Yeah, I think they phone rung and they walked off to answer it or put it on silent. She said we'll deal with them when they come back. But she didn't deal with them, at least not on camera, so they probably got word not to come back. Go home for the day. Keep on walking.
Because I couldn't imagine going back in there after she already made her first announcement.
I don't know who be sitting in the courtroom. I think somebody, I'm sure one of the YouTubers gonna know who phone it was. They gonna know who it was. But yeah, I mean it happens sometimes. I done had judges' phones go off, and I done seen bailiffs' phones go off, and the judge might look, and everybody keep going. So yeah, it happens from time to time. But I think this is going to be a good trial. At least we are back. We haven't been back in what? When was our last day in court? June something?
Before Juneteenth.
Before Juneteenth.
Mm-hmm.
And
so before, it was like the 19th, like before the 19th.
And we're going to be in August on Thursday.
Because I know the last day that they have to take away from.
This is crazy.
From Woody's is what, from the 12th to the 17th? They have to take away or redo their whole testimony?
From the 12th, I think.
Oh, okay.
Yeah, from the 12th, but that's going to be crazy because how you going to tell the jury, ignore what you heard, disregard all of his testimony? I think they should just let him pick up where he left off.
Because all they're going to do is re-ask the same questions anyway.
Yeah, they re-ask him all. And then they get a state of chance to get, to get a
no,
state
I
of
was going to ask you, but they can't, that gets thrown out, right? They can't come back and say, oh, you said this time. It just be the same questions.
Right.
Okay.
But it's going to be hard because the jury can only consider what they hear now, what's in evidence. But, it'll be hard. When it's time for jury deliberations, I'm sure they'll be bringing up some of the stuff that was supposedly throughout. They may say, well, Woody said this. No, you can't consider that. That's throughout. You got to consider his new testimony. I mean, it's too confusing. Oh, yeah, go ahead, India.
So, since they're throwing out part of that testimony, when it comes to the notes, like I know they leave their notebooks at the courthouse. So is the courthouse just going to take it upon themselves to take the notes pertaining to that? Or like, how does that work?
Let somebody tell you them people don't be taking notes, but go ahead, Tadala, I'm sorry.
Oh, see that. So you ain't got to worry about notes. There ain't no notes. They already got their verdict in their head.
Oh, India, that was a good thing too, because they can go and just get them now, right? But then the jury will want to know what happened to our notes.
Yeah, because they leave their notebooks at the courthouse. So, like, do they take it upon themselves, like the court personnel, to like remove those notes, or like how do they go about that?
Yeah, that's gonna be weird because we don't even know. I mean, you can't just go into somebody else's notes and try to scratch out what you think should be scratched out. You may be scratching out the wrong thing.
Mm-hmm.
And they may not even be taking their notes in order. They may go back and put a note next to a note of another witness to compare the two. So you won't even know what to scratch out. It's not like they're going to have, okay, it listed, this is the testimony of Tick, this is the testimony of Woody. They may have notes scribbled everywhere. So I can't see a bailiff.
I need to do some research to see if like that ever happened. Cause like how do you like Harvey said, how do you just continue? Like how could you just act like it never happened?
I mean, you can tell maybe tell the jurors to scratch out their own notes, but I mean, while they're scratching it out, they're gonna be reading it. So it's gonna be, yeah, this is insane. I'm with Harvey. You really can't do this. It's a mess, and I think the judge even said as much at the end. The judge was like, "We might as well let somebody else question the witness for Hilton. I mean, we already got a new judge and a new everything else." Let me see.
I do think she's under I do think she's under pressure, like to keep the case going. Because I think if it was really like, I don't know, I think she think it should be thrown out, but I think she's under pressure to kind of like keep it going. Because I just don't understand it. Like I really do agree with Harvey. Like I just don't understand how you could just tell them. And this is just based on just the jury, not even everything else, but just the jury. Like, how can you be, okay, you've been gone for a month. Oh, nothing happened. Like, there was a flood in the building. And just, oh, and by the way, that guy who was on the stand last time you guys were here, any notes that you have, you need to scratch those out. Like, we'll be starting his testimony. Like, I don't, like, how do they do that? That's why I was asking, like, what do you think she's going to say? Because she was saying, as if they were going to, like, basically asking a lawyer if they could propose what they want to be said. Because it's like, what do you say?
Right. I mean, it's unheard of.
Is it though? Like this, I mean, I know this specific thing has never happened, but like.
Right. And it's unprecedented, so.
Can I ask you a question real quick before you go?
Yes.
Would you ever interview Woody?
Yeah, I wouldn't have no problem talking to him, but it'll be better once everything is over with. I mean, because right now he's making his rounds, talking to people, but he's not actually talking about the case itself because he's still a sworn witness. But I think you can get more of a constructive interview when you can ask him questions that he can answer about. I don't even know if I even question him about the case like that, because you don't want them to try to come back and circle the block and charge him after the case is over with.
He's done enough talking on his own. Like if anybody think that Steele and them are not don't have screen recordings of his live streams and stuff like that and are combing through that stuff, they're mistaken, because they're definitely going to bring that up. He's been live a lot.
Oh yeah, see, so if the feds swoop in or anything like that, maybe about the gun, because I think he was concerned with the gun case. He had a gun when he was defending his family. When his family daughter was shot at, I think he said he admitted to shooting back, so he was concerned about getting a gun case with the feds. But somebody said that Kayla is live, and she states it was Deputy L. Brown. It was an officer who exposed the ex parte meeting and instructed the other officers to turn off the body cameras. Wow, Miss LaVonda, you hear that?
So why is she saying it now?
Wait a minute, what you say? I hear you.
They were trying to accuse Kayla of being the mole of leaking it, but it was actually a cop, they said, that told about the secret meeting, and he the one that told the other officers to turn off their body cameras.
And then she went over there and told them some too. She didn't tell them the initial, but she went over there. And again, if you're defending Woody, never mind that you are Young Thug's nephew godmother, you wouldn't have went over there and told them anything. That's none of their business.
All right, y'all.
Wait
I
a
gotta
minute.
go. I got a 7-page paper to write, so I'll talk to y'all later.
Oh, thanks so much. All right, Tasha. We'll catch you on the next one. So the deputy told her she wasn't allowed in court today. That same deputy. So maybe she mad. Maybe she mad at the cop that let her in, so she finally told on. Like, hey,
They
I
don't
ain't
want you
protecting
in
you no
here.
more.
You can
Messy,
support.
messy, messy.
How can he keep her from a public trial? Though? That's a public courtroom.
Because she a mole.
Well, apparently he the mole.
So you believe her?
Well, I don't know because I ain't talked to her. I'm just going
But
by
she
what.
admitted that she went over there and told them. Okay, let's say Brown did go over there and give them that nudge. As a defense attorney for somebody else, why would you go over there and tell them?
She didn't know the
It don't-
meeting was a secret. The meeting wasn't like a secret meeting, and he's not a defendant. Like, she was representing him as a witness.
Okay, that's
Somebody
good.
say
I stick with it.
she's tired of being bullied.
Do your thing, Kaylee.
I don't understand how is it not open to a public. It's a public trial. Anyone should be able to go in and sit in and observe the trial. I mean, that's the constitutional right to a public trial. I don't think it's locked down to the public.
It's not. Like, you could just walk in. Well, I don't know where. I thought it was like that everywhere. You could just walk into a courthouse and sit in the courtroom.
And sit in, right. They can't lock the doors.
You getting ready to go over to her live to support her and you'll find out.
Well, here you go, Miss Lamont.
What? No, I was saying you can go over there and get first-hand access. That's all I said.
Right. I mean, I wouldn't mind finding out. I'm gonna find out on the back end, though, not not on the front end. Because I've been sitting up here already for 11 hours. I'll find out behind the scenes, so we can reconvene possibly tomorrow. Okay, Robert said I live here. So, Robert, have you tried to go to the courthouse and was denied access? Because I've never heard that the courtroom.
I know it was full, so they have that extra like overflow room, but still.
If it's full, then that's a different. Yeah.
And you know, a lot of people was there today because this is the first day back, and you know everybody's interested now.
Right. So maybe it was over capacity, but I mean he should have said that if that was the case.
Not going in the door. Was he the man in black who is intimidating Woody? Y'all remember that?
Who knows? Right. Who knows? Could be. But hopefully we can find out and get some first-hand knowledge of. I mean, that's what people been wanting to know since day one. Who was the quote-unquote mole? Some people say who was the whistleblower.
Why she just telling us now?
That's what I said.
Ironically, when he wouldn't let her in the courtroom, that made you mad enough to tell. So, in the interest of justice, you wouldn't tell, and that's somebody on the state side. Girl, I hope she. You know what? I hope
we don't know. Well, we don't know if it's sure it hasn't been confirmed.
Right, that's your girl. I don't have.
So
what is it saying? What is the word? What is the word, young? What's the word, young lady, that the judge say when they say, "Oh, I'm not taking her proffer. I'm not accepting it."
Jiggy say what Kayla did. Kayla supposedly said, "Here we go, Jiggy. Can you see that?"
Look, Jiggy said, "Never mind. I don't even care." But look.
Oh, that's what he said.
Kayla better not do nothing and mess around and do anything unethical. Like if that state, she said, who's Whitaker?
Who's Whitaker? Oh, that's the judge.
She said
the judge.
Right, but how could he be the one that gave her the information? He wasn't even working there. she said it's the judge's, is Whitaker's deputy. Or is it just getting mixed up in the comments? Who that man is?
Let me see.
Kayla states Deputy L. Brown is Judge Whitaker's deputy. So is that the same man who told about the ex parte meeting? The one that kicked her out, or they just not letting her in the courtroom? I was just confused how that went together.
I mean, it's all, maybe we'll be able to find it and get it firsthand. But yeah. But somebody say he was in Glanville Court. Well, you know, they move bailiffs, they move courtroom to courtroom, especially in the morning time. If nothing's going on in Whitaker's court, then it wouldn't be unusual for them to all be gathered in one court. And I believe they did say it was a lot of deputies and investigators from the DA's office. It just wasn't one deputy from Glanville's court. But this is some good info, though. I mean, maybe we'll know more about it tomorrow. But thank you again, Miss Lavonda.
Okay,
I'm gonna tell my editors to leave some of it up. Just go in and find that slip up and take that out.
Okay, young man.
Okay.
Enjoy the rest of your evening.
Oh, thank you. Hopefully we'll talk soon.
Okay.
Okay, have a good one. All right.
Bye-bye.
All right, y'all. So here we have it. The deputies told her all that stuff when she took over. Say, do your research. She is live now. Okay. Well, all right. All right, y'all. Thank y'all for joining. And hopefully we can jump back on tomorrow. I have a court, but I think I should be able to take care of that maybe virtually or maybe during the lunch break. Because I still want to get on and cover some of this so we can see what's really going on. And before we go, if y'all don't mind hitting the like button, and for those who want to come back, subscribe. But you got to turn on the notification bell because when I go live, you're not going to know it. So what would be the purpose of even subscribing? If you're not going to know when I'm live and you're trying to catch the trial. But all right, y'all. And thank you again to all those who were supporting, who came up and spoke, to the ones who donated. Danielle on Cash App, Alicia, Slick So Famous, donated 3 times. Thank you for that. And 305 OG that got the party started by mentioning it when he came up. So that was really kind of all y'all. And the one that just hit the like button. Yeah, hitting the like button. Thank you for that. And that's free. Some of y'all said, I ain't gonna even do that. And I know sometimes we all have different opinions, but I try to make sure everybody have a voice over here. I'm gonna talk that loud. All right, before I go, let me give my disclaimer. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk their law. All right, y'all. I'll see y'all hopefully tomorrow. All right, y'all have a good one. Y'all, thank you, Politicking with Me. Have a good night. All right, let's go.